special song for you. It was so cute.
I didn't record it.
We can try it out.
Well, you know when you're out. Well, what game? Well, it's supposed to be a picture of it.
Oh, there's. Okay. Yeah, the white's long. I am organized and ready, and apologies, I was here an hour ago, but somehow when you arrive early, you spend too much time doing other things. So, welcome to our second day of the State Board of Equalization. Thank you so much for your attendance, and we do have today a couple of honors to present. The first one is going to be our Orange County Assessor. I guess we need to call to order. Okay, I've called it to order. We don't need to take roll again. We're all here, correct?
Yes.
Okay, good. All right, we're called to order. We just recessed. This is a continuation of, and we're all here. So, I get instructions from former chairs. Anyway, I'd just like to take a moment. Sometimes when good things happen, and especially because we were in Orange County anyway, and now that our total focus at the Board of Equalization, at least after December, will be assessments, property tax, and a few other items, but primarily assessments, assessors, and property tax. I just wanted to, I asked because we were coming to Orange County, I said, okay, well, how's our assessor doing? And it just so happens there was a review of our assessor, Mr. Claude Parrish, who used to be a member of the Board of Equalization, who's sitting over in the corner there. I'll be calling you up in a minute. But he recently completed the State Assessment Practices Survey. Under this program, the BOE, the Board of Equalization, our property division, reviews the practices and procedures of county assessors' offices. Counties are responsible for local property tax assessment, and the state has an interest in promoting fair and equitable assessments. A recent survey result showed that the productive working relationship with the Board of Equalization and the Orange County Assessor's Office. The results show the high degree of professionalism and knowledge within the Orange County Assessor's Office. My office has relied on Mr. Parrish and his team for solving constituent issues, and they have been a tremendous asset to us. Assessors play an important role in three very distinct ways. In efficiency, being able to contact and visit your local assessor's office creates efficiencies for taxpayers by allowing local issues to be solved at the lowest level possible, which is what we try to do here at the BOE, to resolve your issues at a very low level. So if you call us with issues, we will try to contact the appropriate person at the state to assist you. Government works best if local problems can be solved at the ground level. And access. Having a local elected assessor means that all taxpayers have the same convenient access to their assessor, and the assessor in turn is directly accountable to his constituents that elect him. And a point of contact. Having an elected county assessor means taxpayers know who to call and can solve issues with an actual person, live in person on the phone or whatever. And he has been a dedicated taxpayer rights advocate with the assessor's office, and it's critically important to help anyone with assessment problems to navigate the complexities. Many people aren't tax experts, as we see here every day at the Board of Equalization, and having an advocate is very, very important. So when the board had issues with Mr. Parrish's audits and things, he corrected them. They went back and verified everything was corrected, everything was done. That is not the case in a lot of counties, I want to let you know. So I just thought it was important to award him. We are missing Ms. Yee's signature, but I'd like to come down here and present this to you on behalf of the board. So let's give him a hand.
Andy, do you want to come? Yeah.
Yeah, of course.
This is now our purview. He's going to give us his cards. A public defender for the taxpayer, so it's at no cost. Here you go. We like to think that's what we do too. Okay, thank you very much. Thank you very much. Keep up the good work. And next, just one more presentation that I thought was really important. You know, we hear all the time about people doing good, heroic things. Recently, there was a airplane crash on the 405 freeway. The pilot I happen to have known just by chance, and his wife, they knew they were in trouble the minute they took off. I guess about 500 feet up. They knew they were they had a problem. They called Mayday, and told them they were coming back to the airport. When they arrived, they knew they would not. The pilot knew that they would not be able to get over the fence to get into the airport because they were losing ground. So he chose, as good pilots do, an alternate path to land. Found that the freeway was that path. It was there was no traffic, luckily. I mean, hard to believe, but very untrafficked. He put the plane down, but there was a little bit of tipping, I guess, because of the way these planes are made. And his pilot's wing hit the berm between separating the freeway, caught fire. And that's where the gas is and the wings. So anyway, to make a long story short, his wife got out. She came back, noticed that he was still in the plane, thought he had followed her. He was trapped. She went in, released him, tried to get him out, pull him out. And today I'm honored to welcome Fire Captain John Meffert to our July board hearing. He just happened to be on a vacation, or thought he was. Anyway, so let me tell the story. He works for the City of Avalon Fire Department on Catalina Island. He's been a fire captain for 17 years. He embodies everything we should all try to be: selfless person who thinks quickly on his feet to solve big problems. Last month, Captain Meffert was driving home on the 405 to get ready for a vacation in Palm Springs. He happened to notice a low-flying plane above his vehicle. Shortly after, the plane's wing came across the hood of his car and crashed on the 405. Captain Meffert went directly to the plane, saw the passengers, Janan and Francisco Pisano, and Frank happens to be a CPA in Mission Viejo, known his family for about 30 years, not well, but know them well, Captain Meffert aided Janan and Frank, bringing them away from the plane to safety. He humbly noted that getting the Pisanos to safety was a team effort. One great example of the four drivers on the 405 who used their own fire extinguishers to help put out the burning plane. Amazingly, Janan and Frank are making their recoveries. There were no casualties. They both had broken backs numerous places. Janan is out of the hospital and in rehab and working, not working, but walking. Frank is still in rehab. He was very severely injured, but expected to recover. So on behalf of the Board of Equalization, I'd like to present an award for bravery. And we also have with us, this is a continuing story, we also have with us Nurse Karen Harold from Hoag Hospital, who happened to be there as well. I understand there was a doctor that was also just happened to be close by. The the fire trucks from the airport were racing to meet them because they had the Mayday warning, and they couldn't get obviously onto the freeway, but they came as close as they could and put out the fire on the freeway with the hoses, relatively quickly, and there were no other injuries. So this is truly kind of a miraculous thing. So I'd like to make this presentation for Nurse Karen Harold from Hoag Hospital, and for Captain Meffert. And with us to honor them is the City of Irvine Mayor Pro Tem Melissa Fox. So if you come down and...
It is my pleasure also to present both of you just with hope, a city pin and a city pen, so that you can always remember this and just a small token of our gratitude for your everyday heroism. Thank you. This gentleman.
Captain, why don't you stand in the middle with Nurse Harold? Why don't you move over one? No, we'll put the captain and the nurse in the middle. Diane, why don't you switch with the captain? Yeah. That way it's equal on both sides. Yeah. Okay. 3, 2, 1, 3, 2.
Well, thank you. Obviously, they did not attend but if you're done, oh, you're my shake my That was just a few weeks ago.
I think I saw it.
You may.
We also wanted to take just a minute, because we don't give enough names for our Board of Equalization members. I really wanted to present each of you with a city pen
Thank
and
you.
with a USB drive. So that
Oh, that's so kind of you. Thank you very much.
Save everything.
Very kind of you, very kind.
Thank you so very much. It was a pleasure. Wonderful.
And to be your host.
Thank you. We love this facility.
I think we'd be glad to do.
Yeah. Well, maybe we can get a Wednesday date? Just teasing. Thanks. Thanks so much. It's been great. And the staff is fabulous. Thank you. Okay. Now on with the more mundane board business. Yes.
Thank you, Madam Chair. I just wanted to take an opportunity, and members, thank you for your indulgence, to recognize all of the individuals. I believe you exemplify an old saying that God's grace is sufficient. In this particular case, it's being reflected in the individuals that we have been able to meet today, and I want to thank you so very much for that. To Mr. Parrish for his outstanding work over the years. I've known him personally. He is a compassionate, caring individual, extremely talented, and certainly there to do everything that he can to help California taxpayers. He reminds me of another saying that an ounce of performance is worth a pound of promises. Thank you very much, Mr. Parrish.
Thank you. Okay. Ms. Richmond, will you please introduce the first item? That's the second item now. Please introduce the second item, I guess it is.
Good morning, members. Our second item on this morning's agenda is item C, Sales and Use Tax Appeals Hearings. Item C1, Marcelino V. Lopez, please come forward. Board Proceedings has received contribution disclosure forms for today's hearings from the parties, participants, and agents. All forms were properly completed and signed, and no disqualifying contributions were disclosed. All parties, participants, and agents are on the alpha listings provided to your office. Each person sitting at the table will be asked to introduce themselves and, if necessary, their affiliation with the taxpayer for the record. 10 minutes is allocated for the taxpayer's opening presentation, followed by 10 minutes for the department's presentation, and 5 minutes is allocated to the taxpayer for rebuttal. Chairwoman Harkey.
Thank you very much. Mr. Angija? No? Okay, I'm just going to say appeals, because I was getting the names twisted all day yesterday. It was, if I said one, it was the other. So will you please introduce yourself and then announce the items?
Excuse me, Ms. Harkey, I think. Ms.
Oh,
Marks.
I'm sorry. We have another procedure. Life changed for us as of July 1, so I'm sorry. Counsel, will you please read?
Thank you. Because of the change in the law, I want to ask the board members if they had any written or oral communications from the parties that have not been produced to the other side, or you suspect have not been produced to the other side that you'd want to disclose. And I understand that before that you wanted to perhaps hear my opinion on that, the application of that law again.
We will do that in the afternoon, so we don't have to get into a big discussion now about it, right before we vote.
Okay, great.
Okay, thank you. Okay, I'll go first. In the matter before us, to the best of my recollection, we hereby disclose that we have had or may have had communications with the appellant and with the tax department in the above referenced matter. My office discussed the issues prescribed in the briefing record with both taxpayer and the department. We do not believe the law imposes a disclosure requirement prior to the July 1, 2017 operative date of the provisions of AB 102. However, we satisfy our ex parte disclosure burden to the extent one exists. Runner?
Want to go this way?
Oh.
I have not had any communication with either party.
I have not had any communication with either party, neither has my staff, in reference to the matter before us.
I have not had I have not had communication, oral or written, with this taxpayer nor the department since July 1st, when I believe this law took effect. I believe any conversations that may or may not have taken place prior to July 1 are not applicable to the law.
To the best of my knowledge, myself or the members of my office have not had any communications with the taxpayer or staff.
Then I would ask the representatives for the department, in order to assist the board members in carrying out their responsibility, if you recall any oral or written communications that you have submitted to them that was not submitted to the other side, that were in addition to or other than what has been disclosed here. Not sure. Is your mic on?
Okay. We don't believe that we've had any communications.
Thank you. And then I would ask the petitioners here whether or not you think you've had any communications, oral or written, that you have submitted to the board members that were not submitted to the other side.
Yes, if this is on. If I don't mind, I need to translate to Mr. Villa.
Thank
I want
you.
to ask him and he can reply to you. Quieren saber si usted ha tenido alguna comunicación con la...
Madam Chair, we may want to have that translation on the record.
You may have to speak into the microphone with the translations. Just pull it closer to you.
I don't know if this is...
Yeah.
Okay, that's clear.
Yes, now, be sure we can hear you.
Quieren saber si usted ha tenido alguna comunicación con cualquiera de uno de los miembros del State Board.
No.
No, he has not.
Yes, none.
He has not
Okay,
had
thank
any
you.
communication with any of the staff members.
So I don't believe any were disclosed, is that correct?
That's correct.
Okay, so we don't need to ask about an opportunity to comment. Thank you.
Madam Chair?
Yes.
I'm a little confused right now in regards to translation. I thought we had a translation protocol, and this seems to not be within it.
Yes,
We
I
do,
believe we
and
requested
I was
Well-
not aware that they needed an interpreter.
That would be board proceedings. So what's the story?
I was not aware that they needed an interpreter.
Okay, why don't we put the two microphones, pull both microphones, one for one.
You got one
Yeah,
for me.
and then one for the other. They're both live. Just pull them close enough so that when you speak, we have it on record, and when he responds, it's also on record. No, he keeps that in his, yeah. Everybody just speak into their own microphone. If you could communicate that with him, tell him to
Yes.
speak into his own microphone.
Madam Chair.
Cualquier,
Madam Chair, just for the record, we may want to consider offering and having it,
Let's just go,
taxpayer
let's
indicate
go
that he
through
didn't want
this.
it.
I want to go through this. I
Well,
don't- I-
you may want to, but I'm not sure this is our protocol.
Okay, so I guess that's what we need legal counsel for, which we don't have. So what do you guys want to do?
I think we should provide them with the opportunity to see if he would like an interpreter.
Well,
And
then
if
let
that's the
somebody
case-
ask the question. Where's our legal person to ask the question?
Well,
Okay,
she's not aware
I
of our
guess,
protocol.
here's the problem. We do not have a counsel at this. We have somebody that's advising on the meetings, but not as a counsel. So what we need to ask your petition, the appellant, is if he would like to have a professional interpreter present at the meeting.
correct. El problema
Speak
que-
into the microphone, please.
Yes, el problema que hay en ese momento es de que no hay una representación legal de parte del departamento del State Board y ellos están sugiriendo de que si usted quiere un intérprete legal que lo pueda representar en ese momento para que le traduzca. Si quieren saber si usted quiere un intérprete en ese momento, es porque no hay alguien disponible.
Sí, yo quiero intérprete.
Yes, she
Okay,
would like to
would
have
you
an
tell us
interpreter.
what you said to him for the microphone?
Yes. I told him that there is no consult available as today, and also I asked him if he wants to have a professional interpreter in order to proceed with this court hearing. And he said yes.
He said he wants a
He
professional?
wants to have an interpreter himself, yes.
Okay, then we postpone the hearing, or what do we do now?
Reschedule till the next.
We can reschedule for the next hearing date. Okay, that will probably be in, is it in
November.
Culver City? In September in Culver City.
Si quiere una intérprete, la próxima fecha de corte va a ser en septiembre en la ciudad de Culver City.
Está bien.
He's okay with it.
Okay, thank you.
We'll receive notice from the board, or this will wait notice?
Yes, we'll receive, we'll reschedule the hearing for Culver City in September. Is
Appreciate
that of record? Is somebody keeping track of that?
September or November?
Appeals apparently wants to say something.
You may, he may.
I thought they said November, you just said September. I just want to make sure we get the right date.
I think it's September is our next board hearing. We'll just reschedule it for the next one. Is that in Culver City? Does anybody know?
That's Culver City.
Yes, it is.
It is in Culver City. We will notify you. Do you happen to have, Joanne, the dates?
September 26th through the 28th.
September 26th through the 28th, you will be noticed, and we'll be contacting you.
Okay, I appreciate it. Thank you so
Contact
much.
your appellant. Okay.
That's fine.
Not now. No, we're moving along. Okay? Thank you very much.
Yes.
Okay. Ms. Richmond, please introduce the next item.
Our next case that has signed in for this morning is item C7, Shawn Victor Bachor. Please come forward.
Thank you.
Okay, Chief Counsel?
Thank you. Because of the change in the law, I wanted to ask the board members if, with respect to the matter before them, if they've had any oral or written communications that have been submitted by other side that they know or suspect have not been provided to the other side that they would like to disclose now.
Okay, in this matter before us, item C7, to the best of my recollection, we hereby disclose that we have had or may have had communications with the appellant and with the tax department in the above referenced matter. My office would have discussed or did discuss the issues presented in the briefing record with both the taxpayer and the department. We do not believe that the law imposes disclosure requirement prior to the July 1, 2017 operative date of the provisions of AB 102. However, we hereby satisfy our ex parte disclosure burden to the extent one exists.
I have not had any communication with the petitioner or with the department.
To the best of my knowledge, neither I nor my staff had communication with the petitioner or the department on this matter before us.
I have not had communications, oral or written, with this taxpayer and other department since July 1st, when I believe this law took effect. I believe any conversations that may or may not have taken place prior to July 1st are not applicable to the law.
My office did have contact with the representative prior to July 1st, 2017. Spoke with Emily Vina in my office. Client was required by Mexican law to operate a company in Mexico. Carmel Mountain Cabinetry are the same company.
I would like to ask the representatives for the department in order to assist the board members in discharging their obligation, whether or not you have submitted any oral or written communications to the board members that were not provided to the other side.
To the best of our knowledge, we have not submitted or provided any written or oral communication.
And I would like to ask the claimants the same question, whether or not you have submitted any oral or written communications to the board members that were not provided to the department.
Not prior to July 1st.
I have not prior to July 1st.
I have not prior to July 1st.
Thank you.
Or after. Right? You didn't submit anything after July 1 either, did you?
Let them make
No,
their
we did
statement.
not submit anything after July 1st either.
Well, I think it's important to get on record. I think they're following the July 1, which is when the law changed for us. But if you've submitted anything at all for the record that was not submitted to both the department and to us, that's what we need to know.
Great, I have not submitted anything.
Okay, so we're all, okay, thank you.
Mm-hmm.
Thank you.
Okay, to appeals, please introduce the items.
Good morning, Madam Chair and members. I'm Jeff Angija on behalf of the Appeals Bureau. The appeal before you involves one unresolved issue, which is whether the unreported fabrication labor costs are taxable.
Thank you. To the appellants, you have 10 minutes to present your case. Then we will go to the department, who will also have 10 minutes. And then you will have 5 more minutes on rebuttal. So please announce who you are for the record and begin. Thank you.
Okay, I'm Harold C. Newman, and I'm...
Pull your mic closer. We can't hear you.
Is that better?
Yes.
Okay. I'm Harold C. Newman, and I'm their representative. This here is my client, Shawn Bachor, and his father, Pedro Bachor.
Begin.
Okay.
It's your time.
Thank you for allowing us to present to the appeals board on our case. My client started his business in the United States as a sole proprietorship. He makes cabinets and installs them into high-end homes and other establishments. He is a true subcontractor, and both sides have agreed to that. He tried to get a facility in the state of California for staining and cutting the wood for his custom cabinets and was hitting a ton of roadblocks. One of them was the high EPA standards in our state, which he found he could not come up with the hundreds of thousands of dollars just to produce the filters and so forth that he needed to do for the staining. So he went to Mexico to set up a maquiladora, and that was to stain his wood so he could compete against his larger competition. The case has been going on for many years, this case here, Due to first, the initial auditor retired, then the first meeting, the attorney could not make a decision, then we had 3 other state board attorneys, for some reason or another, had to leave the case, and so we are kind of here now. My client stands before you with a huge liability that has over $570K, including the interest. Bear in mind, my client never collected from his clients because it was thought that he is a subcontractor and was doing everything in his power to do it correctly. This amount of sales tax will cause his business in the U.S. and Mexico to close if it is not resolved. Now we are before you to determine our fate. Our case is mainly one issue. Is my client one or two distinct businesses? If both of my client's companies were structured and actually in the United States, we wouldn't be here today. But this is not the case. My client, a sole proprietor in California, is also an owner of a Maquiladora in Mexico. Per the law, as it states, one would clearly state that due to the nature, these are two distinct companies, and the law established is correct. However, in Mexico, a Maquiladora must be a corporation, period. In Mexico, to be a sole proprietorship, you must be a Mexican citizen or have Mexican immigration status, as any U.S. citizen cannot be a sole proprietor in Mexico. I have given you an exhibit on what a Maquiladora is. This exhibit is given to me directly by a Mexican attorney, and as the exhibit states, in order to be a Maquiladora, you must get an IMMEX permit. This permit is not allowed for individuals. This company is solely formed for the purpose of receiving raw materials and creating products to be used for the U.S. company. A Maquiladora cannot sell anything to Mexico or anyone else other than the parent company in the USA. I feel this particular case is a presidential case in this sales tax arena. The way the law is done is only based on what company is set up as in the United States. What it does not take into effect is how a foreign country categorizes how a company is set up in their country. By not considering this factor, a small company like Carmel Mountain Cabinetry is being discriminated against solely because he is not a corporation. If he was a big corporation in the United States, then we would not be at this hearing at all. Again, in this hearing, I am bringing up a 1975 case. I put it in the docs. It was MAPO, Inc. versus State Board of Equalization. MAPO was a U.S. corporation doing business for Walt Disney, another U.S. corporation. In this case, Disney retained all title to materials, ideas, and completed items done by MAPO. Disney was in charge of all day-to-day operations of MAPO Corporation. MAPO Corporation did not do any other work for any other company other than Disney. The conclusion of this case was that MAPO was fabricating items for itself through its employees, in fact, and therefore no sales tax was payable. To me, this case is the same as what my client and his Maquiladora is doing. The only difference is that my client has a Mexican company and a U.S. company, period. In closing, please look at the case based upon what it really is and the facts of the case. The law is ambiguous to any foreign entity classification and should be noted on how the companies are structured and not their classification in this case. In our mind, the result should be clear, whereas dealing with a mutual foreign company is in a classification of itself, and the word corporation doesn't mean the same thing in all countries. Sometimes a business is forced into creating a company based on foreign laws, as in my client's case. If he could be a sole proprietor in Mexico, he would be to this day. Thank you.
Okay, thank you. The department, please introduce yourself to the record. For the record, you have 10 minutes.
Sure. Before we begin, my name is Robert Tucker. I'm with the California Department of Tax and Fee Administration, and I have a statement. We exercise our right and request the board not vote on this matter until we have the opportunity to obtain copies of all documents and obtain any evidence of oral communications, if any. The board should not vote on this matter until we've had the opportunity to review such evidence and respond.
Good morning, Chairwoman Hart.
Let's talk about this.
Okay.
What does that mean?
This simply goes back to the ex parte communication.
Okay, let's go on, have the hearing. We're not going to, we'll just put it on submission. and
No,
then
wait a
we'll
minute, I want to have a
discuss it.
discussion on this item.
Okay.
I mean, that statement implies that there may be evidence that you have not yet seen. Maybe you want to redo the statement somehow? I mean, all parties have testified that they have not had ex parte communication to the extent that they have. The information has not been any information other than what's been presented to the record. The appellant and made such testimony. If that's not sufficient enough for the department, it's certainly not sufficient enough for me either. So, what say you?
Mr. Horton, my understanding is that no representation was made for the period prior to July 1st.
Okay, got it.
And that's simply what that refers to.
So, let me see if I can clarify.
Go on.
So let me see if I can understand. Since we have failed, or since we have not disclosed or unable to disclose communication prior to July 1st, that is your basis for why it is that we should not vote until we disclose what conversations we've had prior to July 1st.
We are simply preserving our rights pending the outcome of the decision to be made as to how the law applies to ex parte communications.
So when you say reserving your rights, help me understand exactly what that means. If we were to vote on this, how would you be reserving your rights if we were to vote on this based upon that statement?
Mr. Renner, maybe you should.
Well, hey, let me have him answer
that statement. I didn't necessarily hear that.
Well, maybe, actually, that would be a good idea. Actually, that's a good idea. Could you repeat the statement so we could fully hear it? I guess we were probably moving on to the next issue in our heads.
My understanding is this morning.
No, I mean, just read the statement.
Just read the statement real quick.
Okay, the statement is, we exercise our right and request the board not vote on this matter until we have the opportunity to obtain copies of all documents and obtain any evidence of oral communications, if any.
See, that's asking us not to vote.
So you're at, the request by the department or division or whoever you guys are today is to not vote on this matter. That's your formal request.
Correct.
Well, we still have the right to hear it. They're just asking us not to vote. But let me ask you, so if we did vote on this, what right are you now feeling like you are reserving?
Well, it's our understanding that we have the right to request and review any written evidence of ex parte communications and evidence of any oral communications.
Your chief counsel has issued an opinion in regards to the law being applied prior to July 1st?
Not to my knowledge.
Well, then on what basis do you make that request?
Based on the discussions that were held yesterday.
Number one, the only one I would think you're responsible to is your chief counsel to interpret the law, not anybody else. So has your chief counsel opined on this issue?
My understanding is that it is still open to discussion whether or not you're required to provide written evidence and evidence of oral communications prior to July 1st.
All right. Under what basis is that?
Under basis of the council yesterday.
No, well, the basis of the council yesterday is being questioned because the statute's in effect as of July 1.
This council has no relationship to your board, to your organization.
And the reason...
Can I finish this, please?
Council's advice was provided to this board. We're acting on the advice of council that was provided yesterday.
You're acting on the advice of whose council?
CD, or Consumer Affairs, DCA.
I work for the Department of Consumer Affairs, yes.
So so your department is working on the advice of the Department of Consumer Affairs.
That was the advice that was provided to your board yesterday.
So if indeed we were to vote on this, what would be your path, your remedy to correct what you would interpret?
We are asking that you not vote.
But if we did, what would be your path, the remedy?
We'll have to see. I can't say.
Would you take us to court? Would you sue us? Would you sue us?
I'm not prepared to make a decision.
This is the seamless divide of the BOE, and I apologize, but this is now new coming up, the first board hearing, And quite honestly, the FTB had a different statement that allowed processes to move forward. The CFTDA, of which I'm not so sure there was even a chief counsel at that time, we had an acting, we were under, we handled items according to the chief counsel at that time. So as of July 1, the world changed. Now, I think that if the CDTFA wants to sue the BOE, that's another topic, and that's fine. That's a state agency suing a state. What I need to, I think we have disclosed any and all. I don't think there's anything prior to that we could even probably.
Madam Chair, we have not, and this is the point.
We-
We have not disclosed. And
I
in
mean,
fact,
we've at least disclosed according to our instructions.
we've disclosed according to our interpretation of the law.
Madam Chair, if I may. Your statement implies that there is an obligation on the part of the members to do more than what we've currently done, and that there is a potential possibility of challenging these proceedings if, in fact, one, the department loses, because you certainly wouldn't challenge if you won.
Yes.
Two, the department feels that the evidence which may have been disclosed requires a new hearing or requires that members recuse themselves, and if in fact it may even bring a challenge to the appellate themselves, and which makes this proceeding non-bearing on any of the parties, from my perspective, which makes it null and void before we even get started. So there's an inherent, you presented a different interpretation than what we've been operating under, and given the fact that the new department is really represented by the office of the governor, we can only presume that that's part of that's gone through some kind of process. You're not making it up yourself. And so without being privy to what that process is, what that analysis is, what that conclusion is, the board is only faced with having to interpret what you're saying. You're asking us not to vote on this matter, given that until all the evidence has been, any discussions or communications or any evidence has been fully disclosed, not a general disclosure, because the general disclosure has been provided, but in the event that you somehow disagree with these proceedings, or you go through some exploratory process to find out what that information is, I don't know how you get there, but I respect your decision. I respect the agency, but based on that decision, I'm not inclined to participate in this process, to be honest with you, because if your presumption is, based on your statement, has any merit, the mere participation exposes us to further inquiry or having to kind of drill down. I mean, I'm fortunate that I didn't have any communications or any information.
You think you didn't.
But I don't know if I didn't have any with the department. So your statement provides the appellant an opportunity to challenge it as well. So if the appellant loses, let's hypothetically say that I've had some communications. Well, one of the cures is for the appellant to have me recused from this process. That's one of the cures. Another cure is to have this case, all the information disclosed, and have the case reheard again. All of which, quite frankly, given the honesty of this process in the past, I really don't, in the nature of public opinion in that regard, I'm not about to proceed without legal opinion. So why don't you give me a copy of this? I'll submit it to my attorneys, have them take a look at it. That's what I recommend, and see what they have to say to me, because it's just my view of the world. So please provide me with a copy. I'll send it over to my attorneys to see what they have to say. But my inclination is not to vote. You've asked us not to. I'm going to concur with that. My inclination is that it opens these proceedings up to question, subsequent hearing, subsequent recusal, all these other things. And I'm not prepared to be subject to all of that.
Madam
Okay,
Chair.
I just have a question, though. I really do. I mean, this was clearly known prior to the board hearing. I think everybody understood that the date was July 1, when these agencies split. That is the statute. What you've read to me is contrary to the statute. I don't know if we rewrite law right here and now, and I would like to know, I think we need to know who it is that prepared that statement. And it was rushed, I understand that, because they were all rushed, as were ours, because we just got notice from our person who's sitting at the hearing. She is just monitoring the hearing. She's not our counsel. Through an email that we had some further disclosure. We have questioned that, and we are trying to get legal opinion on that. And I think the department surely knew before this morning. So I think we need to have somebody with some level of authority from the legal side of of the CDTFA come explain, maybe to us or maybe to explain to a chief counsel that we don't have yet in this seamless transaction, as to what they would like us to do. The statute says we're supposed to have hearings until December. That's the statute. There's nowhere for these people to go. And so I don't understand why you would like us not to vote. I don't know why we have to listen to CDTFA to vote to begin with. But that being said, we have one member that's uncomfortable. So I'm just trying to figure out, we don't report through CDTFA. They don't report to us. So, Mr. Gao or somebody, would you like to opine? We're confused here.
We are as well. I think that Ms. Marks has given the direction that she can, as best as she can at this point in time. We were unaware as you that they were going to make that statement, and so the members are addressing their concerns, so I think it's to the members, and I'll look at council as well.
Well, I just would like to know, why is this all kept in secret? See, this has been my problem since I've been at the BOE. Every time something comes up, it's a total shock to everybody because nobody talks. And so I'd like to know why we were surprised the morning of the board hearing, why somebody didn't call our department last night or during the day. Let us know why you show up here at 9 o'clock hearing with a statement that in essence says we can't have a hearing, and why we don't have someone that can review that and tell us that we can. Or not. And I think it would have been real easy. Welcome to the state of California. Enjoy your business opportunities.
Madam Chair?
Yes.
Let me just clarify a couple things. Number one, appeals, were you aware of this statement prior to that being given?
Only insofar as I know the question was asked of FTB all day yesterday, so I assumed it was a question that would come up today. I didn't know what answer they were going to give.
You were not aware of their answer? Okay. Did you all communicate to the taxpayers prior to this event that this was going to be your position, that indeed the taxpayers had been asked for a hearing, they've showed up here, thought they were going to have their case deliberated, and the state of California was going to ask, one portion of the state of California was going to ask that their hearing not be voted on?
No, we did not. This statement, I developed it last night based on the hearing yesterday and based on the discussions yesterday.
What happened yesterday?
You developed it last night.
Yes, I did.
What changed yesterday that made a statement necessary?
Mr. Renner, my understanding is that, and this has, and if I'm incorrect, please let me know.
Right.
But It is still unclear whether or not it's required to disclose ex parte communications prior to July 1st.
Was that unclear to you 3 days ago?
They need to get his chief counsel.
It was based on the advice of your counsel yesterday.
So the only reason you have this is because this council said that the disclosures were responsible before July 1st. That's the only thing that made this statement, made you make the statement?
This is to protect the California Department of Tax and Fee Administration.
Clearly not to protect the taxpayer.
We understand that.
We speak also on behalf of
Let me just
taxpayers as
ask
well.
one question. Does your department have a chief counsel?
Yes, we do.
Okay, can we take a half-hour recess, run it by your chief counsel, and let's find out what we can do at this board hearing? Because what you're telling us is not in the statute, kind of violates the statute. So I'd like to call a half-hour recess. Please communicate with your chief counsel, get back to us. Let's figure out how we proceed with the board hearing and how they reconcile having the board hearing with taxpayers here scheduled to be heard, and you're telling us not to vote, and how that is all reconciled within the statute that passed as part of the budget trailer language that was supposed to be seamless for all of us.
Madam Chair, the appellant wishes to speak this, just to...
Yes.
Yeah, this is exactly what has been happening to us since 2009 after the audit. And if this continues, what they're trying to do is push it out so far that the interest that is accruing here is going to be higher than the debt that they're saying we owe. As it is, they're saying that we owe $350, and the interest alone is over $187. I mean, really, I do not understand the logic of this.
1,000, right?
Yes.
107,000.
Yes, and my client never collected it. I could understand if he collected tax and didn't pay it or something to that extent, and we gone through this case. They even re-audited the case because we came out and we said, no, we're a subcontractor. At first, they thought we were a retailer of the supplies. Now they're saying, you know...
Yeah, we're hearing the case. This is not what we're supposed to be doing right now.
But I'm just saying, it's a constant...
We hear you.
Okay.
You know, they're just dragging it out.
I know, we're being backed up.
Madam
So,
Chair, I think the other, I'm
going to call for a half-hour recess.
Before we go, I'm
and
going to
we
change,
need-
I'm going to ask for the instruction that you just asked for and clarify. I'm confident that the chief counsel that they have is going to say it's okay for them to say that. I'll bet, next month's pay on it. But my question is, what I would like to then go to the next step, and that is ask what the department intends to do if we do indeed vote for these issues. What's the intention then? What's your chief counsel going to tell us, recommend to you, that you tell us you're going to do if indeed we vote on these items?
Well, thank you, Mr. Renner. Madam Chair, I mean, my concern is that we have basically three different opinions here that are similar in nature. One is that the ex parte communication is retroactive to cases that where we are presiding over. And so my understanding of the statement is that the department believes that they should have access to all evidence, all discussions, so that they can determine whether or not any additional information that's not part of the record is being considered in this proceedings. And that is inherently challenging, as all of the members have somewhat articulated, unless you just had zero communications. And so I also need to check to see if we've had a communication with the department. I'm pretty confident we haven't had a communication with the appellant. And the potential cures for that have been, the legal opinion on the cures for that vary as well. And so my legal counsel says one cure, and I'm being redundant on purpose because this is what I need to have somewhat of a response to, is to just recuse yourself from the process. That both the respondent and the appellant have the option of asking a member to recuse themselves. And then second is to have the information, with the ultimate goal of having the information presented But in the absence of recalling that information, we don't know, you subject yourself to potential information coming up. Of course, the negative confirmation or negative confirmation that I don't know, I don't remember, I guess that sort of protects the agency. All of those, I mean, I don't want to be redundant. I think I've won the record, so just review the record. And I agree with Madam Chair, maybe if it's your testimony that you prepared this statement, absence of review of your legal counsel.
And the governor's office, who you say they report to.
Was that your testimony?
I prepared a portion of it, yes.
No, I mean, who finalized it? Not prepared, my apologies.
I finalized it last night in my hotel room.
Yeah,
I mean-
and so you could have let us know earlier, and
Well,
That would have been ex parte
I mean, I
communication.
appreciate you.
in ex parte with your counsel,
Okay, guys.
ex parte. And the big-
I'm presuming that this is not your personal opinion, that this is the opinion of the department, which means everyone associated with the department, this is their opinion.
You're making a big assumption.
No, I mean, is that correct?
Correct.
Okay, then the fact that you prepared and everything is a good thing. Appreciate your knowledge in that process.
I don't.
Let's see if that's where so I guess we can presume that that's the position of the department, and so taking a 30-minute break is not going to change that position.
Okay, so we have some choices here. We either don't hear any cases today and we leave, or we hear the cases and we don't vote, and we can then take all the items under submission, and then we'll get clarity from the governor's office. I want this to come from the governor's office. I do not want it coming from the CDTFA. Okay, because the legislation that was supposed to be seamless is July 1, and we're supposed to be hearing cases like this until December. That's the law. So I think the CDTFA is violating the law. And in fact, that if they're violating the law and the statute, then these taxpayers should have some recourse.
Well, I don't know if
I am saying that. You don't have to interrupt me, please.
Wow,
I think this has come to this point because this is, okay, please, hush. I've got the floor and I'm the chair. So well, that's what I want.
That's
I
my
want
concern.
Okay, do you want to, board members, do you want to hear and not vote? Just take them under submission until we can have a general conversation. We can have an opinion of the governor's office on this. That's what I would suggest. We have taxpayers here who would like to recuse themselves in that instance, or do we just cancel the board hearing and then what do you want to do?
Madam Chair, if I may, I mean, I've had no communications with the taxpayer, and
That's not even the point anymore.
In time, I could figure out relatively quickly if my staff, my team has had any communications with the department. This is a personal assessment, but my assessment as a member of this body is that it's not in the body's best interest but personally, I'm prepared to listen, prepared to vote. In fact, I've heard quite a bit of evidence already that I'm a little concerned about the administrative delay, but
Okay, then let me, yes.
so I'll submit to the will of the body.
A couple of things. Number one, obviously, we're all doing this on the fly. I'm thinking through it, maybe what I would be satisfied in terms of a two-step process. Number one, I do firmly believe that the law took place July 1st, and therefore any communications prior to that is not applicable under the law. However, I am willing to have a conversation right now with counsel to determine, because I do know what conversations took place prior to July 1st, and in order to then know that a decision that would be made today is going to be then a decision that cannot be challenged, I'd like just a couple of questions to the council in regards to ex parte. If indeed it's interpreted the way it is, that now it is being interpreted by you and also now by the tax agency. and that is a couple things. Number one, if my staff had conversations with the taxpayer, that my staff did, let me start at the simplest point, my staff did, is that ex parte communication that I had?
The law implies that you, that an ex parte communication is communication that you had access to. So if you have meetings with your staff that were in those,
if I was aware of conversations, let me make it easy. If I was aware of conversations that my staff had with this taxpayer, that would indeed fall under ex parte.
Yes, it would.
Okay, good. If indeed that conversation had no information other than that was already previously in the record, would that be any violation then of ex parte?
I think it would. I think that you can just disclose that it's completely consistent with what's in the record, but I think any communication, even if it's reflected in whatever the official record is, would still be a communication.
Okay, so under that basis, under what that statement is, just let me clarify, if I was then to disclose that indeed my staff had communications with that taxpayer prior to July 1st, but there was no evidence or discussions outside of what was already in the record, that would be sufficient?
Except they could.
Yeah, I would think that if you could make it a little bit more specific about what those issues are, then, but yes, I think that would be sufficient.
What those issues are, it's the record. It's the
department's reserving the right to challenge.
Well, right, they can challenge it, but if I know that but they can challenge it, but if I know I'm confident about what the answer is, then heck, I don't care if they challenge it. I just don't want to, at that point, they can challenge all to the cows come home. Again,
the taxpayer said there's been nothing submitted that wasn't submitted to the department.
Well, I know, that's what the taxpayer said. I just want to make sure we're all saying the same thing, because again, it's clear that the state of California, represented by the tax board, is more interested in getting their money than a fair shake to the taxpayer. So I just want to clarify those issues.
That's why it happened.
Okay.
I think, what the code says is that the way in which you disclose it is to have a memo, and let me see if I can get to it. The way in which it's supposed to be disclosed is a memo stating the substance of the communication and any response that was made by the presiding officer or anybody in your stead.
So
that's what the code requires.
Just to clarify what you're saying there, then, in order to meet and solve the issue here, to cure the issue, we should have a memo on each of these items.
That's what the code requires.
Based upon this issue, our offices should write a memo.
That's what the code requires. At this point, because
well, it's important to know that the code requires that. So we should write a memo then on each of these items, and in order to disclose then to what of what took place prior to July 1st.
Well, I think that's what the code requires, although it may anticipate that disclosure is coming in the form of that memo, whereas right here on the record, I think you could disclose orally what was what the communication was.
So in your opinion, an oral disclosure that we would make would satisfy the law?
I'd have to look more specifically at that, but I think that's what.
I thought you just told me on the record it was okay.
No, I would like to look more specifically at that particular issue, and I can take a few minutes to do that. But I think because the disclosures that are on the record are not considered ex parte, I think then.
Pardon me. Council is asking for a few minutes. Could we take the recess? Then I can make the call.
I think so, and actually, I'd like to talk to my counsel
I
too,
would like
I think
that,
that's fine.
because I'm fully
appreciated.
prepared to hear the cases and take them under submission and then get the governor's read on this, because I really am not ready to listen to everybody, but you go ahead. If you can get an adjustment that allows us to continue the hearing, I'm happy. So 30-minute recess. We will be back at 10:45. Okay. Members, I think we are ready to proceed, but let's let our chief counsel or our acting chief make a comment. Did you have any communication?
Thank you, board members. In looking at the sections, I think apply the plain reading of this statute that requires disclosure. This requires disclosure prospectively of communications that are violative. I think that any communication that's ex parte would be violative. We think that just the plain reading really supports the disclosure of any and all ex parte communications. There's always room for interpretation in the law. And I think the advice I provided you yesterday is sound advice, and I stand by that. I think that the way to move forward is relatively simple in that we've been asking about communications that have been made with either side that you know or suspect have not been provided to the other side. With respect to oral communications, the statute does say memo. I really think that anticipates that you wouldn't be making those disclosures on the record, and communications made on the record are not considered ex parte, and we don't want to literally elevate form over substance. So I think to the best of your ability to disclose any communications, any oral communications on the record as you have done, is sufficient to be compliant with the law. I think written communications, I think, obviously is a different issue. I don't see any bar to going forward. The law allows for a way to cure any communications that have not been disclosed, that need to be disclosed. So you could move forward in the way you see comfortable. I don't see any bar to doing that. I don't see anything in the law that, either in statute or case law that imposes personal liability on any of the board members. I know that the law provides for a cure, and that's, I think, the way that allows the board to move forward.
Okay, I would also like to make a statement. I have called legal counsel through the governor's office and through our counsel, and we are going to have Mr. Gao request of the AG a formal opinion so that every agency is operating under the same rules. I did get an opine that, they had that retroactive application of the law was probably not intended. And so with that, I will open it up to the board. We can go forward, we can hear the cases, make decisions, and then also it was kind of implied that the CDTFA did not make law for us, that we can listen to our counsel and to the AG. So we can go forward and make our decisions and vote, or we can go forward, we can hear and take the matters under submission till we get a firm memo from the AG. What would you like to do? Yes.
Just a clarification. I didn't quite understand. You had said that you had quoted somebody, or had said somebody had said that retroactivity of the law was not intended. Who was that from? You said,
I didn't
no, I'm
say
sorry.
that.
That was to the chair.
Somebody, the counsel from the governor's office he was not going to wade into this issue because he thought we probably needed
The
an AG.
chief counsel of the governor's office, or
It
who?
was.
I'd just like to know. I mean, I agree.
Yeah.
I agree. I'd just like to
Well,
know
he-
who it was that opined.
Okay, he didn't actually opine. What he said is that he was involved a little bit in writing the law. He doesn't have it on his desk.
Okay,
But
okay.
he had intended, or he doesn't believe that it was retroactive, or should have been retroactive, but he was going to call Maribel's office, Maribel Batcher's office,
Okay.
and get some direction, which is who our counsel is now assisting, being here. And he
Okay.
was also going to refer or give a couple names for the AG because he believes, as I do, that all agencies ought to be operating under one set of rules, and that we were able to proceed with the FTB based on their language yesterday. We all did. we wanted additional clarification. But so now the question to the board is, do you want to take these under submission until we get the AG opinion, which should come within a day or so? I don't think we're expecting a long process here.
Okay. My opinion is that we should move on. I'm prepared to vote. I'm prepared to actually disclose then, even though I don't believe it's necessary, conversations that my office had prior to July 1st.
The only thing I would caution you, Member Runner, is if you miss one or there's a problem, you want to be pretty vague in your disclosure because I
get it, but I think we're confident, and so I just feel like I don't want to leave anything unturned in order that disadvantages taxpayers in this process. I'm a bit concerned that as you know, I'm afraid that as I interpret, even though it may not be their motivation, it certainly looks like what's happening as TFA is seeking to try to take a second bite against taxpayers. I think that's unfortunate, and I'm not prepared to be a co-conspirator in that process. So for that reason, I'm prepared to move forward, and as we begin this particular hearing, or each hearing, I will amend my previous statement with what it is that I now have knowledge of, and we'll put that on record, which I think council has said is sufficient.
Okay.
Yes, I think that is sufficient. The code just calls for, as I said, a memo. I think putting it on the record would suffice at this point, stating the substance of the communication. If you can't be very specific, you can talk about whether or not there were any facts or analysis or law that is something other than what's in the record.
Okay, thank you.
Okay, are you okay, Ms. Stowers?
Yes, I'm prepared to move forward.
Mr. Runner?
So am I.
Ms. Ma? Prepared to move forward? Okay, then you have heard it. Away we go.
Can I make, I'd like to go ahead and disclose the rest of my statement at this point. As it relates to C7, Brian Wiggins had phone call conversation with taxpayers representative Mr. Naiem on June 29th, 2017. The discussion involved the contention that fabrication labor done by Mexican maquiladoras should not be taxed because the title to the materials did not pass to the maquiladora. In addition, further discussion was held that the ownership of the two entities were basically the same. All those items are within the record, and so the no new information was communicated.
Okay, I would just like to state that if any memoed information that I happen to have, my staff has been preparing, I will be submitting. I don't have it right now for the record, but I did make my statement that we believe we may have had communication with the appellant and the tax department, and probably the tax department as well. If we're communicating with one, we're always communicating with the other. And my office discussed the issues presenting the briefing record only with both the taxpayer and the department. And so that was that we don't, and the rest of my statement is on record, that we don't believe law imposes disclosure requirement prior to July 1, 2017 operative date of provision AB 102. However, we hereby satisfy our ex parte disclosure burden to the extent one exists. And have you disclosed already? Yep. You've disclosed already, you've disclosed. Okay, and yes.
Madam Chair, if I may, Jeff Angijo on behalf of Appeals. To this point, this matter has not been subject to Section 40. Taxpayer today is mentioning interest relief. To the extent that they specifically dispute interest relief, that puts this matter over Section 40. I looked at the timeline during the break. I come up with 18 months worth of delay for which we are revising our recommendation to reduce interest for those months. My very rough numbers, it comes up to approximately $41,000. That still puts it over the Section 40 threshold, even with our revised recommendation, if taxpayer is specifically challenging interest relief. If with that reduction there's no challenge, it stays under Section 40.
So it's still Section 40, which we know, we
If it's not, if they're not specifically challenging it, then it's not subject to Section 40.
I'm confused. So what is I've got 570,232 with taxes, which is total tax and interest.
To this date, until this morning, only the tax was at issue, and that's under $500,000, so that's not a Section 40 matter. Today, they're mentioning the delay. That puts it over. So I've looked at the timeline, I have a reduction, but that still keeps it over unless they're no longer going to argue that.
How much is the tax?
415.
415?
Sorry, I'm sorry. The protest, the redetermination is 389, so, and change, 390.
389 is the total tax.
389, 936.19.
936.19. And so the interest,
180, 296.11.
so here is the question then to the taxpayer, I guess. Section 40 requires a written opinion and whatnot that, is published. It's not an opinion that's binding, but it does discuss the case, what happens, what the decisions were, takes a bit of a, why don't you explain what the difference is?
Section 40 requires a published decision that memorializes this board's order, the conclusion that they reached today. If it's below Section 40, a published decision is not required. It doesn't necessarily change the result for a taxpayer, just that we've got a added...
It doesn't necessarily change your result, but what it does is probably, well, I don't know. I think it keeps it below a threshold to where it gets a lot of scrutiny. I guess that's the best thing to say. Is that?
No, I don't think so. Can I ask a question? Did you say something about an 18-month delay?
So when this matter was first assigned for appeals conference,
Right.
we had personnel turnover. So
Right.
attorneys to whom it was assigned left, and as they mentioned, that happened 3 times.
Right.
It's unfortunate, it's unavoidable, it happens, it's not the taxpayer's fault. I didn't pay attention to that till it was brought up today.
Okay.
So we would conclude that's an unreasonable delay. There's 15 months there. There was a 3-month delay that I count after the department's response and prior to the supplemental decision and recommendation coming out. So that comes up to 18 months, and then I'm just multiplying by the monthly accruing interest shown on the hearing summary, which is just my estimate, not exact. But that comes up to 40,000 and change, so I'm rounding to 41. That still puts us, if all of the interest is disputed, that puts us over the disputed amount of 500,000, so makes it subject to Section 40.
For the practical matter for today, if indeed the dispute is over the amount, and let's say the decision was for the taxpayer, that in terms of calendar, then would mean what in terms of the decision and then us continuing on making the final decision on that item as it would be a scheduled for us.
If the decision is in favor of the taxpayer,
yes,
there would be no petition for rehearing, I presume.
Right.
It goes final 30 days from the notice of redetermination going out. We'd have this before, the Section 40 decision would be back before you before December, if that's what you're asking.
That's what I'm asking. I just don't want to I don't want the taxpayer to be in a position to where we would potentially fine for him and then all of a sudden have a problem down the line because this board would not be the board that would be dealing with that.
We usually expedite these Section 40 decisions to get them back before you as quickly as possible to begin with, and so in this case, we'd be able to do that. We've got to wait for it to go final, so we've got 30 days so figure 45 days from now, and we have it before you on the October calendar.
Okay, thank you.
Okay, thank you. Thank you very much.
So just to close, I'm sorry, the remaining question we have is we need to find out if the amount in controversy, even after my recommendation, is still over or under the $500,000. The amount in controversy is what the board needs to determine so we know if it's subject to Section 40 or not.
Madam Chair, question of the appeals. Is that contingent upon the appellant challenging it? So if the appellant's not challenging the interest, the board still can take the interest matter under consideration, ask questions.
And it wouldn't, you could relieve more interest.
And position the appellant, position the case to be expedited without the Section 40.
Yes, I think I'm understanding you. If it's not subject to Section 40, you could...
challenge.
The amount in controversy is what the taxpayer specifically disputes, and if with our concession they no longer dispute the interest, then you're under that threshold. And the board could still relieve more interest if it saw fit. It could still address any matter under contention. It just wouldn't put it subject to Section 40 if it's not specifically in dispute with an amount over $500,000.
I mean, I think all the cases could be subject to Section 40. As far as I'm concerned, my concern is more expediting the finality of the process for the appellant. In this case, given the lapse of time, I would think they would want a finality sooner than later. And so if they were not challenging the interest, the board could still take the interest under consideration, and that them not challenging the interest would put it below the threshold for Section 40. And regardless of what we did subsequent to them not challenging it, wouldn't change the Section 40 determination.
Correct.
Just wanted to put that on the record.
Do you understand all that?
Basically, what it sounds like is if it's under 500,000, that it's not under Section 40. However, even if he drops it, it's still under Section 40 in this particular case.
Actually, the reverse.
The reverse.
The
If he
reverse.
drops it, it's not under Section 40, but we can still alleviate interest, I guess. That's what you said? We can still take interest under consideration.
We can.
So, do you wish to reduce the claim from 570 to 3230, which has got a $40,000, in essence, this is kind of what it is, $40,000 been removed, so your total claim would be roughly 530, and continue on with the Section 40 requirement, or would you rather reduce, or would you advise to reduce to 389,930.19, I guess is the amount of the tax, and then allow the board to consider interest, because in essence, if the hearing goes in your favor, the interest goes away anyway, right?
Yes.
So if the hearing doesn't go in your favor, then the interest is still there, but you would have to pursue it, I guess, in other means. So, does it matter?
I don't think it matters in this case. I mean, we're contesting the whole amount at this point, so it's kind of a moot point at this.
So that means this is subject to Section 40. You're
Okay.
protesting the whole amount.
So you're contesting the tax and interest?
We're contesting what they say that we owe. You know, which obviously if the council here decides that the amount is not due, obviously interest drops as well. So.
Okay, thank you. I don't have any problem with the Section 40 as long as we get the opinion.
Just that we hadn't noticed that, so I wanted to make
Thank
sure.
you very much. I do appreciate that advice. Okay. Welcome. Oh, Mr. Njija introduced the items, right? There we go. I'm sorry. We're kind of off track.
Madam Chair and members, the appeal before you involves one unresolved issue, which is whether the unreported fabrication labor costs are taxable.
Thank you. Okay, now to the appellants. Thank you very much for your time and your patience. You will have 10 minutes to make your presentation, announce who you are for the record, and then we'll go to the department, which will also have 10 minutes, and then we'll be back to you on rebuttal for 5. Thank you. Introduce yourselves and proceed.
Okay, my name is Shawn Bachor.
Be sure you're speaking right into the microphone.
My name is Shawn Bachor.
Okay, pull the mic closer to you. You don't have to remember. That's fine. We heard you that time. Okay.
My name is Pedro Bachor.
And I'm Harold Newman, their representative. And thank you for allowing us to present to the Appeals Board our case. As you can see, my client, Shawn Victor Bachor, and his father, Pedro Bachor, are here. Client started his business in the United States as a sole prop. He makes cabinets and installs them into high-end homes and other establishments. He is a true subcontractor. The State Board of Equalization has also agreed that he is a subcontractor. He tried to get a facility in the state of California for staining and cutting the wood for his custom cabinets and was hitting a ton of roadblocks. One of them is the high EPA standards, in which he found out that he would need to come up with hundreds of thousands of dollars in order to put special filters and regulators and the like just to stain anything or do anything. So in order to get the jobs that he has, he would need to he has to have this to compete with the large cabinet subcontractors in order to stay in business. So he went to Mexico to set up a maquiladora to stain and cut his wood so he can compete against his larger competition. This case has been going on for many years due to first the initial auditor retired, then it got re-audited, Then, first meeting, the attorney couldn't make a decision. They had to go to many attorneys, as you noted, 18 months of delay. And now my client stands before you with a huge liability that we still believe he does not owe. According to the Appeals Division Board Hearing Summary, this amount is over $570,000, including interest, and my client never collected from his clients because he thought he was a true subcontractor and was doing everything in his power to do it correctly. This amount of sales tax will cause his business in the U.S. and Mexico to close if it's not resolved. Now we stand to see what our fate is. Case has only one issue. Is my client one company or two companies? If both of my client's companies were structured and actually in the United States, we wouldn't be here today. Because in this case, my client, a sole proprietor in California, is also a maquiladora in Mexico. But if he was in the United States, maquiladora is a corporation, sole proprietorship, yes, two distinct entities. But, so the law in that case would be correct. However, in Mexico, maquiladora must be a corporation, period. In Mexico, to be a sole proprietorship, you must be a Mexican citizen or have Mexican immigration status. Any U.S. citizen cannot be a sole proprietorship in Mexico. I have given you an exhibit on what a maquiladora is. The exhibit is given to me directly by a Mexican attorney in Mexico. And as this exhibit states, in order to be a maquiladora, you must get an IMMEX permit. This permit is not allowed for individuals at all. You have to be a corporation. This company is solely formed for the purpose of receiving raw materials and creating products to be used for the U.S. company. A maquiladora cannot sell anything to Mexico or anyone else other than the parent company in the USA. I feel this particular case is presidential for this state sales tax arena. The way the law is done is only based on what company is set up as in the United States. What it does not take into effect is how a foreign country categorizes how a company is set up in their country. By not considering this factor, a small company like Carmel Mountain Cabinetry is being discriminated against solely because he is not a big corporation. If he was a big corporation in the United States, we wouldn't be here. Again, in this hearing, I am bringing up a 1975 case. It is Mappo versus State Board of Equalization. Mappo was a U.S. corporation doing business for Walt Disney Productions, which is also another U.S. corporation. In this case, Disney retained all the title to materials, ideas, and completed items done by Mappo. Disney was in charge of all day-to-day operations of Mappo Corporation, and Mappo Corporation did not do any other work for any other company other than Disney. The conclusion on that case was that Mappo was fabricating items for itself through its employees, in fact, and therefore no sales tax was payable. To me, this case is the same as what my client and his maquiladora are doing. The only difference is that my client has a Mexican company and a U.S. company. In closing, please look at this case based upon what it really is and the facts in the case. The law is ambiguous to any foreign entity classification and should be noted on how the companies are structured and not their classification in this case. In our mind, the result should be clear as to whereas dealing with a mutual foreign company is in a classification completely on its own. The word corporation in many countries is not the same. Sometimes a business is also forced into creating a company based on foreign laws, as in my client's case. If he had a choice, he would still be and will be still a sole proprietor in Mexico today.
You have more time if you need it.
And
No,
basically
you're okay.
what this case is again, it's one case. Is he two corporations? I mean, is he two different businesses? The only reason why the State Board of Equalization is stating that they're two corporations, and it states clearly in the summary, the only reason is because the maquiladora is a corporation and he's a sole proprietorship. And in the law, yes, if it was U.S. law, that makes 100% sense. However, and also in the summary, it says that he had a choice, but he didn't have a choice. In Mexico, you cannot, any American citizen cannot be a sole proprietor in Mexico, period. You have to have a 1% Mexican owner in order to become a maquiladora. The only reason why he did this is so that he can compete with the higher-end cabinet people to do his trade. And, you know, it was just not cost prohibitive for him because of all the EPA regulations and everything else in this country here to be able to satisfy, staining and cutting lumber and so forth. I mean, he does excellent work where it's even scribed into the walls. I mean, he does not even use the molding that you see today. So he has a custom trade that he does himself, and he has his laborers in Mexico. Some of them have permission, immigration, where they can come over and work, and they come with him to help. So they are his employees. He goes to Mexico every few days, correct? Every few days to make sure that the operation is going the same way, and he is the owner of both companies. So that's basically our statement. I mean, I could drag it out more and more, but I think it's cut and dry.
You'll get an opportunity on rebuttal.
Okay, thank you.
So listen up. Here comes Department of Tax and Fee Administration. Thank you. You have 10 minutes. And please introduce yourself for the records.
Thank you, Madam Chairwoman Harkey and members of the board. I am Andrew Cui with the California Department of Tax.
Can you speak up? I think just get low. There you go.
Oh, I apologize. My name is Andrew Cui with the California Department of Tax and Fee Administration. With me today is Robert Tucker, also with the department, and Kevin Hanks, also with the department. Petitioner is liable for tax measured based on his cost of cabinets that he furnished and installed in California. As his representative states, the law is clear. The law provides that if any person fails to make a return, the department shall make an estimate of the total sales price of tangible personal property purchased by the person for the storage, use, or other consumption of which is subject to use tax. As relevant here, the Revenue and Taxation Code Section 6005 defines a person to be an individual, a partnership, a corporation, or a trust. It defines an individual and a corporation to be two separate persons. Petitioner did not hold a seller's permit or file returns during the audit period. Therefore, the department billed petitioner as an individual for the tax liabilities petitioner incurred from operating his sole proprietorship in California. Petitioner is disputing the liability on the basis that he believes he, as an individual, is the same person for sales and use tax purposes as a Mexican corporation from whom he purchased the cabinets. Petitioner furnished and installed the cabinets as a construction contractor in California. The cabinets are fabricated in Mexico by the Mexican corporation. The Mexican corporation has two shareholders, Petitioner and Mr. Victor Vargas. The corporation is also set up as a limited liability entity in Mexico. Petitioner purchased some of the materials tax paid in California and then shipped the materials from California to the Mexican corporation. The Mexican corporation then used the materials, for example, wood, to build the cabinets in Mexico, which it then exported to Petitioner in California. The corporation also issued invoices to Petitioner for the cabinets and did not collect sales tax reimbursement from Petitioner on the invoices. At the time of importation, Petitioner filed entry documents with the United States Department of Treasury, U.S. Customs Service. The entry documents list Petitioner as the importer of record, the invoice number, a description of the merchandise purchased, a value in U.S. dollars, and the weight and quantity purchased. The entry documents also include a check mark in the box stating, "I further declare that the merchandise was obtained pursuant to a purchase order or agreement to purchase, and that the prices set forth in the invoice are true." Copies of the invoices are attached to the U.S. entry documents. In response to the question, record whether the transaction was between related parties. Petitioner typed, "not related." The documents are signed by Petitioner's attorney in fact. The entry documents also include the Mexican corporation's manufacturer ID number, identifies the country of origin for the cabinets as Mexico, and based thereon, the Mexican corporation is able to export the products to Petitioner tariff-free. For the tax years in question, Petitioner also filed federal income tax returns reporting his income from the cabinetry business in California as a sole proprietor. During the audit, the auditor determined that Petitioner's total sales reported for federal income tax purposes was Petitioner's bank deposits from his two California bank accounts. Petitioner did not provide bank statements for the Mexican corporation's bank accounts, and these were not examined in the audit. Petitioner deducted his cash payments to the Mexican corporation and his cash payments to California vendors for the materials as the cost of goods sold for federal income tax purposes. The Mexican corporation, on the other hand, filed separate tax returns as a corporation in Mexico. Petitioner believes that we should disregard the fact that petitioner and the Mexican corporation are separate legal entities and that they claim federal and international benefits based on their separate legal status. However, the law is clear and defines an individual and a corporation as separate legal entities for California sales and use tax purposes who must report, file, and pay their respective tax liabilities separately for purposes of the sales and use tax law. There is no statutory authority to combine the sales and use tax liability of these two separate entities and then to treat them as a single person for sales and use tax purposes. Regarding petitioners, the case that petitioner cited, the MAPO Inc. versus the State Board of Equalization, that case is also distinguishable. In that case, MAPO was a wholly owned subsidiary of the other corporation. It owned no materials, it kept no books and records, and it bore no liability for the products that it made. In other words, it was basically just a corporation in name only. In this case, the corporation from whom petitioner purchased the products at issue had two shareholders. It was a limited liability entity versus the sole proprietorship. In addition, it issued invoices. It had its separate bank accounts. It had separate records. And there were, of course, the declarations, too, that this was purchased from, quote, not related, end quote, entities for the prices stated on the invoices, which are attached to the U.S. entry documents. And I have those available if the board members would like to see a copy, for example, of the entry summaries and an invoice that was submitted with the United States Customs Service. And also, regarding interest, we concur with the Appeals Division's recommendation, or the Appeals Bureau's recommendation. Thank you.
Thank you. Okay, you have 5 minutes on rebuttal.
Yeah, based upon that, you are stating that it is a corporation. It is a maquiladora. We gave you documentation stating that it is such. If you go based upon a maquiladora corporation is completely different than another corporation. And yes, they have to have separate documentation because they're in separate countries. If they were in the same country, it'd be the same. You know, in order to go through the borders, you have to have a purchase order to get things through the border. Otherwise, it's not going to come through. We gave them boxes and boxes of documentation on both companies. And again, they had the first auditor in there, and at the first time, they're stating that it's a purchase. It's not. They did the re-audit, and they found out, and they noted on here that they were a full subcontractor. They are doing the materials, creating the product, bringing parts of the product from Mexico over, and then assembling it in the U.S. and putting it together. Now, they did pay all sales tax on the lumber and almost every other part that went into these cabinets that went to Mexico. There is a specific double taxation treaty between Mexico and the United States, hence the maquiladora. Again, the biggest issue here is, you know, they are stating that it's a single, he's a sole proprietor, the other is a corporation. That is the distinction, and that, to me, is the only issue different in this case. Anything else on that? I mean, the sales tax, we didn't have a sales tax license, again, because we assumed that we didn't need one due to what my client was doing.
Okay, members. Member Ma.
Okay, I'll just start. So, to the taxpayer, it said that there were two shareholders. Who was the other shareholder?
Was one of the employees in the Mexican, so we put him on for 1%, so he could be, so the corporation could be done in Mexico. So
Right.
it's just like the Hilton or Sheraton Hotel, they have to have somebody, an attorney or something, have 1%, and they could build hotels or whatever. It's the same thing for anyone that's going to do a corporation up there.
Okay.
See, the main thing is that all the materials that we buy, they're buying in the United States, and we pay the taxes on the materials, everything. Be a nail to all the lumber. and
Okay.
then it's shipped to Mexico. We do the product, and the product comes in parts. It's just like a framer in construction. A framer comes and frames, he doesn't pay any taxes because he's putting it in the walls. We're putting this cabinet, this is not a fixture. We are not selling tables. This would be taxable. We have a product and they know it. We gave them all the records of all the installations that we do. We even send them pictures, how the materials, we send them over to the United States in bundles and everything, and we have to put them together. We have the laborers here and they're working, they're putting the materials. So that's not a taxable item. This is, we don't have a store. We don't show the cabinets like other stores that show the cabinets, that's different. Our cabinets are in very high-end homes where we have to apply them right to the wall. There is no scribes. They have to make perfect custom, and that's where we're at, because that's why we pay all the sales tax up front for all the materials. We know we have to pay sales tax, that's where we do it, all the materials. The same thing as the framer buys the lumber to build the houses, he pays the material. The rest is labor. So we do the labor, and that's why we're disputing this tax that what they had on it.
Okay. That was my one question for now.
Anybody else have any questions? Member Horton.
Thank you, Madam Chair. Question of the department. Department indicated, the appellant indicated that the product was purchased tax paid.
Yes, that's correct, but during the audit, we actually made an allowance for all the tax that was paid, so that amount is not at issue. It reduced his liability.
And the department also adjusted for any shipping expenses that would have been exempt shipping, if it were. I'm asking, actually.
There were no, on the invoices that we had, we didn't have separately stated shipping charges. In order to be non-taxable, shipping charges need to be separately stated, but the invoices just listed the prices of the materials.
Is that pursuant to a test period, or there was no, to the appellant, in shipping your product to the United States, did the corporation charge the partnership for shipping?
I'm sorry, again?
Did the corporation charge the sole proprietor?
Sole proprietor, my apologies, for shipping?
No, the corporation is the same. He's a sole proprietor in the corporation, he is the same. So we didn't charge each other. We just pay the drivers and we pay, the shipping.
In any of the invoices from the Mexican entity to the California entity, in any of those invoices, was there a charge for shipping?
No.
Were there in?
How was the product shipped?
The product shipped in trucks.
Your own trucks or a shipper?
His own truck.
Own truck, okay. No further questions this time.
Member Runner.
Yeah, in that exchange there between the materials coming from the maquiladora, was there an invoice?
Well, the maquiladora invoices to cross the material in the border. You have to have an
Is it an invoice or just is it actually a bill, an invoice?
No, it's not an invoice. What it
Okay,
is
so
is
what
like
is it? What is it that you have to show when you come across the
It's like
border?
a bill on lading. You have to
A
show,
bill of-
because
okay.
we have to show all the material that's coming
Okay.
into the United States, you have to show going
Gotcha.
back.
So so there is no real invoice. Nobody is being billed
No.
for the materials that are coming from Mexico to the U.S.
Right.
And again, that's under this whole concept that it's all one ownership.
One ownership.
Because you wouldn't bill yourself.
Yeah.
You wouldn't create an invoice for yourself.
Yeah, and that's
So it's under the
correct.
concept that there is just one ownership, there's no invoicing going on, there's all the transportation is all within the same ownership. The thing that creates then the structure is the fact that it is required under Mexican law for you to have this maquiladora
Yes, correct.
established is what is unique about this, which is out of your control. It's just what it is that the Mexican law requires.
Yeah, plus also, if they didn't have it under Maquiladora, they would be subject to VAT tax and all of the Mexican tax, which would be a double taxation. So it is a specific and specifically geared for other countries to invest in for labor in Mexico.
Right, and these are all agreements that are
This was
treaties.
created
These
by
are all
NAFTA.
treaties and economic agreements between
Exactly,
the
that
United
is
States
correct.
and Mexico.
This is
in
under
order to-
NAFTA.
Pardon?
This is under NAFTA.
NAFTA, right. These are all agreements under federal law that allows you to do this.
Yes.
That is correct. It's similar to like PepsiCo and Pepsi, the same type function where PepsiCo is a foreign maquiladora in Mexico making Pepsi, or Coke is another one, in Mexico. Everything is made there and it's shipped to the United States. So it's the same type of operation.
Okay. To me, it's important to see, I mean, again, the concept to me is ownership. And clearly, if there was two corporations in the sense that you'd have to build one another, you'd have to have record, you'd have to demonstrate that you're actually changing ownership of the material from one place to another, there'd have to be greater record. But clearly, the fact that there is none of that is, it seemed to me, an indicator that it is all clearly under one ownership.
That is correct.
Okay, thank you.
Member Runner,
You can ask him what you want.
no, you just bring up an interesting point. If there is no document consummating a contractual sale, I mean,
They're dying to talk.
I'm going to have to kind of take a look at this. I mean, we're basically imputing the selling price without such a document, and the Mexican corporation could take a loss if they wanted to and sell it for a whole lot less if they wanted to, and how would we dispute or impute a price other than that, and particularly with it being a foreign country? But I see you guys kind of circling. Mr. Cui?
Yes, Member Horton, they actually did issue 2 invoices for every transaction. One of the invoices was attached to the U.S. entry document, and the entry document stated again, quote, "I further declare that the merchandise was obtained pursuant to a purchase order or agreement to purchase, and that the prices are set forth in the invoices are true," and an invoice was attached. And in addition to that, there was a handwritten invoice that was separately, in addition, prepared for each transaction, and I have copies, and I can provide them to the board members. I can provide the invoices and entry documents to the board members if you would like to review these documents.
I would like to see the documents and share them with the appellants as well.
Are you saying you only have 2 for the entire audit period?
No, for each transaction, Ms. Stout.
These are examples of each.
I provided, there's 2 invoices for every transaction, but then we have invoices there were invoices provided for the entire audit period.
So just to summarize, CMC does invoice the petitioner for the fabrication labor that's at issue today. Also, some materials are acquired as well in Mexico and used to fabricate the cabinets. So some of those charges are included in these invoice billings then to the petitioner's business.
So,
There are no materials built in Mexico. No materials are acquired in Mexico, period.
that's not really the line of questioning. But, case is still open. They believe that this is one entity. They operated under the presumption that this was one entity. Under that presumption, they have a right to charge whatever they want to charge. And if the corporation changes its mind and issues a refund for these sales, then that reduces the selling price, in effect reduces their liability to the extent that, and how would we argue that?
Correct, Mr. Horton. We aren't arguing that that there's a sales price in addition to what was charged. What we're just saying is that the amounts that CMC billed to the taxpayer for the assembly labor, the fabrication labor, is what the added taxable component is. That's the charges that are part and parcel to their cost to perform this construction work.
I appreciate that, and I think the department was right in doing so. But given the relationship of the entities, I'm under certain circumstances, in the absence of an agreement between the parties, the agency has the right to impute the selling price. But if these parties were to agree to a different selling price, then what would be the department's options at that point? I mean, even now, they could go back and say, okay, well, we weren't two separate corporations. And I know Water's Edge sort of comes into this. I can't remember exactly. I'm going to look it up while we're talking. But this is a foreign company that we're arguing is not related to the California-based company. And this happened with the auto dealers back in the 1900s, where the auto dealers, the manufacturer was overpricing in order to reduce the profits in California in order to minimize the tax. And then we passed legislation to kind of deal with that. But let me just ask the department their opinion under that circumstance. One, do they have the option, the right to do that? Of course, I don't know how you say they don't, but, and if they were to do that, what would you say? What would be your position?
Yes, Member Horton, and I would just clarify that during the audit period, the sole proprietorship petitioner actually made payments to the Mexican corporation, and he deducted those payments on his federal income tax returns. He deducted the payments made to the corporation in Mexico. And I'd also clarify that the issue is that the law defines a corporation and an individual as two separate persons.
No, I get
so
that.
it's not, yeah, okay.
I get the law defines them as two separate persons, but they're operating in such a way that they can actually control these transactions. And I don't know what their income tax return said. I mean, I don't know if they got losses that they're carrying forward. And if they do have those losses, to the extent that they do, they can make an adjustment. I mean, they control these books. We may take a position that they're separate because of form, but as far as reality is concerned, they have complete control over, appears to have, or alleged to have complete control over these transactions. And so I don't know why they couldn't just adjust it.
Mr. Horton, if they were to adjust, they would need to go back to their income tax returns. They've
I
already
agree.
claimed these payments as cost of goods sold.
I agree.
So they would
I
have to
agree.
file amended tax returns.
I agree. I'm not disagreeing. I mean, in fact, I actually said that depending on the income tax implications, they had lost, I don't know, I haven't looked at it, but if they had losses on the income tax returns and they can make the adjustment, or somehow anyway, not my call. I mean, I don't know. I mean, taxpayer, and then thank you, Madam
Yeah, can I speak
Chair,
on this?
for indulging.
As a maquiladora, you cannot have a profit in Mexico.
Pardon?
The profits in Mexico are zero. You know, as a maquiladora, that is one of the conditions. It's mainly for the labor to have the labor in Mexico. When they were paying the maquiladora, it was just to cover the costs that were incurred on the maquiladora only. And if you went through the books, all you would see is monthly, daily checks going to them to cover the costs. So, I mean, it's a direct, our mind, it was transparent.
In that case, I withdraw my discussion.
Was it to cover the cost of what?
The laborers in Mexico.
The labor?
And any of the fabricating costs themselves in Mexico itself, i.e., electrical, their warehouse, not the warehouse, but their little area where they do the cutting and so forth, that type of stuff. It is solely for the continuance of the laborers. And also in Mexico, they have a very strict employee type of function that they have to deal with. They have, I'll let Shawn speak more on the employee side, that they are bound by having this.
I would like to hear about the employees.
I'm sorry?
I would like to hear about the employees.
Yeah, when you're looking at the invoices, these ones right here, these are invoices from our place here to send to Mexico. This is not coming from Mexico here. You could see the invoices, what it says on top. It's going to, and what it is, the tax there, those are when we ship in the materials to Mexico, we have to make an invoice of all the taxes and the materials coming in. So when they come out, we have to bring all the materials back. Even sometimes it's sawdust. Mexico wants you to take it back because it doesn't belong, because that's a maquiladora.
Okay.
So if he looks at all these invoices are bogus. They're not invoices coming out from from Mexico to us. This is plywood. If you see them, it says how many sheets of plywood. Those are the materials. That's good. That's good. These are things, the shipping here through the broker, the materials. They're all materials that we send to Mexico.
Can I just?
Go. No,
I
I was going to hear about the employees, but let's just keep going
Yeah.
on the invoices. I
Member
defer to
Mar,
you,
did you
Mr.
have
Herrera.
something
Oh, I'm
on
sorry.
invoices?
But we'll come back. Go ahead.
Well, I had another question.
Okay,
Can I-
who wants to
can I
talk
follow up
about
on the
the...
invoice?
Yes, please.
Let me just finish up on the invoice then, so we get to conclusion on this particular issue. So this invoice here that isn't an invoice that came from the maquiladora.
Yeah, it
I'll get
didn't
through.
come- it
Maquiladora
didn't come from Mexico.
To your Temecula.
No.
No, it comes from the Temecula
This is
to the
an invoice
maquiladora.
that you sent with the materials to
Yes.
Maquiladora. So there still is no invoice
Right.
that
No.
exists.
No.
Once the materials are fabricated or stained, I shouldn't say fabricate, stained
Right.
from Maquiladora to the United States.
Yeah.
Correct?
Right.
There's no invoice.
Okay, let me just see what department says.
That should have been the third document. It's the handwritten document that says Caramel Mountain Cabinet Tree, SDRL.
You're going to have to speak up closer to the mic.
We don't have the third document.
I do.
Oh, there should have been a third document
No,
with the
I don't.
handwritten.
Handwritten document, I do not, I have one, two, none of them are handwritten.
I have
I have two
Carmel.
of the same invoices, 022.
I have no
Carmel
handwritten
Mountain.
document.
Here's-
My apologies.
Okay, here's okay, I got a handwritten document now.
Can I have one of those, please? One copy?
Yes, you may.
If I could make one other comment, we also have the statement from the representative that the amounts were billed were for the labor, and which he regarded as fabrication labor, and that's the amount that's at issue today.
Okay, let me ask so you have this before you now?
No.
I don't
Yeah,
have
yeah.
it.
Getting it. She's making a
She's
copy.
bringing a copy.
Must be in pesos.
The big. It can't be dollars.
Thank you.
Oh, well, that's a different date. This has nothing to do with this.
No, but it's the idea, it's some, I mean, I think, yeah, we gotta see what it is, I guess.
It's a different date.
Yeah,
It's not related to these things, I don't know what it's related to, that's why we need to, well, we can go on with some of our questioning, and then once you get a
Okay,
copy
I
of
have a
this,
question.
we can come back to
Okay,
it.
thank you, Member Mock.
Okay, so I have a question. So you buy the wood and the supplies, you pay tax here in the US, then you ship them down, you truck them down, you have people that stain it, cut it, and then you bring them back to your truck and you install them in
Houses.
houses.
In the construction
And then
houses.
who is selling, so the contractor, so you work for the contractor? So the
Yes.
contractor is the one that actually sells the cabinet at fair market value, right, to the developer or the owner?
Yeah, what it is it's the homeowners building a house. There's a general contractor, and we're subcontractors, just like the framers, the plumbers, the
Okay.
electricians.
Okay.
So we supply the cabinets, and we install them. The installing part takes sometimes longer than the building of the product because it comes in parts. That's why if we were selling tables or cabinets that people will see, we'll have a store, and then we have to pay tax on it.
Got it. And then,
This
so
is-
the contractor is the one that writes the invoice to the homeowner? Like, you never send the homeowner?
No, we send an invoice. We send
To
an
who?
invoice to the contractor.
Right, to the
because that's our
contractor.
contract.
Right,
That's our contract.
right, and
And then
that's
he
your
bills the
services
And he bills the customer,
for the
and then they pay
cabinet.
us.
And then the contractor is the one that sends bills, marks it up,
Mm-hmm.
bills the owner, and presumably charges the sales tax.
No, what happens is that when it is something that, a fixture that you buy, let's say for example, a bathtub that the plumber sells, they charge tax because they get in a store. Like I explained, the framer, he buys all the lumber, he puts it up, he never charges tax. He pays tax on the lumber. It's the
Right.
same as
I
us.
get it.
We
I get
pay tax on the lumber because this is not a fixture. We are installing it in the walls.
Got it. But you do not charge the customer, the contractor charges the customer for
Well,
all
we
of
s-
it.
we send
You
an
work for the
invo-
contractor.
Yeah, we send an invoice to the contractor.
Right. I get
And then he just,
Got it.
either they
We're
got paying
fine.
vouchers or
We're
checks.
fine,
I
we
got it. I
understand.
just
You're a
wanted to make sure that
subcontractor.
You are
Yes.
truly a subcontractor.
Truly subcontractor.
And,
yes.
and they do have a subcontractor license too, so
Okay.
we are bound by that as well.
Okay, thank you. Did you have some questions?
No,
I-
back to your employees. Talk to me about the Mexican employees. Who's paying them?
We're paying the employers.
The sole proprietor?
Well, he's paying the company.
pay-
What the maquiladora does, it's just their pay like if it was an employer here. They deduct insurance, they have insurance, they have the taxes and all that. So this is the money's wire transfer from his account, and all the employers get paid in Mexico every week.
Every week.
If I
Treated
might.
as if it's still a single entity.
When I was, long ago, I worked for a company, I was the bookkeeper for a company that contracted maquiladora in Mexico. I guess that's kind of redundant. But they just send an invoice with all the employees, the dollar amounts, and you, in essence, just pay that invoice for the expenses. And that's kind of the way they're handled.
The department said something about the company was a limited liability entity with two owners, and you all said one of the owners had less than 1% ownership. Does anybody know, is that a limited liability entity similar to a limited liability company in the United States where it could be considered disregarded?
I'm sorry, what was the last part? I didn't.
Is it similar to the limited liability companies that we have here that can be considered a disregarded entity?
Yes.
Because everything they're saying to us, all of the expenses that have been incurred by this entity is paid by them as a sole proprietorship. So it's as if it's one, and it does not really exist. It does not seem like it exists for Mexico tax purposes because you're saying it does not pay any taxes there.
No, but they do have to report.
They
you
did
explain
I
file.
want to
that?
tell them about the reporting on.
You have
on the Mexican
reporting,
side.
but you don't have tax obligations.
Correct. I mean, they just have to report what is going on. They have to report
In-
the employees and stuff of that nature.
In Mexico, how it's called Hacienda, the IRS, and every corporation there buys it goes in the computer, and you buy this program, and it's very expensive, it's like $5,000. And everything goes, you have to report. They could go anytime on your corporation and look that it's straight. It's not like here that you do the tax and everything. We are just working with, if it was like the IRS, Hacienda, it's almost like a team. Every week that they put on, they have to put on straight how much the workers get and everything, because we're not making any profit, so we have to report all that on it.
Okay.
I
And the
don't know.
reporting is done by the individual.
Yes, we have to report it, but everything, they check everything out because it's in their computer constantly. It goes to their IRS there, which is called Hacienda, and my accountants there, they put it on, and that's what, everything has to come out even.
Okay, thank you.
Now, on the invoice here, one of the invoices here is in pesos, the 420,000 pesos that is there, the invoice is in pesos. Now, one of the reasons that these invoices are done is to see what we're projecting on the month, or 2 months or 3 months. And what they do is they send it us to our offices here in Murrieta, and we check them out if we're making any money or what we're doing and all that, what is coming out, and that's one of the projections of this. This is not a custom invoice. Custom invoice, if it was something done by custom, it would be sealed and it will have stamps and everything. This is just for our records.
This would be used as kind of an internal control
Yes.
Exactly.
within the same ownership.
Yes.
Thank you.
And the same thing is, everything they're saying to the department is that they are treating it as one. They're covering all of the expenses of the Mexican company. They're doing all the reporting of the Mexican company. And this limited liability is very similar to either some kind of a pass-through entity. That seems to me that it is a single entity, and you don't have a third party.
Right, and just to clarify, even in California, an LLC and an individual would still be treated as separate entities under the definition provided of person under the sales and use tax law. So even if you had an individual and then an LLC as two separate entities, that still would be considered two separate persons for our purposes here. And then here, in this specific case, it's even further removed because not only is this an LLC, but it has two shareholders versus one shareholder. And of course, they did have documentation recording these transactions. They had separate filings. They filed tax returns in Mexico as a corporation. And I mean, basically, the way we're looking at it is that the law defines a person separately as an individual as one person, and a corporation or an LLC is a separate person. And then
What about a partnership?
And a partnership also is a separate person from an individual. So even if you had an individual and a partnership doing business with each other, those would be two separate persons. They'd have two separate sales and use tax returns and two separate permits with us.
If they were required to
If they
have
were
a
required
seller's
to,
permit
right.
and to,
If they were required to have a
Right.
permit, yes.
Okay.
Back to the invoice, so this third invoice,
Pardon me.
is that the one that you guys are using to impute the sales?
We didn't.
We're not imputing sales. I just wanted to make that clear. So we're not imputing sales. What we're looking at are just the direct costs of the cabinetry that the petitioner is installing in these contracts. So what we've done is identify approximately $1 million of property that was acquired tax paid. We've allowed credit within the audit for that $1 million worth of purchases, but there are $5 million in additional costs related to all the cabinetry expenses that the business has incurred from the company in Mexico. And it's those charges that are in question that we're saying tax is owed on that assembly fabrication labor that's performed by that other entity, whose costs then get passed on to our taxpayer, and our taxpayer is then taking a deduction on their federal income tax returns associated with those $5 million of charges from the Mexican entity.
And that's, I'm assuming that may be everything we've been talking about, that you're paying the Mexican entity, the labor, the shipping,
Basically,
and
everything.
where else you have to pay under
Utilities.
So some of that may not be labor. Is it possible that what you picked up, or what, to the petitioner, what you reported on the return could be a mixed bag of labor, utilities, shipping, and everything else?
Based upon this number here, this $4,790,000 in fabricated labor, that's the entire jobs. I mean, on his personal tax return, in a 5-year period, he didn't make gross $1 million a year. So I don't know how they're coming up with this labor. I really don't. Can you explain?
So those are the identified direct costs associated with all the cabinetry work that is conducted by the business. Originally, when the auditor looked at the business, he was thinking that they possibly were retailers of fixtures. It was later determined, no, in fact, they're not making retail sales of those fixtures. In fact, they're the consumer of all the materials and the assembly labor related to the construction of those materials, because they're not selling them in a prefabricated condition. So what the law says is that you need to incur tax on any of those associated costs, either assembly costs or material costs. These are just material costs associated with all these contracts that we found associated with all the cabinetry work over this 3-year audit period.
Go right ahead.
That sort of presents problem, not necessarily, but let me just ask some questions.
This is basically, sorry, go ahead.
I want to try not to be leading in these questions, so forgive me if I am. The department picked up all of the expenses, not necessarily a contractual sales price, but the expenses, did I hear you correctly?
These are the actual incurred costs to pay for the associated assembly labor that's performed in Mexico.
And how did you determine it was the cost, and where did you get the number?
So from the invoices that Mr. Cui presented. I mean, this was just for one contract, but there are numerous invoices, that relate to each individual customized contract.
And is that the answer? And so you looked at one invoice, and based on that one invoice, you made the conclusion that all of these, or did you look at things on an actual basis? I mean, where'd you come up with the total number? How did you get to the total number?
If I may clarify, they had costs of goods sold listed on their federal income tax returns, and
you did use cost of goods sold?
Yes, we looked at that on their income tax returns and also on the profit and loss statements that they provided for cost of goods sold.
So there's an assumption on the part of the department that cost of goods sold reflects the total fabrication labor and all the costs associated with fabrication based on your observation of one invoice?
No, multiple invoices.
How many invoices?
We've just illustrated one of the invoices for one of the many contracts.
So I'm trying to extract how the department got there. So if you want, you could just tell me. So the department did a test, right? And they didn't do a test. They just
no test. So basically, we're looking at the profit and loss statements and the income tax returns.
I get that.
For all years?
I want to focus on the test that the department did to determine that cost of goods sold all of cost of goods sold reflects the fabrication labor from the Mexican entity. Tell me about that test.
So to clarify, in the original, I could go originally in the first audit, the FBO audit, they didn't provide income tax returns or business records, so we used solely the declared import value, and you have a copy, for example, of one. And we had a listing they had these declarations for 2007, 8, 9, and 10, but not for the last year of the audit period. And for 2008 to 2010, we actually accepted the taxpayer's profit and loss statements that were provided to us by the taxpayer. In addition, we had the supporting invoices. And for 2011 and 2000.
In addition, we had supported invoices.
Right, we had
You didn't look at the invoices on an actual basis, so can you define what you mean by supporting invoices?
Right, so they
quantitative analysis.
So they had like basically three values. There was the cost of goods sold deducted on the income tax return, there was the profit and loss statements, and then they had the declared values on their import statements. And their profit and loss statements, they actually provided to us they showed a lower cost than what they deducted on their income tax returns, so we gave them the benefit of the doubt and used that lower value.
I get that. And in the absence of source documents, you issued an FBO, you used the profit and loss and all the other final documents that they had. What did you look at to determine that all of cost of goods sold should be attributed to a sale between these parties of fabrication labor?
So we're looking at their various...
What source documents did you look at? What tests did you conduct?
Profit and loss statements.
That's it. So you just looked at
profit and loss statements. They had some federal income tax return information that we could also examine. The profit and loss statements were supported by invoices, purchase invoices.
You keep going back to the profit and loss statements supported by purchase invoices. Did the department examine purchase invoices and all of the expenses, some source documents, to determine that all of cost of goods sold reflects the selling price of fabrication labor between these two entities?
Yes. We have the categories of cabinet Mexican cash expenses, materials for cabinets, and Mexican wire transfers. And so those were the component
Tell me about
categories.
That test. Tell me what you did. I get you got the categories. Tell me about the test. Did you do a test of all of it, cost of goods sold? And of that test, you determined all of it was fabrication labor, or did you do, and I'm going to use this term, but it typically is called a segregation test, where you take a look at the universe, you kind of segregate it out to see what cost of goods sold is. You develop a percentage, and you say, based on that percentage, based on this test, based on that percentage, cost of goods sold reflects all fabrication labor, and there's no errors in the reported cost of goods sold.
Right.
And so you verify it so you can accept it. Or in the absence of evidence to the contrary, you just accept it, and that's the right thing to do. But I'm just...
So typically what happens, and what
I
happened in this
typically.
case...
I try to stay away from hypotheticals, even on my side of the fence. What actually happened?
Right. So in our examination of the taxpayer's accounting records, and most importantly through our communications with the taxpayer, just to identify what these costs represent, we determined that there were these three component charges that relate to assembly charges performed by the maquiladora.
Okay.
And so they led us through the individual invoices that you have in front of you for some of the transactions. Typically, we don't look at every transaction because we don't have the time to do that. But we trace some of those transactions into the summary records. That's what was done in this case.
Okay.
And then we looked at the importation documents that confirmed the U.S. dollars that were associated with those purchases. So those kind of tie to the profit and loss aggregated costs that we're scheduling in the audit.
Yeah, I understand what you're saying. It's a long about way of saying without repeating it. I get it. Question of the appellant. The expenses that you are you required in any way to cover these expenses related that the Mexican entity has?
Yeah, all the expenses we have to pay.
You pay all of the expenses?
I'm sorry?
You pay all of the
It's one company, so it's just like if you have the company here, you have to pay the expenses to the workers, the rental, the electricity, water, everything is paid.
Okay. And on the labor, you just paying the actual cost of the labor?
Yes.
So what?
In Mexico, they have, the pay in Mexico is the labor gets a pay, and it's got, including, it's called another thing, it's called Infonavit, which is for housing for them, and then there's another payment that is the IMSS, which is the insurance, like the Social Security, and then they have the vacations pay, they have a pre-vacation, they call it too, and then they have an aguinaldo at the end of the year that they get bonuses and all that, and that's required by law, by the Mexican law. It is not, a lot of people think that it's very cheap to do the stuff in Mexico. It is not. It is very tough to work in Mexico. He has to go, I have to go to the shop and travel 105 miles back and forth. That's 210 miles. And,
It seems that the department has taken a position that all of your expenses are, they're attributing all of your expenses that you are treating as part of your cost of goods sold because it's called part of your cost of operating that company. They're treating all that cost as a sale of fabrication labor. And so if there is within their, if there's an agreement between the parties that the fabrication labor is only to be billed to you as the actual cost of that labor, and that you're somehow expensing the rest of that as some other contractual relationship, then, and you can distinguish that, then the selling price of the labor is the actual cost and not all of these other expenses, if that's the case. Again, I don't want to lead you into anything.
See, the other way too, that if we were selling to a store, then we wouldn't even pay tax on the material that we buy. We'll be tax exempt.
I mean,
And then the store charges a
if both
tax
these
on it.
companies were in California, the California-based company wouldn't have to charge you for their telephone, for their insurance, for all of that as it relates to the labor. They could choose to either absorb that, or they could choose to charge you some other way, or if you owned it, wholly owned it, you could choose to expense it off. I'm asking what happened. I mean, you're in a fortunate position that doesn't sound as if the department, and maybe I'll go back to and give them an opportunity, as the department really scrutinized the total cost of goods sold to determine if all of those costs were attributed to the actual fabrication labor, and we have no evidence to the contrary that the department's wrong. Other than whatever your testimony is, unless you can present something.
In this particular case, like you stated, if it was two separate companies, that's correct. If it's one company, no, all expenses would be allocable. And I'm looking at this thing here. They keep on going to the first audit. They're not realizing there was a second audit and there was a true subcontract. If you look at this on page 3 of the actual summary here, they only reduced it by $316,000 for all of the cost of goods. On assumption, the first audit, they assumed that it was two distinct companies, okay? And then they said, oh no, it's a subcontractor. So you're saying $316,000 for 5 years is all the profit, all the materials, and all of the labor to install? I don't see it, because the $5 million is what they made for this whole duration of the audit. That is the gross receipts. So I'm not sure where they're getting, if they're throwing the whole cost of goods all as one whole, or how they're coming up with this number. So, like I said, it has gone through many hands. They've had many auditors on this, and that's why we're here today. It's a mess. And again, our stance is still the same. My clients here, they treat the whole thing as one. If it was an LLC like he's stating, yes, 1% owner is almost a disregarded owner.
Did the department look at the income tax returns?
We did. We looked at cost
You
of goods
examined
sold.
them. Did the department find, was there any expenses on the income tax returns? Was there a reasonable relationship between the expenses claimed on the tax returns and the cost of goods sold that would have given you some indication that possibly expenses that were not attributed to cost of goods sold were included in the cost of goods sold as opposed to being expensed out?
there's no indication of our examining that, but I wanted to just reiterate what Mr. Quee had mentioned. We're not taxing all of cost of goods sold. So it's only those three categories that I identified that we're associating with the assembly labor or fabrication labor. So it's the three
You do know that
categories
you-
of
Part of your
cost-related.
testimony was that you picked up all the cost of goods sold and, okay.
Well, I mean, virtually most of it. I mean, because cost of goods sold, 94% of cost of goods sold.
My apologies. Just tell me what is, not, I mean, because it's changed. Your testimony is changing. So, you found three categories. And if you guys want to meet and confer, I'm okay. You found three categories. And of those three categories, you determined that all of their, so tell me what happened again.
Right. Mr. Horry, and I apologize for the
That's okay.
confusion.
That's
So,
okay.
so what Mr. Quee was mentioning, and what I want to reiterate, is that the majority of cost of goods sold do relate to assembly charges and material costs.
How did you
as you would
determine that?
expect for this business. But
How did you
it's-
determine that?
Because we examined what cost of goods sold was on the income tax returns. We compared those
No, there's
totals.
just one number on the income tax returns. You have to go back to the
Right.
source documents to determine that. So
Right.
you examine the source documents that went into the purchase journal, that went into cost of goods sold. How many source documents did you examine?
It's not identified how
It's
many,
not
how many
identified.
source documents. I mean,
So you arbitrarily took a number of source documents, reviewed them, and you can't trace that into the purchase journal. And you can't trace from the purchase journal to the cost of goods sold on the return unless you did a period of time on an actual basis. I
So
mean, you
they-
can
so they would have
extrapolate. I mean, there are a lot of things you can do, but you got to tell me you did it. Otherwise, I can't take that under consideration. From what you're telling me is that you, I don't want to,
So,
Tell me
so,
what you said.
Mr. Hart, we have three categories of manufacturing costs that are related to the work done in Mexico. The
I
three
get that.
categories I identified, we have individual accounts that identify those accounts. Those charges consist of 94% of what the taxpayer is charging as cost of goods sold.
So what you're saying is that in the purchase journal, you didn't use cost of goods sold at all, but in the purchase journal, there are three categories that make up the fabrication, the cost of fabricating, and you just picked up it from the purchase journal.
Well, from the profit and loss statements. The figures that we're looking at come from the profit and loss statements, which are supported by entries in the purchases journal, which are further supported by the purchase invoices. So we're just saying the majority of cost of goods sold relate to charges for materials and for the associated assembly labor that was conducted in Mexico.
Yeah, I don't,
But we're not
All right.
taxing all of cost of goods sold, just those three categories that relate to charges from the maculadora.
well, I'm not necessarily in a position to, and don't believe in redoing the audit from this position. I do want to say, though, that, and it doesn't appear, I do want to say that it appears that the numbers, that it appears that there is some possibility that using the number that you use could include expenses that were not attributed to the fabrication of these items, and that you have not stated that you've done a test or that you've picked it up on an actual basis, the actual cost on an actual basis. Instead, you picked up, from what you're telling me, the profit and cost of goods sold on the profit and loss statement, as opposed to, which may be commingled with other expenses. And if you were to say that you did an examination and you verified that cost of goods sold and profit and loss there were no other expenses included in those numbers that could be attributed to costs that are not associated with fabrication labor, based on your test and your examination. And fortunately, we're going to have an opportunity to kind of, because we're not going to vote on this, to kind of go back and,
We are going to vote on it.
we are, I mean, today?
Yeah, we're voting on it. We're
Oh.
proceeding based on our advice of our counsel.
Okay, well, you have the audit there?
We've got the audit working papers
Can-
here.
can I look at it?
Sure, sure. There's a statement I just wanted to share with you. In the audit work paper comments, they say the accountant claimed that the total expenses per those 3 accounts that I mentioned to be the cost of goods sold for income tax purposes. So, and those are the charges that they're accumulating within the P&L, supported by their purchase records. They haven't indicated to us that those include any other charges, that aren't related to the purchases from the maculadora. And our auditor would have looked for that to just ensure that there weren't utility charges or some other
Not
sundry
necessarily.
charges.
The appellant hasn't presented or testified to the contrary. It just doesn't appear to, it just based on their testimony, it appears that there are a whole lot of expenses that may be non-fabricating expenses, non-fabrication labor, that's included, and it also, given the relationship of the 2 separate entities, they actually could just sell the fabrication, the actual fabrication, at their cost. They don't have to impute a markup on it, and they don't have to recognize a markup on it. And I get if they went to their income tax returns, and they did this, and it was on their income tax returns, they don't have to do it in cost of goods sold in order to reduce their profit and loss. They can expense it and then end up at the same spot as far as their taxable income, their income tax treatment. So, and the fact that we ask a question of a particular party, it's always in how you ask the question, in the detail of the question that you ask. If you're exploring, trying to get at the truth, which is inherently the problem that we're having with this new process, but it is what it is, and we've got to deal with it.
Mr. Horton, if I might add, those were the amounts that were billed by the Mexican corporation to the individual. So that was simply a billed amount. Those are the amounts that showed up in his record. There was no...
Their testimony is they're billing all expenses.
They're billing an amount for the fabrication labor.
That's not their testimony. Their testimony is that they're incurring all expenses associated with that factory, and that's what the billing reflects.
It's an internal audit.
And based on their relationship with the Mexican country, it appears that that's true, that they have to do that. I mean, that's part of the requirement of the Mexican government. So that lends credibility to their testimony that they are assuming all of the expenses of that operation down in Mexico, and that they are paying for all of the expenses of that operation down in Mexico. And so if the department hasn't segregated that out, and they can't say with confidence that all of those expenses, the department, I think you're right, given your position, that you're right to assume, but we've got other evidence now.
I'd just like to add that there is a schedule that is in the file, Schedule R1, that has a bunch of other charges that aren't just fabrication labor. So with that, I think, I'm going to, we've certainly talked this a whole lot, and I think we have a member that's ready for a motion.
Let me try a motion, and then we'll go from there and see if we can just certainly discuss the motion. I would move to grant petition based upon the findings that Maquiladoras is the same ownership as the sole proprietorship, and we would acknowledge this as a Section 40 case, and that it be precedential decision based upon the board's finding.
Presidential?
Yes.
I'll second it, now we can talk about it.
Can I see the audit?
Why are you asking for?
Why are you asking for precedential?
Well, I have no issue with decision being presidential, but
I do. I'm just not sure.
Let me
But I don't-
let me tell you
I don't
why I believe it's
necessarily agree that
presidential.
they're
Let me
separate
speak to the
entities.
motion real quick, and I
Go
can
ahead,
explain.
please.
My reason for making it presidential is because I believe that there may be other taxpayers who are in similar tax situations where they have a relationship with the Maquiladora under the Mexican law and therefore have this requirement. So all we're doing by saying this is that we're setting a standard for other companies who may be in the same situation where they're a sole ownership, like this one, they end up with another business in Mexico, but because of Mexican law, end up with a Mexican partner at 1%. So all I'm saying is this clarifies if similar people are in the same business relationship, then the rationale of sole ownership would be the same.
Can I ask a question?
I
So
can divide the motion if we'd like, if that makes it
Yeah.
easier.
I'd like to divide the
Can
motion.
I ask a question to taxpayers? So what happens if it's not a 1% partner that you have to have?
You
I mean, is that
cannot-
the minimum 1%? Like, what if it's, 51 you guys, 49 someone else?
It could be any percentage.
It doesn't matter.
Yeah, but we put 1% because we own it all
I get
outright.
it.
This way, if they come to harm us, 1%
Right.
does
but-
not do anything.
Right, but could you have said 90%, 10%, and still done it the
Yes,
same way?
yes.
49, 51, 49.
Yes.
So that's my problem with having it a precedential,
Okay,
is
let
the
me just-
percentage
Well,
may
but in that
change,
case,
even
it
though they
wouldn't
could
be.
have the same tax
Okay, let me-
treatment.
let me-
If it was
we can discuss
90/50 or
those
something like
different
that,
issues.
Yeah.
Okay, actually.
then it wouldn't be full ownership like what we're talking about.
Yeah,
The
but
reason
then
why
it would
we
be
are
ownership.
specific 99-1, if it was 59-49, then it is a true bona fide, complete separate entity, because there is two owners, and most of it would be a Mexican corporation. So
Okay,
in our case,
What is it, 98.2%?
Ours is 99-1.
I know, I'm just saying, for another taxpayer that sets it up to be
Oh, I see what you're saying.
98% and 2%, could you
But
still?
there would be no reason for it to do that,
No,
because...
I'm just,
yeah.
I know there's no reason, I'm just asking. Let's say you have a husband and wife
Oh, I see.
that work for you, and you want to have it 98%, and then 1% to husband, 1% to the wife. You could still report it the same way, right?
Technically,
And
yes.
claim the same thing that you're doing, but instead of 99.1. I'm just saying, we're trying to figure out whether we want to use this case as a precedential case moving forward, but my concern is that the percentages could change, so just because it's a sole proprietor having to organize in Mexico, the percentage may change, and therefore,
Right.
I don't want to use
Here-
it as a precedential because the circumstances may
That
change.
could be the case, and so let me just ask appeals real quick. And that is, if indeed the percentages were different, then the facts would be different. Correct? Hey, let me answer. Would that be correct?
You're going to have the same problem. It's a question of degree. Yes, the answer to your question is yes, you'd have different facts. Is 2% sufficiently different? Is 3%
Right, but
sufficiently different?
that would then change it as the precedents would then be based upon the facts of this case, correct? Which is 1%.
Yes.
So the idea of a future decision being greater would not apply to the precedents of this case. Somebody could try to argue it. They could try to argue it, but the fact is, it is different. So that's why, so in my understanding, the issue of the precedents of this case is based upon the facts of this case, which is the 1%. Again, I'd be glad to separate the
I actually
issue.
tend to agree with you, Mr. Runner, that with only having a 1% ownership, well, having 99% ownership really demonstrates to me that they're truly controlling that other entity. And in substance, it is one entity. When you start moving that percentage to 95, 96, the facts do change.
Right.
And
That would be my understanding of the
Yeah.
case, of the facts.
And you could direct us to put language in there to limit it to the facts of the opinion that you're
That would
choosing to
certainly be
publish.
the intent of the motion, is that the facts would be based upon the facts of this case alone.
Exactly. And what is also compelling to me is these other expenses that they are paying over, the housing, the insurance, the vacation, the pre-vacation, all possibly part of this labor cost that was picked up by the department. So if we don't have a second, I will go ahead and second that motion.
I seconded. Or you go ahead. You go ahead. Okay, motion made by Member Runner, seconded by Ms. Stowers. Is there any objection? No.
Well, wait.
Come on. Speak up. We got a motion, we got a second. Are you objecting to the motion and the second? I'd roll with it.
Okay, let me just make a statement here, you know. In any other, I mean, we're faced with a situation where we could have explored this, and appeals is not allowed to supplement the record. We're looking at the evidence as it presented here. I'm looking at the testimonies that's presented here, and based on the facts here, I'm having a real challenge of objecting to this motion. I mean, so, I don't necessarily believe that, anyway. All right, no, I don't have any objection.
Is there any objection to the motion? Okay, such will be the order. Thank you.
Thank you. Thank you very much.
Thank you very much.
Okay. There is a lot. I happen to know that they built everything in there. And you pay one big lump sum.
Yeah, they could get there a number of different ways if they
Yeah,
wanted to.
I
They could fix
used to
this
actually
way
do
they
the
would.
billings and pay the bills
Yep,
to
we're on mic.
a company named Calvin. I clicked it on.
Madam Chair, if I may say, just
Sure,
for the department, the auditor actually did allow, I mean, the auditor made an adjustment of 45% on one schedule, picked up the actual on another schedule, which created a whole nother bit of question as I examined the audit. So there was some consideration by the auditor that maybe these numbers did include more than they should have, based on the schedules themselves and how they treated it.
Okay, thank you. Ms. Richmond, next item, please.
Our next hearing for today is item C5, Tobacco and Gifts, Inc. Please come forward.
Been through the job. Did the job.
The whole invoice number. Okay, C5. Oh, that we go back again here.
Good morning.
All righty, I think we need to read our statement again. Are we going to, we're going to continue on with this method of disclosure?
Can I say ditto? Would that suffice, Ms., our chief counsel for the day? Can I say ditto? Or?
I think you have to make this, she told us
All
yesterday
right,
we had
all
to
right.
make the statement for the
Okay,
record.
Thank you. I got it.
I'd like to ask the board members, because of the change in the law, whether or not they've had any communications, oral or written, with either the parties in the matter before them that they know or suspect have not been provided to the other side, and could you disclose those at this time?
Started that and worked down?
Okay,
Okay.
yeah, go
I
ahead,
have not,
whoever's ready.
Yvette Stowers, I have not had any communication with the petitioner or the department on this matter.
Staff, I don't believe we communicated on this, but let me just read my statement. I don't have anything saying I did. Okay, in this matter of C5, Tobacco and Gifts, Inc., to the best of my recollection, we disclosed that we don't believe we've had, but we may have had conversations with the tax department and with the appellant. We would only have discussed the issues presented in the briefing record. We do not believe the law imposes a disclosure requirement prior to July 1, 2017 operative date of the provisions in AB 102. However, we hereby satisfy our ex parte disclosure burden to the extent one exists.
I have not had conversation or communications, oral or written, with this taxpayer nor the department since July 1st, when I believe this law took effect, and I believe that the conversations that may or may not have taken place prior to July 1st are applicable under the law. In this case, I know that we have not had any conversations even before July 1st with this taxpayer.
And to the best of my knowledge, myself or my staff has not had any communication with the taxpayers or the agency on this case.
To the best of my knowledge, I nor my staff have had any communication with the taxpayer, department, or appeals on this matter.
And I'd like to ask the department whether or not they have submitted any oral or written communications to the board members that were not shared with the other side.
The department has not made any communications with the board members regarding this appeal.
I'd like to ask the taxpayers if you've had any communications with the board members prior to this time.
No.
Okay, thank you. Mr. Anjija, or?
Good afternoon, Madam Chair Harkey and board members. I'm Ramona Verigi on behalf of the Appeals Division. The appeal before you involves 3 unresolved issues, which are whether further adjustments are warranted to the unreported taxable sales, whether adjustments are warranted to the unreported taxable cigarette rebates, and whether petitioner was negligent.
Thank you. Welcome to the Board of Equalization. To the appellants, you will have 10 minutes to explain your case, and then we will go to the department, who will also get 10 minutes. Then you will get 5 minutes on rebuttal. So please introduce yourself for the record and begin.
Good afternoon. My name is William Shi, and I'm a CPA representing Tobacco and Gift Corporation for this auditing issue. Sit beside me is Miss Liu Zhiming. She is the owner and manager of the company. So we are glad to come here.
Is that all you explain your case?
So you want to continue just?
Yes, this is your turn.
Okay, good.
Please.
All right, yes. This is the auditing back to 2013. The auditing generated in 2013. The auditing period is from 2010 all the way to the end of 2012, which is 3 years period. So basically, we have a dispute or disagreement with the auditor side, mainly focus on the source of documentations. The auditor, they use the so-called purchase method to determine the company's sales. They got a CD, which is contained 3 years purchase from the SAM Club. So the SAM Club provide a CD to them, which according to the previous auditor, I believe the first name is Joseph. He calculated and saying that for the 3 years total purchase from Sam's Club is about like $900,000, which is way higher than my client record. Okay, so on the other hand, talking about Sam's Club, the source of documents, Miss Liu did go to the Sam's Club to request the same information. However, according to Ms. Liu, and the SAM Club saying that they only can provide past 2 years. So when she went there to ask for the data, the SAM's Club gave her the complete 2012 data and partially 2011 and partially 2013. So basically, total is about like 24 months data. And after we were heard that Sam's Club has a CD providing to the auditor, Joseph, because Joseph told us, when he, visit, the store and having a meeting with us. So we did, Ms. Liu did, go to the Sam Club to try to get the same information. However, she couldn't. And then the Sam Club clearly told them that we only have 2 years. So now we told Joseph, and then we request the CD, and then so that we can compare the CD data to the information we got. And the auditor agreed to provide us. However, he never gave us. Okay. So then, after a certain time period, the state, the board of, at that time, I think it's still called Board of Equalization, BOE, issued the determination. Okay. So then we asked for a review, or we do the appeal process. And then in the appeal process, we were told the auditor left the board already, and we were told that we asked for the CD, and then in the meeting, the representative, I believe the name is one is Elsa, and the other one is Jason. They agreed that they will find a CD for us. However, we waited and waited, and eventually we still have not get the CD. Instead, we got some Excel spreadsheets, and they told us this, is the information come from CD, but they didn't say, no, this is a CD. No, actually, I believe they didn't say so. And even, the appeal department, Mary, I think Mary Wang, when in her report also indicate, as of today, the department still has not provide a CD. So without a CD, it's really hard for us to do some comparison. But from our side, okay, this is the information we got from Sam's Club, and we also provide this one to the department. And the department said that, we are going to study this one, and we are going to do some comparison, and then eventually we are going to get you back. However, as I know, we never see any comparison report, between our one and theirs. Okay, but I do did a research on this report. If your respectful board members are interested, I can show you. So according to report, I have complete 2012, monthly, this go by a monthly report, okay? And each line item and also the total. But there is a confusion here. I think maybe that could cause the original auditor confused. Is in representing the total of the monthly purchase, the numbers kind of are weird, you know. So for instance, you know, I'm looking at, 2012, July 30, you know, report. So the total is like a 55, you know, comma or dot, and 001016 dot, period. And then 68 cents. Looks like it's a big number, you know. But if you carefully look at it, and then you can see the actual total amount in July 2012 should be $1,016.68. So I have a suspicion is that maybe the auditor is just read the number and then misunderstand the, you know, the digit, so that he add them all together, got like 900 something, 900,000, 951,000, you know, big amount. So, but when I take the total monthly, which is around $1,000, and in April 2012, it's about $932. So if you add them together, the total purchase in 2012 is about like $20,000 or something like that, you know. So it's not the one as the auditor concluded, which is in 2012, the total purchase is $40,996. Okay. So unfortunately, you know, we haven't got the CD. Okay. You know, to be honest with you, today my discussion is focused on CD. Okay. My thinking is the department should have done better job on this issue. Okay. First of all, they should have keep a good file maintenance records for our auditing file. Okay. So if Joseph, he left something, it should be kept in well place.
Okay, your time is up. You will have 5 minutes back on rebuttal, so now we'll turn to the department, and please introduce yourself for the record.
Good afternoon, Chairwoman Harkey and members. My name is Scott Lambert. I'll be representing the California Department of Tax and Fee Administration today. To my right is Kevin Hanks, also with the California Department of Tax and Fee Administration, and to Mr. Hanks' right is Stephen Smith with the CD TFA Legal Division. In this particular case, the taxpayer operates a smoke shop that sells cigarettes, tobacco. They also sell other items such as water pipes, glass pipes, other bongs, and things associated with the cigarette tobacco industry. They also sell some miscellaneous gift items as well. Upon audit, the taxpayer provided 2 years of income tax returns. They provided some Sam's Club purchase invoices, some manual sales journals, which were numbers that they wrote down for sales. There were no cash register tapes. There was no detail information as to where the numbers arrived at. They also provided incomplete bank statements. During the audit, the taxpayer told the auditor that the only supplier was Sam's Club. Based on the fact that a lot of the cash was not deposited into the bank account, which was from a review of the bank statements that were provided. The low markup when comparing, or actually in this case, it was a high markup when they first looked at it, which was comparing what was reported to the amount of cost of goods sold on the income tax returns, which was for the 2 years only $9,000. But on the purchase invoices themselves, it was only $115,000 in purchases for the 3-year period. That works out to less than $40,000 in purchases for a year. So the auditor contacted Sam's Club and obtained a listing of the purchases. There is no evidence in the file that a CD was provided. There is evidence that an email was provided that contained an Excel spreadsheet with all the detail of the purchases that the taxpayer made by their customer number with Sam's Club. That information was then used to establish the audit liability. So a shelf test was conducted. It showed a markup of about 7.5% just on cigarettes. So ultimately what happened was the purchases were obtained less than 1% deduction for pilferage. That amount was then marked up 7.5%, and that amount was compared to what was reported, and there was a difference of $868,000. Just to reiterate, there was no evidence of CD. The detail information that was on the Excel spreadsheet was provided to the taxpayer. The taxpayer did obtain their own information from Sam's Club. The department asked the taxpayer to go through and analyze that. They did not do that. The information was provided at the appeals conference. The appeals conference holder traced the purchases from the Sam's Club file obtained from the taxpayer to the Sam's Club information obtained by the department. Didn't notice any differences between the two for the amounts that were traced in. So that was in regards to the sale of just cigarettes, and so that's the amount that we came up with. There was also unreported rebates, cigarette rebates. That information was obtained directly from one of their suppliers, Philip Morris, and that is an actual figure. It's $35,680. That was also not reported and is included in this audit. A negligence penalty was also added in this on this audit. This is the taxpayer's first audit. Nevertheless, the department does not believe that the taxpayer could honestly believe that what they were reporting was the proper amount of tax. When you look at the amount of purchases from just Sam's Club, it's $951,000. The amount that was reported by the taxpayer was $145,000. There's a 600% of error. Also, the department has provided an exhibit. I believe everyone's been provided with that. The first page is the compliance inspection report. It's dated September 28th, 2011. This is almost in the middle of the audit period, so our ID unit went out and conducted an inspection. What you'll see down on the left-hand side, under cigarette suppliers, it lists Sam's Club and another supplier, Chi Wan International. This is evidence that the taxpayer had more than just one cigarette supplier. And I'll just point out, and the department's not making an argument for a higher liability, but what we'll point out is that these purchases are not included in the audit liability, based on the fact that the taxpayer's husband told staff that only they had purchases or they only purchased cigarettes from Sam's Club. If you go to the back, under the investigative statement of facts, in the second paragraph towards the bottom, up about the third, and I'll just read here what was said. Frias, which is the investigator, asked Lynn to provide the last 12 months of cigarette and tobacco purchase invoices as required by 71. Lynn provided Frias with valid cigarette and tobacco invoices for the last 12 months. The invoices were from Mox Inc., USA Tobacco Company, Chi-Wan International, and Sam's Club. Lynn stated he purchased cigarettes twice a week. The invoices that were provided to the department were only 63 for the audit period. That is well less than 2 times a week. If it was 2 times a week for the audit period, it should have been 300 purchases. And I'd also point out that at the time of this inspection, the taxpayer had the invoices for these suppliers, did not provide them to the department, and then was directed for them to maintain the purchase invoices, which they did in another inspection that provided them in 2013, but they did not provide this to the auditor for this audit. So accordingly, the penalty was applied, and the department believes that the penalty is applicable in this case. For those reasons, the department concurs with the Appeals Division decision and recommendation.
Thank you very much. Okay, you have 5 minutes on rebuttal.
Okay. There's one thing I want to your department to clarify is he mentioned that the owner's husband, Mr. Ling, you had a kind of a conversation, communication with him. Could you tell me when it happened, and then it's regarding which specific time period regarding the alternative vendors or additional vendors? Could you tell us when? And as I know, okay, maybe I can wait for the other party's answer, reply?
What exactly are you asking me?
Clarify, because the department mentioned that they conduct investigation on the husband of the manager, and the husband told them they, in addition to Sam's Club, they also purchase from other source or something like that. And I just want to know this information is generated in which year or for which year purchase. Yes, I should say they had more vendors, but this is not happened back to 2010 and 2012, 3 years period. So I do want to clarify this part from department right now.
Okay, we can clarify that. Are you finished with your 3 minutes? You've got 3 more
Yes.
minutes. Do you want to
Okay.
continue?
And also, I still want to focus on the CD, okay? Sounds like the department 100% deny there is a exist of the CD appear, okay? However, from the report, appealing report, the department say the other way. Let me read for you, okay? Which is a contradict for their current explanation. Okay, I just find somewhere. Okay, so let me, okay, so I try to find the English version, but now I have the Chinese version. The department guess, okay, Sam's Club could provide, the purchase CD information to the auditor, So, let me see. I need to get the original, stuff somewhere. Okay, anyway, since the time is short, my opinion is, my point is this, okay? Even for the department at that time, in the appeal, in an appeal meeting, they didn't deny that there is an existence of CD, but now they completely denied it, okay? So this is really, we feel kind of a surprise, okay? And I will strongly suggest Sam's Club still there. They open, weekly or whatever. We need to go there. Both parties need to go there to find out what exactly going on. Okay? Yeah. I have no any other specific opposing or comments on the other issues, but of course, I just want to add one is regarding the markup. 7.64%. The manager told me that the Joseph went there, and then at that time it's already 2013. However, he used the 2013 markup to evaluate the purchase during the 3 years period from 2010 to 2012, which is not reasonable. But I'm focusing on CD today. I'm done.
Okay, let me just go back to the department, and if you would respond to the initial question of the appellant.
Sure. The question is where the information came from my testimony that the taxpayer's husband provided this information to us. There is an investigative statement of facts that I've provided as an exhibit. It's the last 3 pages of the exhibit, and it is signed by the inspector, which is dated October 17th of 2011. And what I read out of there is specifically from that report, verbatim, and it says that the taxpayer had these other suppliers, and this is dated, the inspection was dated in September of 2011. The audit period is for the years 10, 11, and 12, so it's almost in the middle of the period. And if you look at the, and it's really a side issue, but if you look at the pages in the exhibit before the inspection report, what you'll see is a tobacco inventory sheet, and this is from the this is from the taxpayer's purchase invoices. So if you look on here, it'll have distribution or wholesaler name towards the top. It's on the almost the middle to the right-hand side. On the one page, it has Max Inc., which is, Mock Inc., which is a tobacco supplier. There's also another supplier name on there, JR Tobacco, which was actually the tobacco that was seized in this inspection, but that's a supplier of tobacco. The report also mentions Humidor, where other tobacco products such as cigars were held. There is no evidence that the taxpayer was purchasing those types of items from Sam's Club based on the list that we received from Sam's Club. So there is also, which I did not provide, but it is a citation that was issued to the taxpayer, and they're given that at the time of the inspection, which basically says you had, in this particular case, you had untaxed tobacco, and I believe there was another issue, and I don't recall off the top of my head exactly what it was, but they get that, I guess you'd call it a ticket. I believe there's another word for it, but a citation is the other word for it. They received the citation, and the taxpayers provided with that and all these reports. So this is not a surprise to the taxpayer. They were well aware of this at the time of the inspection.
Okay, thank you. Now, we'll open it up to members. Any questions? Member Horton.
Thank you, Madam Chair. The department picked up rebates, cigarette rebates.
That's correct.
What was that based on?
That was based on, we noticed on the income tax returns that there was some other income. It was $50-something thousand on the income tax returns. So that piqued our interest, and we contacted one of their tobacco, well, I shouldn't say one of their suppliers, one of the manufacturers of the cigarettes that they sell, contacted them directly, which was Philip Morris, and they provided us with the exact rebates the taxpayer received for the 3 years of the audit period.
Did the department review the actual agreement between Philip Morris and the taxpayer that indicated that these rebates were buy-downs?
The taxpayer did not provide those. The department requested to see the contracts, and they weren't provided. So an assumption was made based on the law that these are subject to tax until proven otherwise.
Question of the taxpayer: did you have an agreement with Philip Morris relative to the rebates?
Can I translate your question to my client?
Sure. You're translating?
Yeah, she couldn't understand English, so maybe I can
Madam
translate.
Chair, what do you want to do with that?
Let's finish the case and see.
Okay.
We don't have counsel.
If you could, at this point, could you translate into the mic so that we could be part of the record? Just
speak into the mic when you're translating to
Oh.
her. We want to hear everything
Oh, sure, of
that's
course,
being
yeah.
said.
Do you have the question? 他问你的问题是 Do you have any agreement with Philip Morris regarding the rebate, right?
Yes.
你跟这个烟草公司那个 Philip Morris 有没有这个一种协议，就是回扣的协议？有没有？
有。
Yes. Maybe I can ask, is a written agreement?
Written.
是不是一种书面协议还是口头协议？
那个就是他那个。
Ask her to speak into the microphone, please.
Yeah.
Now, I'm not asking if she received the rebate. I'm asking if she had a contractual relationship with Philip Morris, a document of some sort.
有没有一种签约式的那种回扣的合约？
因为那个柜台那个货架都是他们公司提供的，所以说你必须得按照就是他们公司的操作去做。
那么有没有合约呢？
合约没有正式签，没有签过那种，算是有吧？
没有正式签署的合约。
对你反正等于加入他们公司以后，他提供你货架以后，就是他们公司有什么就是优惠就会给你。
Yeah, according to her, there is no formal written contract.
All right. So how did the department come to that conclusion? They're purchasing from Sam's Club.
That's correct.
And so the department determined if anyone can walk in there and get the same discount? I mean, if you go into Sam's Club, they have these notices that you can get a rebate, but you got to fill out this form and get a rebate. Anyone can get it. Whoever purchased the merchandise can get it. So that's not necessarily, we can't conclude that that's not just an advertising, marketing on the part. It's not a buy-down. The question of the appellate, as a result of these rebates, did you reduce the selling price of the product to your customers? I mean, well, we'll strike that. Were you obligated to reduce your selling price in proportion to the rebate?
因为给你
Speak in
回
the
扣的
mic,
原
sir.
因，你是不是
Sir,
Yeah.
bring your mic
因
closer.
为回扣的原因，你是不是相应的根据那个 Philip Morris 烟草公司的要求，降低你的销售价格？
没有。
是吧？你
因为是这样，因为是那个 我在Sam我买50块吧，我还卖50块，就是我没有加价。那个，比方他给我的rebate一条是2毛钱到7毛5，就是我不加价的，就是他要求我就是说，我买的是50块，我还要卖50块。他给我的rebate就是，比方说有了一条是7毛5，有了一条是2毛之间不等。
Well, I withdraw the question.
Yes.
You don't have to answer.
Let him.
She answered, I'm sorry, should I translate?
Yeah.
Or answer your question? Yes. Basically, it's not reduce the price, but actually it's a reduced price because Philip Morris sell, for instance, $50 a bar, but ask her to sell $50, same price as she purchased. However, the Philip Morris will give her maybe 20 cents rebate, things like that.
I don't, why is that taxable, Department?
Yeah, the way it works is, these are third-party transactions. So what you'll do is you go to someone other than the manufacturer, you purchase from them, you sell to customers that come in to purchase, and the agreement is that you sell to those customers at a reduced price.
There is no agreement. They're saying they didn't sell it. You have no evidence that they did.
We do have evidence that...
They reduced the price?
Well, we have evidence that they received an amount from Philip Morris.
That's not the question. The question is, do you have evidence that there's an agreement, that these rebates are, that they are buy-downs and they are obligated to sell the product for a lower price? Their testimony is, they sold it at the regular price. They got a good deal. They sold it at the price they sell it for. Based on the evidence that we have, any consumer can go in there. A non-retailer could go in and buy a huge volume and get this rebate. This rebate is not isolated or specific to this retailer. So that in and of itself, there's no contractual relationship, no requirement that they reduce the price. At least I haven't seen any evidence. The rebate could be for advertising. I mean, they could just be reducing the actual cost to sell the product. I mean, the rebate could be a discount for the most part.
Right. In this particular case, the taxpayer received an amount of money from Philip Morris that's been confirmed with Philip Morris. The department has asked the taxpayer to provide the contract between them and Philip Morris. That has not been provided, and therefore, the way the rules work, and I believe it's section 6012.
6012. No, I get it. Let me ask Mr. Njiju. Just, I mean, I understand 6012, 6006, and 5. I get it. But it appears to me that this is a discount that anybody can get. You can walk into Sam's Club and you can receive this rebate, which is a discount, and you don't have to reduce your price, you don't have to do anything. You have no agreement between the parties that this is anything other than a discount.
So Regulation 1671.1 is directly on point and says that it's rebuttably presumed that the rebate received in this instance is for the dollar-for-dollar reduction in the selling price and constitutes gross receipts, and then puts the burden on the taxpayer to come up with the agreement to show that it was for something other than a refund of the purchase, or a rebate, taxable rebate. So the taxpayer would have to give you the written agreement to show that it was for advertising or some other promotion not related to a reduction of a selling price, and that's expressly in the regulation.
But the key to the regulation is rebuttable. In the testimony here, which, quite frankly, I thought they were going to say something different, but they didn't. The testimony here is that they don't have an agreement with Philip Morris. It makes sense that they don't have agreement with Philip Morris because they're not buying from Philip Morris. They're just buying from Sam's Club, and they're going and they're taking the. Well, I don't want to put words in their mouth. How do you receive that rebate? Is it automatic, or Philip Morris do you have to send a form in? When you go in and buy from Sam's Club, is there a document that you have to fill out to get the rebate, just like any other customer?
Yeah，你那个要收那个隧道的回扣的时候，你要不要填一个什么表格去收到的
不用。
？No form to fill in.
Let me interject here. What I heard in the testimony was that she paid Sam's Club for $50 and sold it for $50 because Philip Morris gave them 29 cents. And so that's a taxable rebate for reducing the price, as I heard the testimony. So I just wanted to interject that. I appreciate the effort
No,
on that.
she
but that's-
couldn't have bought it for $50 and sold it for $50.
If she's getting 29 cents back, or 20,
Is that-
whatever
is
it
that
is
what
back.
happened?
Yeah,
That's the
that's
way
Your
it works.
profit is 29 cents?
not
Well-
29 cents, but the 29 cents a pack, or whatever it is that they sell. Sold $50, sold for $50.
There's all kinds of agreements that, I mean, there's no standard agreement that
No, I
they
get
have,
it.
so it,
But, Madam Chair, if I may, the chairwoman has indicated, your testimony is that you purchased partners, I guess a carton? Help me?
Whatever he
Purchased
made
carton from the
purchases. You made
from the
purchases
Sam's
for
Club.
$1, for, let's say $1. You made a purchase for
No,
$10.
let's let them testify.
But you're asking a question.
You purchased product for $50, and you sold it for $50
yes.
less 29 cents because of your rebate. Is
Or
that,
less $5, or less $10.
is that,
Sold it for the
is that
same
what happened?
price.
Yeah, as Ms.
not
Liu
what I
told
said.
me, if you
Where you got
they
29
purchased
cents.
$50,
Give 'em
and then
29
they
cents.
sold $50. They cannot sold higher than $50. And, the Philip Morris gave them 20 cents, maybe more 20 cents.
Per
rebate.
pack?
But let me verify one thing.
Why don't we do
他这
this?
个 20 cents
Why don't-
是怎么给你的？怎么给你法的？
那个给他了，有那个银行呢，给他一个银行账号嘛，他直接吞的是吞到我的银行
他就把这
账号上，
20 cents 就打到你账号去是吧？
2毛到7毛5。
Yeah.
But the-
So they just provide a banker's account to the Philip Morris, and then the Philip Morris will, just transfer 20 cents to their account. That's all.
Okay.
There is no written contract. There is no form to fill in.
I get it. Maybe the department can respond. Did the department observe that they were discounting the sell proportion to the rebates they received?
that's my understanding based on when they conducted the shelf test. That the cigarettes that they were selling were, from Philip Morris, the ones that qualified, were sold at the discounted rate.
The same rate as the rebate? It wasn't just arbitrarily selling it for less?
That I can't say. I don't know what amount that they were selling it for. I just know that when I read the audit report, that it said that the cigarettes where the discounts were taken into account when they did the shelf test, which would be the time that they would see that, because there is no evidence before that during the audit period. So from 10, 11, and 12, there are no cash register tapes, and there's no way to go back to verify what it was being sold for.
At the risk of being redundant, you have no obligation to reduce your price? No contract that you know of that you can present?
I'm sorry, could you
You
say
have
again?
no contract
Apologize.
with Philip Morris at all?
No contract. Mhm.
All right, that's...
Thank you. Let me interject here. What the testimony was, and it may be a bit construed, is that you paid Sam Club $50 and you sold for $50. And because Philip Morris gave you 29 cents, I'm assuming per pack. Okay, so you're shaking your head yes. So that's a taxable rebate for reducing the price, because you're getting, in essence, your profit from Philip Morris. So I just want to circle back with that. No, excuse me, I have the floor. My big concern right now is with the Sam's Club invoices. I have that the petitioner provided purchase invoices for 63 different days during the audit period, and the purchase amounts on those invoices are consistent with the purchase amounts obtained by Sam's Club for those same 63 days. But unauthorized purchases, you are claiming, are for 503 different days during the audit period. We have a sheet here where, and this sheet just goes from, I had my staff prepare a sheet from 10/3/2012 to 12/27/2012, so that's roughly 2 months. And you're only, there's a lot of purchases from Sam's Club on that Sam's Club is reporting, or we verified many of them, but you're only showing 2, which, how do you explain that? I know you're talking about a CD or lack of a CD, but how do you explain that all these purchases were Sam's Club's just reporting them improperly, or what's your claim?
Pardon me, which period do you mention? Is it 2011 or 2012?
Let me see. I think it's the entire, it's the audit, it's the audit period. It's the entire audit period. So it says 63 different days during the audit period, the invoices that you provided. And the purchase amounts for those invoices are lining up with what Sam's Club is reporting, the information we received from Sam's Club for 63 days. But then you're claiming that these other invoices from Sam's Club are not yours, or are not hers, not the appellant's. And so 503 different days during the audit period are not of the appellants, but 63 are that tie right in. How do you explain that?
Yeah, there was a period that they lost their Sam's Club card, and so that might, during that period might be used by somebody else, and then they make some purchase or consumption. That's why, Ms. Liu also read the Sam's Club, report, and then they couldn't recognize these purchases made by them. So they could have something like that, this, let me ask her, is how long the period? 你那个丢失那个卡的话，大概是多长时间的事情啊？大概？
发现了，好像因为以前进货都是我一个人，后来我老公那个丢掉了以后，我觉得
就讲多长时间
吧？大概有5到6个月
Yeah,
才发
about
现。
5 to 6 months,
5 to 6 months, she claims the card was lost.
你有没有去报失啊？
因为当时没有发现，后来发现了才去报失。
She didn't at that time because the car was lost. Was her husband's car. They have 2 cars. Each one have one, but her husband didn't realize until maybe 5 months later. Yeah.
Okay, back to the department. How do you verify Sam's Club's purchases?
We contacted Sam's Club, and they provided us with an Excel spreadsheet that contained all the purchases that had them listed by the different products. I'll point out that the purchases from Sam's Club remains fairly consistent from year to year. In 2010, there were $291,000. In 2011, there was $319,000. And in 2012, there was $341,000 in purchases. So the purchases stayed relatively consistent. And I think it should be pointed out to to determine whether the figures that we come up with are reasonable or not, the taxpayer is only receiving about a 7.5% markup on these cigarette sales. So you figure when you take a look at their purchases and you figure out what their gross profit is, it's not enough to sustain this business, even with what we've come up with. Because even if you're looking at $340,000, you're looking at maybe $25,000 in profit for a year, which works out to maybe $2,000 a month, and that's with all your overhead expenses and other things.
Can I explain?
Okay. Thank you.
Can I explain?
Yeah, go ahead, explain.
Okay. Actually, I've forgotten to clarify their business. Actually, their main business is not retail of cigarettes. Okay. Their main business is lottery, state lottery dealer. They sell different types of lotteries, federal, states, bunch of it. Okay, so that's their main business. Okay,
Thank you.
so cigarettes part is pretty much even. They are not making money solely by cigarettes part. So I have to clarify that part.
Thank you. Member Ma?
Thank you. To the department, when you reviewed their tax returns, 2 years of income tax returns, compared with their bank statements, were they in line or not in line?
Well, we had the problem with the problem with doing that, we didn't have all the bank statements. And I don't...
How many bank statements did you have? How many bank statements?
I'd have to go through and take a look at it. I don't know off the top of my head. I'd have to take a look at this, but there's another problem in that as well, is that the cash is not being deposited into the bank. So the fact that even if you had all the bank statements, you still have the issue of cash being deposited, and so...
And how do you know there's no cash? There's no cash deposits?
Well, one of the issues is the bank only allowed them to deposit $5,000 a month of cash into the bank, or else there was a penalty of, I believe, 1% that they would charge, and so you only saw a small amount going into it. And the other thing I would point out is that they were making purchases of their inventory with cash when they were going to Sam's Club. So there didn't appear to be a question that...
And how much did they show on their income tax returns?
As far as sales?
Yeah, revenues.
In 2010, it was $94,000, and in 2011, $54,000. That was gross receipts.
On their tax returns from their company, right? So they're sole proprietors, or I guess it's a corporation, S-corp?
This is the corporation's tax return, not the individual.
Corporation's tax return.
Yes.
Okay.
Excuse me, can I clarify in case I've forgotten,
Yeah.
Regarding the bank statement, my client clearly said we provide, of course, I also remember, all 3 years monthly bank statement, no 1 month missing. I need to clarify that, okay? And also regarding the business, they are small business. They are mom and pop business.
Right.
They don't hire any employees,
Right.
okay?
So her husband, Patrick runs
yes.
the company. Yeah, I mean, I went through their Yelp reviews. They got very good Yelp reviews, by the way. Very, very good. Very positive. People like coming. So, yeah, I can verify that the husband is in the business every day.
Yes. They are just
And who-
two-person
I get it.
business, and they know they almost like a 24/7 things like that. They don't have a weekend. Every day work very hard from morning 8 o'clock to 7 o'clock in the evening. Every day.
Open 7 days a week?
7 days a week, yes.
And what are the hours?
No holiday, no Christmas, no
What are the hours?
Thanksgiving. Huh?
What are the hours?
From morning is 8点钟吧. Yeah, I think 12 hours.
Okay.
Yeah, 12 hours. Every day, every day.
So who does
No
the purchasing?
vacation.
Who does the purchasing? Someone goes to Sam's Club?
Mostly, I think Miss Liu, she go to Sam's Club, right? Is that right? 你丈夫去不去？主要是你自己吧，只要是你自己啊。
他几乎不去，都
Yeah,
是我一个人。
he almost stay in at the store, and they for the lunch for dinner they just bought like fast food, you know. Very hard, you know, very hard. So they are S corporation, but they are supervisorship size. Okay. So that's why they don't even have a modern adding machine to do all these electrical calculation. They just very original. Just write down each time sales. They just write down one amount. Okay.
And so, Mr. Shi, do you prepare their tax returns?
Yes, I do.
And their sales tax returns?
Yes.
How long have you been their CPA?
I've been about about 18 years CPA. Yeah. I received my CPA
So
license.
since they opened the company?
Oh, no. They are let me ask. 你这个生意是多长时间了？什么时候开始的
02年吧。
2002 they started.
Okay, it shows incorporated April 2005, but that's okay. So they've been open like 10
they
years?
didn't incorporate until 2005, yes.
Okay, and how long have you been their CPA?
2005, I guess. Yeah, 2005.
Oh, you've been their CPA since 2005? You?
Yes. Oh, yeah, for me, yes.
You personally have been signing their tax returns
Yes.
and filing their sales tax returns?
Yes.
Okay. And,
Since 2005, yes.
okay, and how do you get the information from them on the sales each month?
They just gave me their so-called journal, daily journal, which is kind of just, how much they sold one bar, how much one bar. But they gave me a total number, monthly total number. And then and then based on that, I prepared the sales tax return. And then also for the income tax return, I get it from I collect the bank statement and also verify the sales tax report, things like that.
Okay, because there seems to be like a big variation between the department's number of 900,000 and reported taxable sales of 145,000 per the taxpayer and their CPA.
Yeah, just to point out that our numbers for 3 years and the tax returns are for 2 years, but yeah, there is a large difference between the two.
Yeah, so I'm looking at this report, which is the only report we got from Sam's Club. So from that one...
Can I see that? We don't have that report.
Sure, yeah. The yellow color highlighted is something is weird, because the number will misleading people. Looks like, a couple $100,000, but actually only 1,000, because like a 5 there is a dot, and then after 20 and then a get number again. So could misleading people.
And how much is the rent each month?
Rent, I can't remember. 你租金是多少钱？月租？
租金是他那个时候才
商店那个时候就讲那时候
1600块钱。
Yeah, 1,600 a month. But keep in mind, their main business is lottery. They make money from there.
你说我了，告诉他我 Super Lotto 是在全加州这么多家是排行前25名的，所以我主要的来源经济是靠 Super
The
Lotto。
lottery and Super Lotto, they ranked top 25 in all California state seller. Super Lotto seller, top 25. So that's their major business, which is not as department said, you know. Actually, department said they sold like a water pipe, something like that. This thing is just, I know. So if you go to their store, a lot of dust on the product, and nobody purchased that. Okay, so a little did get gifts, no sales.
But their income tax returns in 2010 showed 94,000 in revenues.
94,000 in revenues, and in 2011,
54.
$54,000. For rents, it shows for 2010, $38,000 for both years, for 2010 and 2011.
$38,000, well, each year is $19,000.
No, each year is 38,000.
Well, based on...
It's 76,000 for both years.
I don't know what to say.
Any more questions?
I don't know, I mean, like, without the Sam's Club, you know, verifying why there's discrepancy, I mean, that's where all the numbers are coming from, right, from the Sam's Club? Okay, so, I'm sorry, I missed it. Did the auditor have a CD? How did they get the Sam's Club?
Right, it was
Numbers.
on, there is an Excel spreadsheet from Sam's Club that was provided.
Can I see that? Do you have it?
Pardon me?
Do you have it in your file?
It's in the, I do not have it with me personally. It is in the department's electronic audit file. There are, I believe, two different files that are in there.
Madam Chair, are you finished with that?
Okay,
Yeah.
hold on. So then, to the accountant, this looks like Sam's Club gave you a...
That's the only one.
This is-
They only have one account with Sam's Club, which is, you can see, 6614, which right after the years and month, you know. So from there, so I don't know what they are talking about, Excel spreadsheet. I did receive the Excel spreadsheet, but I just doubt it if it's really come from Sam's Club, or maybe is the former auditor's own worksheet. So this is a question.
Yeah, so you mentioned a CD. Why do you think there's a CD?
We asked for a CD
I know,
from day one.
How do you know there's a CD? How do you
The
know?
audit told us. We both here, he said, I got a CD, and then the CD report is 951,000. So we just got surprised. And then I said, can you give us the CD? He said, okay, I will give you. And later on, no CD provided at all.
Well, I think there's a large discrepancy in this number.
Yeah, I agree.
I don't know, is there a CD?
There is, well, first of all, I'll go through them. The auditor is no longer with the department. It's unsure what he said, but as far as the evidence that we have, so whether you referred to a electronic file as a CD, I don't know, I guess that's possible, but there is no evidence there's a CD, but we have the Excel spreadsheet with the details. So it's not just a number for a month. It is each transaction that they have, and then the detail from each of those transactions. So if you bought 100 cartons or whatever it was that you purchased from Sam's Club, each one of those is going to be listed on there. So you'll have the Marlboro,
Has anyone seen this?
No, that's what I was going to comment. You're saying that it's your electronic file.
Yes.
I just say, I don't have access to your audit files, your electronic audit files, and it's not part of the exhibit that was part of the DNR.
Right. Well, and this is, it's in the audit file. I guess what I would point out is that appeals has the ability to look at that and has looked at it and has traced the taxpayers' figures that they obtained from Sam's Club into that file. And the department can provide that, but it's a large document because it's a lot of purchases.
We
My
have
notes
seen,
say
we have
that,
seen these before.
My notes say that someone from Walmart stores, Brian Henley, provided the download, and it appears that it was provided on February 14th, 2014.
That's correct.
Is it the department's practice to keep a copy of the original email that came through with the download?
It is.
And did you guys keep a copy within your files?
I believe so. I can't recall off the top of my head. I have seen the file myself, the electronic file, and they do refer to that email at the date, and I'd have to make the assumption from that we do have that email from him.
Is it your practice also to secure the file so you can have your original with no changes made to it, so that if we were to have a copy of this spreadsheet, we can have confidence that nothing was changed from it?
That's my understanding.
Ms. Dowers, I think another element here, too, is that the Appeals Division recommended that the taxpayer take that summary that's included in the audit work papers, take that to Sam's Club and have them actually go over the listing and just, make it satisfactory in their mind that those purchases actually relate to their purchases under that membership card. I'm not certain if they did that, but that was encouraged.
You guys did receive that spreadsheet then, that long spreadsheet, to the taxpayer representative over here? Did Appeals give you a copy of that spreadsheet?
Yeah, and I received a spreadsheet, but this is an Excel file.
Right, I understand that, but there seems to be a misunderstanding that it seems like the prior auditor said CD, but what they really had was an Excel spreadsheet. So to address some of your concerns, the Department's Appeals Division recommended you take that spreadsheet to Sam's Club and ask them to compare that spreadsheet with you, walk you through that spreadsheet. Did you have an opportunity to do that?
Okay. From day one, when I received the spreadsheet Excel, I just doubted if it's really come from Sam's Club. I will just assume this is not Sam's Club stuff, because from the one report I submit to your respectful members, these are Sam Club stuff. These are Sam Club stuff. So I just very, very suspect that the Sam's Club could provide two types of data for the same customer for the same period. Okay, I just feel very surprised on that. Okay, so I just, to be honest to you, I really sincerely believe this spreadsheet is not comes from Sam's Club. It's the worksheet prepared by the auditor who left already. Okay.
I understand your argument. Member Runner?
Yeah, just quick on, first of all, on the spreadsheet itself, is there an indication on the spreadsheet that it was from Sam's Club?
I'm not sure.
You don't remember, or you're not?
It's not that I don't remember. It's
This is on the bottom here. It says Sam's Club. Is
This is not from. This is from the. This is
yeah,
from
this
him.
is
This is his, not theirs.
This is Miss Liu.
Right. So they provided us something that says from Sam's Club. So did the spreadsheet that the auditor provided them have any indication it was from Sam's Club?
I do not recall if it said Sam's Club on the bottom of the page.
Okay, let me ask you, I'm going to go to appeals real quick. Because under this new world we live in, we don't have access.
We're trying to
which is,
pull it
I think,
up.
really unfortunate for the
We're-
taxpayer. I mean, here we are, have the taxpayer, we don't have access to the file. I'm confused at times how it is that we get information.
We do want to.
So tell me, in a situation like this, how would you instruct us to get this information?
As long as it's as long as it's discussed on the record, it's not ex parte, which I'm not allowed to give that advice, but my opinion is we're all discussing it. There's no ex parte communication. We've got a digital copy of it right here.
Back up a minute. Can we not go to you and you provide information for us?
Yeah, we do now.
Hold just a minute, let me finish.
My understanding is we're not allowed to, per the MOU, we're not allowed to supplement or add to a record, but at a hearing with all parties present, if evidence comes in.
That's not my question, my question. If there's something in the file concerning the taxpayer, do we not, and we ask for it, because we can't have access to it anymore individually, are you not allowed to provide it for us?
We're not allowed per the MOU to add to the record or supplement, so.
Is it in the record or isn't it in the record if it's part of the audit worksheet?
My email instructions is we're not allowed to, but those email instructions also said that the Y drive was copied through board proceedings into a board member drive. So my understanding is the board members and their staff should have this document and access to this document in their board member drives.
Right now?
Yes.
Okay.
In fact, the problem we had was for the D cases later today, you should have had it and didn't a couple of weeks ago or a couple of days ago, and now do. That's how I know this all came up. You're supposed to have access to this.
Anything that,
This is part of the record, this is part of the audit work papers. I don't know how to print it out right now, and if it's given at a hearing, I believe there's not a problem with you receiving it, but you should already have access to it in your board member
I'm a
drive.
bit stymied right now because at least we're trying to figure out whether or not we did have access to it. So that's what I'm trying to figure out
I don't know
right now.
I don't have access to a board member drive, but I have emails from these D cases instructing us that TSD was supposed to copy and board proceedings was supposed to make available Y drive matters into the board member drives.
my staff member, Ms. Renati, said we did have access to this.
When you say I'm sorry.
We can access anything that we need for a case. We're not supposed to communicate with the department or add information, but we do have, I believe, the ability. I think we had that squared away initially because we weren't allowed to access anything. And then we made a special request that we had to have these particular files through board. We had access to this through board proceedings. So that was how we accessed the files.
So clarify for me, so it's in the board proceeding drive, or is it a separate drive?
There's a board member drive, as I understand it.
Okay, then I think I have
And everything that's in the Y drive has been copied into that by TSD, not appeals, not the department. What we're looking at, you should have access to.
I think I'm just a little different because I'm not part.
You're different.
Yeah, so I'm okay with it.
Well, I'm
okay with
confirming,
it. I know that.
confirming right now whether or not we actually did have it, so I'm just, let us take a look at it.
So when, to appeals, then you guys have that spreadsheet on your system right now? Does it have any notation of where it came from, the source of that document?
Email trace.
Oh, try the bottom. It says Sam's Club XLS.
It says that from,
And what is this? This is the invoice number. Invoice number, date. Membership number, date, item, special tax code, quantity, amount, tax collected, none. Membership type X, I don't know what that means, and then item description. And it's 4,000 lines or more. That's where we've stopped.
For 1 year.
For 1 year.
1 year. Can you tell who created the document? I think if you right-click on it or something like that, check the properties.
Oh, yeah. You might have to go to the icon. Go back out to here, the file manager, and then right-click on that. No, it shows a creation date.
That's a good guess.
Go ahead.
I'm not an expert at this.
I know,
It
so I was
shows
calling for TSD.
shows a creation date, shows the file type, it doesn't show who did the creation. But at this point, I'd rather not be reading into the record if the members have access to it. We'd rather,
My system is different. I need to actually be on a BOE computer or CDTVF, computer, which I'm not on. I'm on a SCO computer, so I can't tap into it right now.
can I give you this?
Is it possible for Ms. Stowers to walk down and view? Why don't you do that? That might be easier, and so that we could put this to rest or not. Thank you.
So read only documents. And you see it. Thank you.
You're welcome. Okay, are there any more questions, or?
Yeah, Madam Chair, may I?
Yes, please.
Question of the appellant taxpayer. Why not purchase your cigarettes directly from Philip Morris?
为什么你不直接从那个菲利普莫斯买香烟呢？
那个万宝路公司，它没有专门卖烟的地方，它都是由 Sam 或者是Sam Clark 他们是代销他们，我们就是到他那里去批发。
Oh, yeah, the Philip Morris, they don't have a department to sell their cigarettes directly to such small business. You know, they only can purchase from like a Sam Club. That's the only way. Yeah.
Okay, thank you.
Okay, they received, I just want to read into the record that what's in the files, they received $35,681 in rebates from Philip Morris and only purchased $115,136. And we think that seems like a really high rebate amount.
他说这个 Philip Morris 给你们的这个回扣大概有35,000块，那么高，是这样吗？有可能吗？
我觉得应该不会有那么高。第一条哈，他刚才那个你跟我翻译说他那个银行账单，我银行账单全部都给他了，因为所有的退款都是通过银行的。这是第一。第二条就是说这个息地的事儿，那个人刚开始第一个来检查我们税的时候，他确定是有这个东西，他这个又从息地上面就是根据息地来做这个账的。然后就是说，后来等到过了有1个星期了，他们就打电话说换人了，现在息地也没有了。然后就是说这个银行账单他也说不全，因为当时不全的时候，他不会说走下一步那个操作。他肯定是银行账单和那个和这个 SAM 的那个 number 号会员卡我都是给他了，确定是全部都是齐全的。
Regarding the rebate, she believed the number should be lower than that. Actually, as earlier she indicated, they provide Philip Morris their bank account anytime when the rebate occur. Philip Morris just will directly, credit to their account. So if you look at 12 months, you add them together, that's the rebate they got. But she just feel kind of surprised that the auditor or the department saying that they have not received the complete bank statement. She can swear that she did provide all the bank statements. And then regarding the CD also, and then she just verified what I said. Both of us, when we meet with Joseph, and he said he had a CD and from Sam Club. As I recall, he never talked about the word Excel. Never. You know, he didn't say this is an Excel report from Sam's Club. He just said he got the report from Sam's Club. I don't think he never mentioned Excel. So that's why I believe the Excel is something prepared by the department or the auditor, maybe based on the Sam CD information. So what I believe is we need to find out the Sam Club CD is there or not.
Okay,
Let me finish, please. I think we can form an investigation team, and then both sides go to Sam's Club. Or we can do subpoena or something like that, and to see what exactly going on. For instance, I don't believe it's a Sam Club Excel report. But can we just send an investigation letter to ask Sam's Club to answer question?
Okay,
it is your information provided.
I'm not taking all this testimony again. You've already said that, so I do appreciate it. Okay, are there any other questions? Members? No. Okay, do I have a motion?
Well, I'm going to recommend a 30-30-30 because this is our second Sam's Club issue that came up, and I actually would like to see the invoices from Sam's Club just to satisfy our minds that when the department brings up Sam's Club's invoices that they really are from Sam's Club. We didn't see them last time. We saw just excerpts of a couple of transactions from Sam's Club, which in my mind made me comfortable voting with the department because there were bank statements, there was checks, and the checks were in order, and it showed that the taxpayers, wrote that check to Sam's Club, even though the electronic signature was like a swish. But that made me confident. Like in this case, that's a lot, big difference, $900,000 to $140,000. Like I would really like to see the listing from Sam's Club directly. This document that was provided by the taxpayer does not show in detail the actual amounts that were purchased, and so this is not useful to me, and I don't know if the Excel spreadsheet that Appeals is looking at is from Sam's Club. I don't have it in front of me. If you say it's from Sam's Club, it would be great if you can print it out, and maybe we can hear the rest of this case later on today, but this is a big discrepancy, and it's unsettling to me, and I can't really make a decision based on, things that an auditor who's not here, a CD, Excel, you're not sure, I just need to see some actual documents of this Sam's Club purchases.
Is there a possibility for Appeals to forward to Ms. Ma or her staff, or both, a copy of the Excel spreadsheet that was just viewed by Ms. Stowers?
Okay, someone print it out. Can you print it out for me?
I think it's long to print out. It's 4,000 lines just for 1 year. We've got 3 years. Because it's already record and part of the record, I don't think I'm beyond my scope. I don't think there's a legal reason why we cannot. Let me just see if I can figure out how to do it.
Or just 1 year. I don't need 3 years, okay? So $900,000 for 3 years means they purchased approximately $300,000, right, from Sam's Club.
Yeah, I'm not looking at the total amounts, and it's a spreadsheet, so I wouldn't be able to just carve out the 1 year. It also won't show your concern for like the signature.
I don't need the signature.
Okay.
I just want to see their account, right, that ties to their member's account.
We can forward it. I don't know, I won't get it to you in the scope of the time you guys are discussing, but I'll start right now.
Well, we can come back on this.
Can the department speak to what the difference in periods may, whether or not that may attribute to part of the difference?
As far as the difference between the 151,000 and the 951,000, is that?
I recall the department indicated that the document was for 2 years, department projected over a 3-year period.
Well, the taxpayer, what they obtained from Sam's Club was for 2 years. The department obtained the purchases for the entire 3-year period. There is no estimation. All these figures are actual. What I would point out on the inspection report that was conducted, and the person that would probably know best is the person that was making the purchases. And if you read what he told our inspectors is he makes purchases twice a week. And that was the inspection that was September 28th, 2011. And when you take a look at making purchases of cigarettes every two times a week, is inconsistent with having purchases for 63 days over a 3-year period.
Thank you.
Let me do this, members. I'm more inclined to go with the department on this, but understanding that there's still a member that has some questions, I would like to say that we close the hearing, that we make a motion to take this under submission and allow Ms. Ma to, or whoever else, to examine what they need to examine and then bring this up at the end of the day.
That'd work, because then we can decide if it's a 30, 30, 30 at that
Okay,
time.
yeah, because my staff is saying she sees the spreadsheet, no indication that it came directly from Sam's Club. There isn't a copy of an email from Sam's Club, just the spreadsheet.
Okay, well, there is an email, so let's just put this, I'll make a motion that we take this under submission. Do I have a second?
Second.
We have a second from Ms. Stowers. Any objection? No, such will be the order. Why don't we take a few minutes now for whatever we need, maybe 15 minutes at least, just to...
I can eat in 15 minutes.
You can eat in 15? Okay, good. I think that's a good idea. We'll take a 15-minute break before we come back again. Is that okay with members? Good. All righty. We're recessing for 15 minutes. We'll be back.
Okay. 先休息一下。
休息15分钟。
Okay, we are all back, but we do need the other case to be cleared from the table there. Offer the appellant a nice seat over here so that we can get on with the next case.
So they're going to move on to the next case. They took your case under submission, which means they haven't voted yet.
Let's see,
So they're going to go on to the next case.
We're going to move on.
Well,
Because
I appreciate that's what you want to do, but let me have a discussion. I've got some information. Well, no, it's not. I think we get to help decide what we're going to do.
You're always so bombastic, and I appreciate if you wouldn't.
Madam Chair, you're on the record.
I know I'm on the record. He was too. I am on the record. I would appreciate just...
Here's my point. During that time, we did get some information, and I would just like to, for continuity's sake, continue the discussion on this item, since it
Okay,
just took
let me
place.
explain what's happened. We took a vote to take it under submission. The appeals is waiting for her attorney to come back so he can show them some of the stuff, and then they will, once they discuss, we can come back and have our vote. But
Just
there's
procedurally, Madam
still
Chair.
things going on right now after we already took our motion, and we can come back.
Procedurally, Madam Chair, if the member is of the opinion that that may change the discussion.
Well, we haven't voted yet. We just took it under submission so that we could move on to the next case.
Well,
But
he could ask them to rescind the vote.
Well, or even if we took it under submission.
Okay, never mind. I don't run the meeting. It's fine. You all just do what you want. I get banged here and here. And this has been an unbelievable 2 days.
Well, I'm sorry for your frustration.
I'm sorry for your rudeness, but let's just continue on. Are we going to withdraw the take under submission in the motion? Because are we continuing the case? That's what's out now. Does anybody want to withdraw that and continue the case with the new information that we just had? Has everyone had a chance to examine the new information?
Well, let me just get clarification from the attorneys in regards to what our options are. We did vote to take this under submission, which then means that we are taking up at a later time, I believe.
Which cases are those?
We're taking up the vote.
I'm sorry, just a minute. Go ahead.
C5, case C5, which we just heard, we made a motion and a second, and we voted to take it under submission, which means that we will be reviewing things and coming back for a vote. Now, I know you're not our regular attorney, but if Mr. Runner wishes to rescind that at this point...
No, that's not my question. My question was if it's necessary to rescind. Is it necessary for us to rescind that vote, or can we just go ahead, even though it's under submission, take it up now under submission, like we had said, and kind of get our questions answered now?
Under submission, we did close the public hearing.
So in
Okay.
other words,
Clarify.
on this case right here, you voted to take it under submission. So the question is, can you now consider taking a vote now as opposed to waiting?
That could be one way to look at it, sure.
We have closed the public hearing, so there would not be any more public testimony, is the point I'm trying to make. So if you want to rescind the previous motion and continue the hearing, you will need to make a motion to do so, or you can, if you think you've had enough time to examine all of the data. Otherwise, this public hearing part is closed, and it's just up for board discussion, but I would rather take board discussion at the end of the hearing, because that's when we're going to be bringing up the other items that we have not voted on yet.
Right. I don't care when we discuss it. I do have some questions for the department. Just
Yeah,
let me finish. I do have questions for the department. I know we have closed the public hearing, and so I do have questions for the department in regards to this particular issue based upon the informations that we received. And so when we take it up under submission, are we able then to have a discussion with the department in regards to the information that we received?
They won't be present. The record's closed at that point.
Okay. So if we want to have a discussion with the department, under the information that we just received, we would need to rescind.
Rescind and get them back here.
And get them back here, along with the taxpayer who's already at the table.
Yes.
Right, you could take a motion for reconsideration of that.
We can
Of that
rescind the
Here-
original motion and then come back and reopen the hearing.
So here's my, I guess, my trying to work through, and that is, the other option is to do a 30-30-30 and give instructions and then go and have it done during the 30-30-30. My only problem is I don't have any idea when a 30-30-30 returns these days and whether or not we will be here during that time. So that's kind of the dilemma that I'm in, that I'm trying to figure out right now.
Well, we can take up, what can happen is that we've already closed the public hearing. If you don't want the department back, then you don't rescind your vote. If you want the department back, then you have to make a motion to rescind that previous vote, reopen the hearing. Or when we get to the point where we're going to examine these items and vote on them, you may then, after a motion and a second, you may then have a board member discussion, but then again, you will not be having discussion with the department.
Nor the taxpayer.
Right, so you have two choices.
So I'll make a motion to rescind, because I guess I'd like to have on record the discussion in regards to this issue.
Second.
Okay, we have a motion to rescind the previous motion to take item C5 under submission. We have a second by Member Stowers. Is there any objection? Okay, no objection. Come on back, boys.
Thank you. I just want to make sure that we understand what we have before us and whether or not a 30-30-30 is even necessary, or whether or not we've got enough information before us. So we now have copies of the Excel spreadsheet that's before us, and I did see, although I don't see it here, the what's it called, the page that shows you where it came from.
Properties detail.
The property detail, and the property detail that I saw did indicate it came from Walmart. So at that point.
That's correct.
Right. But the problem is, and I think I asked for the property detail to be distributed, a screenshot.
We did send that to board proceedings. It should be.
Okay, do I don't have that?
I did send it to you.
You sent it to me how?
Email.
Electronically?
Is it in the email?
Yes.
Okay, so I got a hard copy here and the other items in the email?
Yes.
Can we get a copy of the email, I think is going to be the next question.
Get a screenshot.
Or a
There's
screenshot.
a
Can we get a
screenshot.
copy of the screenshot?
That's what we sent by email. We sent the whole Excel spreadsheet, and then independently, we took a screenshot of this properties detail, and we sent that to board proceedings, and that should have been sent to you as well.
Yeah, maybe,
5
maybe
minutes.
that.
Okay, here it is. Here is requested, which is right here. Okay. And
we offered to show that to taxpayer and the representative.
this is the Excel spreadsheet.
Right.
Read only.
You guys can open, sorry, the members can open.
Go to the properties?
On that spreadsheet.
On properties, it'll give
Yes.
us that information, right?
Right-click properties and then go to details.
Yeah, except I do math.
For the record, both the appellant and the respondent has access to this as part of the record.
Well, taxpayer does not have access to our
Okay, let me do it
library.
this way. Let me do it this way.
The information.
Let me do it this way. I can get there this way. On that properties report that's attached to this email, what are the, I'll go to appeals on this. What are the dates that it was delivered?
February 13th, 2013.
And when was what was the date that it was then, that it was last?
I'm sorry, just so that's the date it was created. I know there was an email by which it got sent to the department. I don't know what
Okay,
date
that was the date it was created. And what was the last date that it was opened?
Date last saved is February 20th, so 1 week later,
February
2013.
20th. Okay, that's my question. Okay, so we had an email that was delivered on February 13th, or a spreadsheet, excuse me, that was delivered on February 13th, and it was closed on February 20th
Of 2013.
of the same year. My question is this: what's the normal procedure for keeping in the file a report like this? I assumed and I thought that the procedure was that the attached email was also a part of the file. And we cannot find the attached email anywhere.
We can't either.
Right. The policy is to maintain that, the email that you're referring to.
So the policy is to retain the email, and we cannot find the email. Do you have a copy of the email?
I was unable to locate it as well.
Okay, because potentially the issue is, and again, this would have satisfied the taxpayer too at that point, because the question that he's got is he doesn't know if this is for sure from them, or whether it was, quite frankly, manipulated between the 13th and the 20th. And so we have no ability to help them with where this came from, because we can't find the original email, which is the proper procedure. Correct?
That is correct. My understanding, and I'm trying to recall, I believe it's I believe that there is an email on that, but I'm not 100% sure. That's my understanding of it.
You believe there's a what?
There is not an email that we didn't retain.
How do you send an
No.
Excel sheet without an email?
I do not believe we retained the
Okay.
email that was sent. So yeah, there would have to be an email that was sent along with it. My understanding is that appeals took the information that was provided by the taxpayer from Sam's Club, traced it into the email that we're talking about that we received in February of 2013, and did not find any differences. But the department itself did not do that, but requested the taxpayer to analyze it. And to my understanding, the taxpayer has not analyzed it.
Well, we asked him to analyze the email, the spreadsheet that we had without the email, right?
I don't believe so. I believe they were supposed to take the information that they received from Sam's Club and then compare it to ours to make sure that, right?
Okay, let me ask the taxpayer, did that take place?
I'm sorry?
Did that take place? After you received this spreadsheet, did you then compare it to your spreadsheet, or did you have a spreadsheet?
Your Honor, I mean, actually, honorable member, board member, earlier, the department said that they compare, Sam Clubs to our printout. I don't know, but it's talking about the 2013, right?
Right.
But the auditing period is from 2010 to 2012. So 2013 is not in the range of auditing. So I don't think it's appropriate to bring 2013 something as evidence to try to prove 2010 and 2012.
Okay, I'm done.
Okay, so, one more time. So the department said that they had this spreadsheet, and these are 2009. On my spreadsheet, it says 2009 transactions. And they were supposed to give it to you for you to analyze. Did our department give you any spreadsheet to analyze and compare with your records?
No, this is the first time I saw this.
Excuse me, I believe if we went back into the file, the taxpayer or the representative said that he got the Excel spreadsheet, but he didn't really believe it was from the department, and so he didn't analyze it. I think that is of the record. I do believe that's what was said earlier. So you may not have had these pieces of paper, but I know I did hear that you said that you just decided to discard it because you didn't really believe it was from the, whatever it is, whatever the place is, Price Club.
Let me explain. I received an email from department during the appealing process And then when I saw this Excel file, I didn't go through line by line. My understanding is because the Joseph told us Sam Club CD, my understanding is not Excel spreadsheet. So when I saw a spreadsheet, I just rule out. It's
You ruled it out
impossible.
because you were looking for a CD and not an
Yeah, I'm
Excel
looking for,
spreadsheet.
I rule out is not that I'm done. I still waiting for CD with my hope.
Okay, so I have a question to appeals. I understand that we do have subpoena powers.
I believe we do.
Right. Is there any way we can ask Walmart? I'm sure they have more than 2 years' worth of data.
Sam's Club.
I don't know that we need a subpoena to do that. We've got statutes that allow us to talk to Walmart, allow the department to talk to Walmart and obtain that information.
Okay, that would be very helpful, to ask them again for the period 2010, 2011, 2012, make sure the account is right with their membership number, because I'm not sure this is their membership number either, 229736707.
I believe that's been verified.
That has been verified?
That's my understanding, that we verified the...
Okay, I would like you guys to do it again.
Can we move a 30-30-30
Yes.
with these instructions?
Yes,
I'll make a
I would
motion
like to move a 30-30-30.
Mr. Renner, maybe just as a consideration, we could just put the matter over to the next hearing, direct staff to do that, and bring them back.
Good point.
Oh, we can? Okay, that's
Yeah,
even better.
That's a good point.
And then that would satisfy me. Thank you.
Okay, so do I have a motion then to postpone?
We wouldn't need it, Madam Chair, you could just do it.
I can just do it, okay. You mean you're letting me? Imagine that, I can just do it. Okay, I'm going to postpone this hearing till the next month, and I believe that is August in Sacramento?
Sacramento, yes.
Oh, in Sacramento, and we'll continue on with this. Just that one just only this one examination part. Does anybody need anything else? Because I don't want to reopen the entire hearing. I would like us to just examine that these Excel spreadsheets are, in fact, I guess the question is, are they in fact from Sam's Club? And you mentioned Walmart as well?
Sam's Club's with Walmart.
Okay, so they're the same. I don't know, I don't shop there. Okay, if these things are in fact, verify that these are in fact from the audit period and they are from Sam's Club, and that the department has verified that the member number is accurate to this taxpayer, and I think those are the only issues in question. Yes, please translate to her.
Yeah, so 现在呢，新的事情是今天呢就暂停休会，这个 board member 责成他们呢去跟 Sam Club 去联系，去核实这些信息的准确性。那么下一次呢，我们再开会，再来讲这个事情。那么除了这个核实这个 report 之外，这个报表以外，你还有什么其他的需要补充的事情就是要他们下次再谈呢，还是就是下次就谈这个事情了？那就是等到下次就是这个事情。I just let her know that next time we will have a meeting regarding this verification result. Is that
right? That's all we're going to meet on.
Yeah.
Everything else has been heard. Just this, and so we'll be in touch with you.
For clarification,
Pardon?
Forgive me. For clarification, August is Sacramento.
Right.
September would be Culver City. Then the Culver City calendar might give a response time, plus the opportunity for us to create.
That's very courteous of you. Would you rather go to Culver City or Sacramento?
你是想，它有2个开会的地点，一个呢是到北加州，还有一个呢也是在洛杉矶靠海边的一个城市。
哪个地点？
Yeah, she wants to choose the closer place, I think.
Culver City.
Yeah.
Okay, so it won't be in August, it'll be September in Culver City.
And this is continued here.
This is continued hearing with only one item left to address. Okay? Thank you.
Thank you. Thank you, all the members, board members. Thank you.
Madam Chair, with the indulgence of the members, I'd like to return to item C7. Upon further consideration of the matter and review of the applicable law, I wish to open the item Shawn Victor Bachor, case number 771334, and change my affirmative vote to a no vote.
Okay, what I would like to suggest is that we do all the changes and the votes at the end. Would that be okay with you? Is that okay with everybody else? I've got it noted here that you wish to change your vote.
I think that statement alone could do it. Bills?
Well, I'm not the expert, but what I've seen in the past is that you have to rescind the vote that was taken, and the maker of the motion has to rescind
Yeah,
it,
so
get a second,
let's do all
it
that
gets
at the
rescinded,
end.
and
I
then we
have it
vote.
noted here that you wish to do
Thank you,
that.
Madam
Is this on the
You're
vote that
very
was just
welcome.
taken?
This is on,
The chairwoman has it.
this is, I
This
have
one?
it, it's on C5.
No, actually,
C7.
C7, but...
C7, rather. No, we're on C5 now. So, okay. That's B. Yeah, I wrote it down. Where's my C's? You are thus so noted.
I think we're done with this case, though, right?
Yes, we are finished with this.
We're done.
Okay, thank you.
Okay. We have C5 to... Okay. So, now, the next item. I long for the days of the midnight city council meetings. So...
Our next item is item D, Special Taxes Appeals Hearings, item D1. Adel, Naiem, Makar, please come forward.
D1?
D.
D1. That's what I thought. Where my agenda is, so I'll just go with this.
Thank you.
Okay. Madam Counsel, it's that time again.
Because of the change in the law, I'm going to ask the board members if, with respect to the case before them, the matter before them, if you have any oral or written communications that was received by one side that you believe was not received by the other side that you would like to disclose now.
Yvette Stowers, I have not received any communication from either party on this matter.
Member Harkey states for this record of D, what is it, D1, to the best of my recollection, we disclosed that we have not had, that we understand we may have had, but we have not, we do not recall that we have had communications with the appellant and the tax department, the above referenced matter. And we would only have discussed any issues presented in the briefing record. We do not believe the law imposes disclosure requirement prior to July 1, 2017 operative date of provision AB 102. However, we hereby satisfy our ex parte disclosure burden to the extent one exists.
For the record, I've had no communications with the taxpayer, the department, or appeals, neither has my staff. In regards to this case before us.
I have had no communications, oral or written, with this taxpayer nor the department since July 1st, when I believe this law took place. And I believe any conversations that may or may not have taken place prior to July 1st are not applicable under the law. And for the record, I have had no conversations with this taxpayer before July 1st.
And to the best of my knowledge, myself nor my staff has had any communication with the taxpayer or to the department on this case.
To assist the board members in discharging their obligation, I'd like to ask the department if you've submitted any written or oral communications to any of the board members that you did not share with the other side.
The department has not communicated with the board members on this matter.
I'd like to ask the taxpayer the same question, whether or not you've had any communications, oral or written, with the board members up till now.
No.
Thank you.
Okay, appeals, please introduce the items on this case.
Madam Chair and members, the appeal before you presents one unresolved issue, which is whether the seized tobacco products should be forfeited.
Thank you. Okay, to the appellant. You have 10 minutes to discuss your issue, and then we will turn it over to the department. We'll also have 10 minutes. You will have 5 minutes more on rebuttal. So please introduce yourself for the record, and you may begin.
Yeah, my name is Adel Makar.
Speak, pull the microphone close to you.
My name is Adel Makar.
Okay, pull the microphone, just pull it from, it's on a cord, yeah, bring it closer. There we go.
My name is Adel Makar. I own the Al's Market 4, the one in Fullerton. It's individual owned. And the Department of Board of Equalization came in to check on the store on May the 18th and May the 17th. On May the 18th, they took the whole day with me from 8 in the morning till 4 in the afternoon. They checked everything. And even though they were looking at every receipt, every item, they look at the item, they say, okay, what is the receipt for that item? So we look for it, we get it, and they look the other way around. This is the receipt, what is the items, this and that. So the whole day on May the 18th, 8 hours, continuous work, searching everything. And the day before, they took like 3 or 4 hours searching for everything too. What did they came up with? They took some cigars from the cigar humidor worth $79.10. It been underneath a small cigar humidor I have. Maybe it been there for too many years because I don't really recognize what is underneath. I cannot see because whatever on the shelf, it has shelves with prices, but this one is like kind of hidden underneath. And that was the one very much the issue. I say, this is too old. You can even see it. It's in between your fingers, and it's fragile, yellow, and it's uneven syllable, or cannot even, I don't even know it's there. And the names to me is so strange. It's too old. And then she insisted, the investigator insisted, no, this is with no receipts. I said, yeah, but I cannot have such a receipt. It's too many years old, maybe 6, 7 years. She insisted to give me the citation, even though she looked at everything for a day and a half. Everything was very good. And I asked her, do you recognize what is it? This is very bad cigars. And you looked at everything for a day and a half. This cannot be right. I mean, it's too old. She insisted to give me the citation. Then I called the wholesalers for such a product. Every wholesaler I've been dealing with, they said it's been discontinued. And even though I asked for them to get me receipts, they say, we don't have such a thing. We don't have 5, 6 years away. We don't have. So I couldn't really come up with the receipts for this. I just want to consider that they checked my other stores. I have different stores. I have 3 stores under individual and 3 stores under corporation. They checked all of them. And every one of them was very good. And I have the dates there in the exhibits, in the one exhibit there, the dates and the time. They visited the store, they checked the stores, all of them. Every one of them is very good, except another store, which is a corporation. They found some items, some cigar items and some other items of the Swisher Sweets. They didn't find the receipts for it, but I have the receipts from the individual company, which is it created another issue I have in the second file. That's the only 2 things I have with the Board of Equalization. However, they checked everything in that store and in the other stores, and these are the only 2 things. And It's $79.10 from very old days. So I am not really happy with the way it is. I mean, they should just trash it. After a day, from 8 in the morning, 4 in the afternoon, whole day with me, investigating every receipt, investigating every item. They take the item, where is the receipt for this? We get it out. We get the receipts, okay, where is the receipts? What the receipts? This and that. They investigate it very well. So why you give me such a headache for something not really? And it's hidden underneath the cigar humidor. I cannot see it because I don't really care about, I care about whatever is on the shelves. That's number one. Number two, important, I had another inspection in the same location in 2013. The inspector from Board of Equalization inspected everything, included that cigar humidor, included the other things, and it was nothing. So very much I think it was receipts there at the time, but now I cannot find the receipts. And I called the companies, whoever I'm dealing with, they cannot come up with the receipts. And it's $79.10. After they checked everything like that, I don't think it's something really big deal. Thank you.
Thank you. Okay, to the department. Just wait a minute. Please, you have 10 minutes. Please introduce yourself to for the record. We're still got, let's set the clock.
Madam Chair and members of the board, I'm Josh Aldrich with the California Department of Tax and Fee Administration, together with Jay Kefalou and Steve Smith. The tobacco products in custody cannot be returned because there's no evidence that the tax was paid on these products. Under the Cigarette and Tobacco Products Licensing Act, when the department discovers that a retailer possesses tobacco products on which tax is due but has not been paid, the department is authorized to seize the products. It is presumed under the Licensing Act that tax has not been paid unless the retailer possessing the products provides a valid purchase invoice, showing that it purchased tax-included product from a licensed distributor or wholesaler. In this case, petitioner has not provided any invoice to show tax was paid on the cigars at issue. During the inspection, petitioner stated that he purchased the cigars from Dana Point. When investigations contacted Dana Point to inquire whether or not they sell those products, Dana Point indicated that they did not.
Are we combining both of these cases?
No, we're not.
No,
I'm addressing the $79.
Dana Point is D2, we're on D1 for $79.
Yeah, $79.10. But there's no invoice on this one. It's the first one, the D1.
Thank you.
So initially, at the initial inspection, there was a larger amount of other tobacco product that didn't have a corresponding invoice. Investigations gave the petitioner an opportunity to come back on May 18th and provide invoices to substantiate the fact that tax had been paid. However, petitioner was unable to produce invoices for the $79.10 in question. Once we verified with Dana Point that they don't sell those cigars and that he did not have any invoices for those cigars, the argument changed to the fact that those cigars were too old. However, on the cigars, there's no indicia of age. The cigars are still produced contrary to petitioner's statement in the exhibit that he provided this morning. And petitioner's retail license is less than 4 years old. Retailers are required to keep their invoices for the past 4 years. The inspection occurred 3 years and 11 months. Generally, the investigations department will offer to destroy it if it's a de minimis amount, but in this case, since there was a much larger OTP that didn't have any invoice and then was reduced, that wasn't an option, or it may not have been communicated that it was an option. So in response to the contention that the cigars are too old, there are photos of the cigars that should have been made available to the members, or at least it was my understanding that they were going to be made available as they're part of the Y drive. but just in case, I printed color photos for your review. My apologies, the one on the end is a little bit less clear, but Mary, would you mind?
No.
Are we really doing this?
Yeah, we are. I don't think you need to take all of the 10 minutes. I think we're probably satisfied here.
Okay. Thank you. If you have any questions, feel free to proceed.
Okay. I'm going to make this real short and sweet. I'm going to make a motion for the taxpayer here. Do I have a second?
Second.
A second by Member Ma. Do you want to open it up for discussion?
No, I didn't know what you were going. I was going to suggest that you give him his rebuttal, but you pointed in his favor.
Yeah, we have a motion and a second to rule in favor of the taxpayer. Is there any objection to that?
No, Madam Chair, but I do want to say something. I mean, as the author, and I believe Member Ma is also author subsequent legislation, it wasn't the intent of the legislation to have the department spend all this time on $79. So I'm just questioning if there's much more to this. When the preponderance of the evidence, based on your testimony, is that everything else was purchase tax paid.
They can't respond now.
Yeah, I know.
Okay.
We shouldn't be doing this, if that's the case.
Okay.
What was the question?
I would just like to add, too, that the problem that we have here with these tiny amounts is that it's posted, it's noted, and if there's ever any kind of second violation that comes up, there's fines and criminal prosecution. So this is huge. This is not something small. The dollars are tiny.
It's not about the
But
dollars
the
only.
reason that the taxpayer is even here is probably because if there's anything that comes up later, he's in real trouble.
He's suspended.
Yes, he's in real trouble. So that's why I made a quick motion, and there is a second. Is there any other objection to the motion for $79.10 to return the product?
The department wanted to make a statement. I just,
Yes.
for the record, I don't want to deny.
No, we've got another case for the same thing, and maybe it can be incorporated. Are you okay with that? Because it's the other case is $362. So he'll have another opportunity.
Madam Chair, I'd just like to give him for
Okay.
the record, give him that.
This is against procedure, though, because we got a motion and a second. But go
No,
ahead.
quite
and-
the contrary,
and
ma'am.
please-
Motion and
please
second, open
respond.
for discussion.
So the investigation should have been rather painless if the petitioner had all the invoices available. It would have been very quick and easily. But investigation extended the opportunity, even though, opportunity to provide invoices, even though the statute requires him to have at least 1 year of invoices for all the tobacco products in his possession at the retail location.
Okay,
All right.
thank you. There's a motion and a second, and just for procedural stands, when there's a motion and a second, the debate has been closed. Not allowed, so the taxpayer will just have to deal with what we've got here for right now. But is there any objection to ruling in favor of the taxpayer? I hear no objection. Such will be the order. Okay, you can stay there for item D2, right? Is that the next?
Yes, the next item is item D2, Al's Market 3.
Now, since we've already, do we have to do this for each case, even though this is the same taxpayer, the the disclosure?
If it is a separate case with a separate record, then we would do that. Because of the change in the law, I ask the board members at this time with respect to the matter before them, whether or not you've received any oral or written communications that you suspect was not shared with the other side, and if so, could you disclose them at this time?
Thank you. With respect to case D2, to to the best of my recollection, we disclosed that we have not had any communications with the appellant, or none that we are aware of, and with the tax department in the above referenced matter. If we had, we would only be discussing a briefing record with both the taxpayer and the department. We do not believe the law imposes disclosure requirement prior to the July 1, 2017 operative date of provision AB 102. However, we hereby satisfy our ex parte disclosure burden to the extent one exists.
Ms. Stowers, I have not had any communication with either party on this case.
Jerome Horton, relative to this case, I've had no communication with either party. Neither has my staff.
I've had no conversations, written or oral, with this taxpayer nor the department since July 1st, when I believe this law took effect. I believe any conversations that may or may not take place prior to July 1st are not applicable to law. In this particular case, I will go on to say we have had no conversation even prior to July 1st with this taxpayer.
Yes, and to the best of my knowledge, myself nor my staff has had any communications with the taxpayer or the department on this case.
Department to assist the board in discharging its obligation.
No.
Tell us if you've had any oral or written or submitted any oral or written communications to the board members.
No.
The department hasn't had any communications with the board regarding this matter.
Taxpayer, have you had any written or oral communications that you've submitted to the board members prior to now?
No.
Thank you.
Okay, appeals, please announce the items in this case.
Madam Chair and members, the appeal before you presents one unresolved issue, which is whether the seized tobacco products should be forfeited.
Thank you. Okay, once again, please announce yourself for the record. You have 10 minutes. That goes to the department, who also has 10 minutes, and then you may have a rebuttal.
My name is Adel Makar. I'm the manager, the president of the Al's Market 3, Inc., this is the corporated. And one of them is Al's Market, the one very much has the problem or the citation. And the same group of the investigators came in, and they spent a big time there investigating all the receipts, all the products, and this and that. And the problem happened that I have the corporation and I have the individual. The previous case was individual, and this case, this one is the corporation. So they asked me for the receipts for some products, however is there. I said I don't have it now because it's too old. Same situation, but this one is not too old. This is kind of old. But I have some receipts, so I showed the lady the receipts. She looked at it and said, oh, this is individual. This is not the corporation. I said, so what? It's the receipts, tax being paid for the item. This is the item, this is the receipt. She said, no. The law prohibits you from transferring product from a company to a company. I say, yes. The lawmakers, when they bought it, he didn't mean one person owner. I'm the same owner for the individual and the same owner for the Al's Market Corporation. This is Al's Market, this is Al's Market. But this is individual owner, this is corporation. I transferred some. She said, nope, I'm not even going to look at it. This is against the law. I say, yes, but the law is not blind. The law can see something. It needs a judge to make it. You can judge it now better than you wasted the time and the effort for everybody. You already really killing me. Before you had $77 for nothing, and today I have the receipts in my hand and you don't want to see it. That's sad. After all the investigation, and she came in around before the Christmas time and came in again after the Christmas time last year. And then I sent the receipts with everything documented to the, I'm not sure about the name of the people there in Sacramento. The guy called me, his name is Jay, from the people having the seized products. He said, these products does not have receipts. I said, no, the receipts are there. He said, yeah, but this is not Al's Market Corporation. I said, yes, this is Al's Market Individual. I'm the same owner, 100% owner here, 100% owner there. He said, no, sir, the laws are not allowing you to do that. Then after I said, that's not fair, and I really screamed at him, I said, you guys making an issue for nothing. Then he said, okay, how about I give you 50% on the value? I said, I'm not gonna take the 50% on the value. Why? This is my products. I have the receipts. What is your problem? He goes, nope, it's a different company. I said, the law cannot be like that. It needs a judge to make it right. Okay, so I gonna complain. I complained to one of his managers. The lady answered me the phone. She's a big manager. She said, oh, sir, you know, the law is not allowing you transfer from a company to a different company. I said, no, this is not from Jack to Mark. This is from me to me. She said, you know what? You have to lobby one of the congressmen to change the law. I said, I'm not going to lobby nobody. And I'm not even going to accept the 50% value. You guys know nothing in the life. It needs a judge to understand the situation. Here it is. I'm here now. I'm sorry. It's sad. It's sad. I don't see it right. With all due respect.
Okay. Is that it? Okay. Are you finished?
Yes.
Thank you. Okay, clear the clock. Okay, to the department, please announce yourself for the record, and you have 10 minutes.
Madam Chair and members of the board, I'm Josh Holdridge from the California Department of Tax and Fee Administration. The tobacco products in custody cannot be returned because petitioner has not established that tax was paid on these products. Under the Cigarette and Tobacco Licensing Act, when the board discovers that a retailer possesses tobacco products on which tax is due but has not been paid, the board is authorized to seize the products. It is presumed under the Licensing Act that tax has not been paid unless the retailer in possession provides a valid purchase invoice showing that it purchased tax included products from a licensed distributor or wholesaler. A licensee or retailer in possession of cigarette and tobacco products bears that burden, establishing that the applicable taxes have been paid and can meet this burden by providing valid purchase invoices, showing that it purchased tax included products from a licensed distributor or wholesaler, and that's Business and Professions Codes 22974. Invoices for the sale of cigarettes and tobacco products must include the name, address, and itemized list and license number of the licensee to which the products are sold. Business and Professions Code 22972 and 22978.4, subdivision A4. When a retailer's location is inspected, it cannot show that the product in its possession is tax paid based only on an invoice that identifies a different location, a different DBA, a different address, a different license number as the purchaser, and thus the product is presumed to be untaxed, even if the purchase invoice shows the same legal entity purchased the product. A legal entity with multiple locations that transfers products from one store to another can only document that the product in its possession is tax paid if the transfer of inventory from one store to another is documented using a transfer log made contemporaneously with the transfer. Without this documentation, it is impossible to establish that the product is tax paid and product is subject to seizure. Business and Professions Code 22978.5, it's the itemization portion, and it says that invoices need to have the brand, type, flavor, and packaging of the product. In this case, petitioner has not provided valid invoices or transfer logs to show that tax was paid on the cigars at issue. Petitioner transferred OTP from a separate business entity to the corporation Al's Market 3, which violates the Licensing Act. Petitioner did not comply with the invoice requirements of the transfer logs, despite being warned to do so on several occasions prior. The board may only order the release of the cigars if it determines that they were illegally or erroneously seized. In this case, the cigars were properly seized because there's insubstantial evidence that tax was paid, and petitioner cannot legally possess them. Therefore, they cannot be returned. Thank you.
Okay, you have 5 minutes if you choose for rebuttal.
I have 5 minutes, I'm sorry?
You may answer or
Yes,
dispute.
yeah, for sure. Tax has been paid. I have the receipts for it. Even though the guy, whoever his name is, Jay from the Sacramento, the one has the seized products, he offered me 50% off on the products because I told him you have the receipts. I already sent you the receipts. He said, yeah, but this is a different company. I said, yes. But I didn't know, I thought because I have the cigarette license all under my name for all my locations, I can transfer from whatever to whatever. To me, it's all Al's market. To you guys, it's individual, corporation, individual. I really didn't recognize it this way, from the way it is from individual, corporation, individual, because I thought it's very much I'm the owner for the cigarette license for each one of them. So I transferred. And even though when I looked at the papers in my hands and the investigator right here next to me, I say, I have the receipts here. Here, look at it. She said, no, I'm not going to look at it. It's from a different company. It's illegal. I say, yes, but that's me. I'm the same owner. She said, no. So it's very much tax being paid. There's no issue. Thank you.
Okay, thank you. Members?
Motion for the taxpayer.
Second.
Objection?
Well, no, I mean, I would just clarify the motion with the permission of the motion is that, the legislation does require that there be a transfer process, that the product, that somehow there's on record that the transfer took place. And I believe that the taxpayer's testimony of providing documented evidence that the transfer took place should have been sufficient. And at some point, we have to take an interest. The aggregate of what we're doing, we can't be form over substance in our assessment at the lower level. We have to go in there, and you have to have a level of professional judgment that doesn't cause this type of activity where we're spending thousands of dollars to resolve something that it seems to me, given that there's no other evidence, that the preponderance of the evidence is that the transfer took place. The invoice was presented, a negotiation took place to split, don't know who did this, in half for the consideration, which, anyway, just want to go on the record, no objection, Madam.
And I would say, I mean, the whole purpose of audits is random audits. It's not really to go and find like that smoking gun. I mean, if you're there 8 hours a day, going through all the receipts and then you find one cigar, then it's illegal. You're going to try to suspend him. In this case, it's about taxes paid. He paid the taxes. It's, I would have liked to have seen, okay, you educate him, you tell him you have to keep it under 3 separate. Honestly, as a taxpayer, I would have assumed the same thing. One license, they're all his name. Why not? As long as he's paying all the tax, why should it have to be 3 separate invoices to 3 separate companies, yet it's one certificate and he's paying all his tax? So I understand your frustration. I apologize. I don't think the tax laws were supposed to be like, hey, if you don't cross your T, on this one form, you don't include the color, then, it's illegal and, we're going to suspend you. I mean, I don't think that that's what legislators, we're all former legislators in the legislature. We want to catch the bad guys, but for the good guys who are trying to do the right thing, who are paying the tax especially, this is not how we would expect taxpayers to be treated. That's all I'm saying. And I understand his frustration. I would be frustrated as well, so.
Part of the challenge with the legislation is strict liability. And so then the board has sought to sort of fix this. I'm trying to recall what it was, because we saw this as a problem before, and there was a workings with the union as well as the industry in order to address how they can accomplish these transfers to the satisfaction of the department. And meaning that at some point, the department has some discretion to say that they're satisfied that the transfer actually took correct place. Very rarely does the statute actually define a specific procedure to the extent that it doesn't allow the department to modify that process to accommodate professional judgment. Anyway,
I'm just thinking maybe the, just one more comment, maybe the department ought to establish a threshold percentage of inventory or something so that we're not dealing with a couple cigars here or there, or I know this could be maybe a licensing violation, but I would think it would be explained to the taxpayer, since the amount is de minimis, it would be explained and maybe allowed to be corrected rather than this, because this is devastating to a person. It's
Very
their livelihood.
devastating, though. It's a nightmare.
It is a nightmare. It's how people survive. He's got a business, and he's trying to feed his family and do his things, and this is just consuming him, I imagine. So could lose his license over this. So there is a motion and a second, and is there any objection?
I'm sorry, Ms. Harkey, I didn't get the second.
I made the motion.
Okay. Ms. Ma made the motion, and Mr. Runner second.
Okay.
Okay, no objection, such will be the order. Thank you.
Thank you very much.
Sure. Next item. Where are we?
Would the members like to take up item P1, the Executive Director's Report, or would you like to take up the final actions from yesterday?
Which one, what do you want to do?
Item P1, the Executive Director's Report.
Executive report, I think we're ready to do that. We'll do that, and then we'll go back and, then the last thing is then to take up the items, to allow Mr. Horton to change his vote, and then to take up the items for vote.
Okay, so our next item is item P, Other Administrative Matters. Item P1 is the Executive Director's Report. Item P11, the Organizational Update.
Thank you, Mr. Gow.
Good afternoon, Chairwoman Harkey and members. David Gow, Executive Director. I'd just like to highlight some of the transition efforts that we are going on right now as far as related to the enactment of AB 102. As you are aware and have experienced, it's been a little bit hectic as we sort through the details to implement the legislation, which went into effect July 1st. I've been meeting regularly with Secretary Badger of GovOps and her transition team, the new executive leadership of the California Department of Tax and Fee Administration, Mr. Nick Medeiros, and all really in the spirit of trying to make this transition as smooth as possible from one department into two, and then ultimately into three when the Office of Tax Appeals comes online in January. So, of great concern really has been to identify and meet with those staff who are still part of the BOE, which I did this past week. I was able to do that. Reassure them about their jobs, while really trying to address their concerns that allow them to continue providing their public service. And then another of the biggest concerns, as I think is evidenced the last couple of days, has been the lack of legal staff support for the board. I do want to, however, thank the Department of Consumer Affairs and specifically Ms. Noreen Marks for assisting us here in Irvine with the board meetings, so thank you. Obviously, ex parte has been the issue of the last couple of days, to say the least, and I will be submitting a request for an opinion from the Attorney General's office regarding ex parte communications, particularly prior to July 1st, on cases pending hearing before the board. And I have been given a contact name and assured that they will be responsive as quickly as possible on that. As you're also aware, I've been attempting to bring on an acting or a lead attorney to provide general legal guidance for the board and assist with the onboarding of the two new-to-state service attorneys that were assigned to the board, one of which starts next week. I have a meeting on Monday that hopefully it leads to addressing this concern as far as bringing on a lead attorney on a short-term basis until we can hire a chief counsel for the board. If you recall the organizational charts, there are a number of executive and manager positions that also need to be filled. Besides the chief counsel, other positions that need to be filled include the chief deputy director, CEAs for communications, legislative and research, and taxpayers' rights, an administrator position for the alcoholic beverage and tax on insurance programs, and an equal employment officer. So this will be my primary focus, and I hope to move forward filling these positions as expeditiously as possible. In the meantime, I'm the frontline supervisor for a number of staff in each of these program areas. I have to say, I've felt a little shorthanded lately, and I want to thank my staff, in particular, for all their extra efforts this last month. I did receive an email, actually, this morning that indicating I can immediately begin recruiting and advertising for the Chief Counsel, as well as the Chief Deputy Director. So that was good news this morning. As you're aware, I've also been working on obtaining memorandums of understanding that are yet to be signed, but that will provide the BOE with the necessary administrative services that are required by AB 102 for the board to be provided administrative and personnel services. These MOUs include one for fiscal and business services, which includes accounting and budgets, the business services area, including contracts, deliveries and transportation, facility operations, mail, purchasing of goods, reproduction, and travel. Human resources as well, including labor relations, and then also information technology services. I've also asked that GovOps and CDTFA work with me to move myself and my personal staff outside of the 450 N Street headquarters facility, and that'll likely be to the Natomas office, where the majority of the BOE staff are located. And they have been responsive to that request, so I'll keep you apprised as to that, how that moves along. Again, I pledge to continue working cooperatively with Secretary Badger and her team, especially Mr. Medeiros, and we've been meeting, and it's been very cordial, and things are progressing, so I appreciate his cooperation as well. I think it's really in the interest of the employees and the board and the stakeholders of both agencies at the center of this effort. So I'd also like to thank you for your patience, and as I look out for your interests and the interest of our staff. I will continue to send you emails on the transition progress and provide monthly board meeting reports. That concludes my report, and if you have any questions or comments, I'm pleased to take them at this time. Thank you.
Thank you. Yes, Member Ma.
Yeah, just a couple questions. I appreciate asking the Attorney General for some guidance. I know it hasn't been easy, but because of Bagley-Keene, we are not able to really talk about a lot behind the scenes, and so this is the forum that we have. I think, although painful, I thank Chairman Harkey for taking the majority of the brunt, that it was healthy in that we got it out. I think we all kind of know where we all stand on this, and I am hopeful that we will, it will be much smoother for our next meeting. Secondly, regarding Natomas, I don't think we ever talked about Natomas specifically, so is that a state building,
Yes.
or do we lease it, and how many people are out there?
Okay. Yeah, so the board now, BOE, the side of us, there are 153 employees, 205 with the members and their staff, but 153 BOE employees. 95 of those are in the Natomas facility currently. So that is where our property tax department is. There's also a few units of the CDTFA there as well, but it seems to be the most logical fit for the handful of my employees, and so that's the focus at this point.
And is that a DGS building, or are we
It's
renting it?
It's a private building that the board has leased for a number of years now. So we have been a tenant in that building.
And can it accommodate the rest of the 60 members?
That's what we've got to, I think, continue to look at. And I've had an inquiry from DGS that I just haven't been able to get back to because we have board meetings. So I'm going to be following up with their real estate officer next week.
Thank you.
Chair. Thank you, Mr. Gao, for your report. I much appreciate your services during this time. I have not necessarily looked at the staffing configuration from a needs-based assessment, but would certainly like to have the input of your staff on the needs of the new BOE, and particularly with the legal staffing. What I did observe, 3 attorneys in the staffing configuration does not appear to be sufficient, considering the litigation issues that the Board of Equalization is dealing with from the previous BOE and any anticipated litigation issues going forward. Some of the other staffing issues where we had, there was one individual communications, for example, without indication of an administrative staff, support staff, in order for them to accomplish their objective. So that it appeared to be operating in without the appropriate support. There was some other concerns that I have. I'd be more than happy to share with you. The exemption, property tax exemption waiver was not assigned to the new BOE, but yet still it's a property tax related item. So I appreciate that this is a process, and I appreciate that everyone is working to try to make it as seamless as possible. But at some point, I believe the department, BOE itself, has to do its own need-based assessment and own evaluation. And then I'd like to see what that professional assessment is. And to the extent that we can provide input, be more than happy to do that.
Thank you. Just to comment, you did mention a couple of things that I've been, both the property tax attorneys and the administrative support are, I think, things that need some further conversation as well. And so I will continue to work on that.
Yeah, the welfare exemption just seems to be a natural fit to the new board BOE.
The distinction or the division that was made on property tax were 4 units. Our legal entity ownership program, the timber tax program, the tax area services section, which does mapping in the taxing jurisdictions, and the exemptions area. So those 4 by statute moved to CDTFA, but it did kind of create a bifurcation, I guess, of what were traditionally the property tax functions. As they tried to balance, the constitutional versus statutory framework, but we will continue to analyze that and present something.
Yeah, in the need-based assessment, I'm pretty confident that all the parties involved also want to take in consideration the impact on the taxpayers. And so to the extent that some things are so integrated into each other, separating them actually may in effect be less efficient than allowing them to continue to coexist. But as I said, I really haven't spent a whole lot of time with this, but I would like to have your professional advice on our own assessment as to what works best for the organization.
Thank you. We will do that.
Runner?
Yeah, I appreciate, some being expeditious on regards to the chief counsel. My only suggestion would be, I'm hoping that works out for you to be able to identify a individual who will be able to come on a temporary basis until we're able to fill the position, until you're able to fill the position. My only thought would be, if indeed it does not work out, that I believe it would be in the board's best interest for you to go out and find a private contract, potentially, in order to bridge the gap. Because I would hate for us to be in the same position we are currently in our next meeting.
Yeah.
Yes. And so, again, I appreciate and hope it works out, but if it doesn't, I hope you look at other alternatives in order to get the support that I believe we need in terms of a full representation for the board, the taxpayers for the state of California when it comes to the issue of chief counsel. The other issue I would ask, and that is that clearly I think we still have some, and again, this may or may not be tied, or can or cannot be tied to the issue of chief counsel, but regardless, I think it's important for us in the next month for there to be, and it could be office by office as far as I'm concerned, workshops with staff in regards to ex parte. Bringing in somebody who will do presentations for our staff, train our staff, so we all understand what the rules are in regards to this process. And so I think that would be something that can or doesn't have to be done by a new chief counsel, it can be done by somebody else coming in, but just so that we can question and ask the unique situations and processes that we may go through to clarify what would be done. I think it would be good, whoever's doing that, to have some experience in regards to the kind of communication that needs to take place between the offices and the departments, though. So I think having somebody who's not familiar with that is at least hard, because then it becomes more theoretical for them, as opposed to somebody who understands and is experienced in regards to that relationship. So again, I don't know if we ought to be able to call on GovOps or somebody within the new departments to come and bring somebody to go to do these workshops. Again, I had a specific conversation with the Secretary, GovOps, who assured me that that could be done. Unfortunately, as we've seen here, it hadn't been done. And so I hope we don't have another meeting to where, again, we don't have that ability to have that kind of workshop and questioning time on that basis. The other issue is that was a bit disturbing to me and surprised then as I talked to the Secretary of GovOps, and that is there were a number of programs that you were a part of, that other executive staff were a part of, that were pilot programs that were being in place and being evaluated to find efficiencies and protection for both the state of California, also for taxpayers. My understanding is that those programs have all stopped. When I brought that up to the Secretary, she was unaware of that. Her words to me is none of those programs should have stopped. They still should be operating, but they're not. And so my concern is that, is that as the new ED comes in, I hope there's an interest in talking to us about those programs that were that were being looked at, that would be more efficient for both the state of California and protective for taxpayers and efficiency for taxpayers. I think it's a shame that somewhere along the line somebody's decided to stop them. Secretary has assured me it wasn't her. So somewhere along somebody made a decision, and I think that's unfortunate, and she was surprised about that. So I hope that we can continue, because every one of those, as you well know, we're focused on trying to create efficiency for California along with being fair and expediting taxpayers' concerns. So it would be unfortunate if we indeed were not able to be doing that.
Thank you.
I had just one issue that I was hoping Member Runner would bring up. We're working with his office, trying to establish some way to do the education outreach piece, MOU, or whatever we have to do to get some cooperation. We have a budget to do so, but to date, we really don't know how to handle it. And there's been, as I understand it, my staff member's not here that's been trying to do this, but we need some participation or some ability. I guess can we contract for the print shop? How do we do these things? Can we partner on some issues? There's a lot of issues where, we just might be a portion of something, but, it's all right now up in the air. And so I think mainly the issue is, if we can't use the department, we have to go through, we have to contract, DGS has to approve the contract. So we need some ability. I mean, I have no objection to going out and trying to find an outside printer and an outside this, but, if we can't use the department. But if we can, then we need kind of an MOU going on in that area, because everything's kind of stopped. And we can't figure out how to get it rolling again, and we can't contract.
Thank you. And we are working through the MOUs, and I'll look at that specifically when I review it again. Thank you.
Okay, do you have anything more?
Yeah, let me add on to that. I'm sorry, I forgot to bring that up. I think it's important because, again, as I talk with individuals, there's a constant understanding that this board is to continue to do taxpayer education. It was brought up as recently in the Controller's article that was in this week's San Diego Tribune. Is that right? Is that the right paper?
Right.
Right. That identified the fact, as she said, quoted in that particular column, that this board would be responsible and have the ability to do taxpayer education. The problem is that That's one thing to say, and again, I've heard it from the legislators, I've heard it from everybody, I've heard it from the secretary. But again, it's one thing to say it, it's another thing to provide for us then the tools and the abilities to do that. Clearly, I think it stops, I mean, the conversations are like, well, you've got a budget to do it with. Well, we may have a budget, but if we don't have the ability to implement and spend that budget or implement those contacts, then we don't have the ability to do it. And it's just it's a sham at that point, and I don't think that's the intent. So I do believe that's important. I know we specifically, for our traditional taxpayer education events, continue to keep those on the calendar. We did have a conversation with the secretary over those items, and fortunately, only one of them had to be canceled. The rest of them, I think, are indeed going forward. But again, it's clearly a responsibility of the new department to do those, which is fine, and we will be able to. We are being invited as co-sponsors, and we can participate in those too, just as we allowed and invited legislators to participate in when we were sponsoring them. But I think there needs to be an overall plan for that, because I'm not sure what's happening in the other districts, but at least I know in ours, those ones that were on the calendar are now being continued and are being worked. And we will go ahead and decide how to show up for those in those areas. So I think that's important, because I don't think that's even been communicated to the members in regards to saying, hey, go ahead, here's what's happening within your districts these days. So anyhow, I think those are important issues. Again, there's an issue between being able to actually educate taxpayers versus saying, hey, you've got this money, now go ahead and educate taxpayers, but we're not going to give you any tools to be able to do it with.
Yeah, I agree. It's a tough deal.
Yeah, thank you. To Mr. Gow, I know you've been quite busy with all the changes, but I note that at the meeting in May before AB 102 was enacted, there was a discussion about board governance, and your then team was going to work on a project or work on a report. And recognizing that you've been quite busy, I was wondering, have you had a chance to do it? Is that still on your radar to complete?
Board governance,
That was the board member governance project that was discussed, I think, right at the May meeting. So to be honest, it hasn't been. Part of it is I have no support on the BOE side, right, to work through that. We had started before AB 102. We had a couple of planning meetings when we were all one BOE, and to be honest, since that divide, I have not gotten back to it. So, but that was the board's direction. So I will.
I think I'd rather not see you go forward with anything that's fruitless at this point. I would much rather wait until January and let's see where we are as a board, what we feel we need. We can do a whole lot of things. We really, right now, what I have asked for is that we have a contact at the agencies, either one, both of the agencies, that we can touch base with if we have constituent issues, because right now we don't have anybody. We were assigned an 800 number, which when I get a constituent call, I need to be able to respond to that, and I need a point person in an agency that will actually respond to me. Now, if that is through the Taxpayer Advocate's Office, we need a name. Who is it that is going to be responsible and keep track of our constituent issues so that we can get back to our constituents and tell them they've been resolved or not?
With all due respect, Madam Chair, the controller would still like for you to move forward on board governance, and I do believe it was a vote in May where the majority of the members agreed to it.
With all due respect, the controller is saying things in the newspaper that I don't know anything about. So with all due respect, I would like to see Betty maybe at the next meeting and we can discuss what sort of governance she would like to see, since we only have one department and a couple issues. And our biggest problem right now is not a governance model, it's figuring out who to contact, how we keep the processes in place, and how we function. We don't have a chief counsel. There's just a lot of things we need to work on. And I think that once we get all of the pieces in place and know who we're contacting, then we can proceed on whatever governance policy we need. I don't think we have any any impact over, well, we don't have any impact over departments. They don't respond to us, they don't talk to us, and so it's not been seamless. It is very much traumatic, and I think the fact that we don't have a chief counsel, that we're still looking for positions for Mr. Gao, I would rather fill those immediate needs and get our lines of communication as to how we communicate, what we do. When we took that vote, it was in conjunction with coming back, that we would be implementing a whole governance policy. We got shut down in the meantime. The world changed. So I think right now we have real immediate needs. I don't want to send the staff bouncing back and forth for things that are not productive at this time. And I'd be very happy to talk to the controller if she chooses to call me.
I was not asking Mr. Gall to move on the policy today. I was just asking him, was it still on his radar? But I wanted to do note that it was something that the board agreed to. That's all I have to say.
Madam Chair.
Yeah.
Yeah, I would not want to, again, there's a whole bunch of stuff on the plate, and I get that. And I would certainly leave it to the ED to prioritize
Exactly.
what needs to be done in order for the board to be able to function and fill its needs. And so my position would be on the governance plan. I think it is still necessary and in this part. But at that point, I think it's just a part of of everything that we have before us. And so I don't want to necessarily say, let's wait till January. I just think it's on our plate, and I'd leave it up to the ED to determine when it is in the process of all the things that he has before him to put that in his schedule.
I think that's a reasonable approach.
And I will, thank you. Yes.
What we govern. It's okay. Okay. So I think you've heard the laundry list, and I do so want to thank you very much for stepping into this new formed entity, or actually old part entity. And anyway, with that, prioritize, just keep in touch with us. I think, the first thing, of course, is chief counsel.
It is.
And let's get that memo from the AG to have some guidance here as to how we operate so that all the departments are on the same page.
Thank you.
And I do appreciate our acting counsel, because this was very, very difficult, and I want to thank you very much for stepping into this. I also want to thank you for the support that, we, in essence, we don't deal with the other departments, we listen to you. So thank you very, very much. Okay, members, we have some votes to take. And we have one rescindance of a vote. Rescission of a vote? Yes, it is.
Pleasure.
Okay, what's my pleasure? Let's let Member Horton rescind his vote. I think we'll all be about this on the same page. Okay. Backland gifts got postponed, right? So, item C7, I believe it is.
Correct.
Who made the motion? Who seconded it?
I seconded, you made the motion.
Yeah, okay.
Member Runner made the motion, I think, does the second have to be rescinded and then the motion, or just the whole motion?
Any member who voted for the motion can make a motion to rescind.
Okay.
It would be a motion for reconsideration to reconsider the vote, and then there would be a second motion, whatever follows after that.
Okay, would you like to make
Move to
a...
reconsider the vote, Madam Chair.
I'll second that.
Were you on the prevailing side?
Yes, it was 5-0.
Yeah.
Okay, so now, do we have, let's repeat the initial motion. What was the initial motion?
Joanne?
The initial motion was to grant for the taxpayer
The initial motion was to grant for the taxpayer. Do you
and
wish
to
to
set
read?
this case as precedent.
And set the case as
Create a-
precedential.
That would be my motion.
Okay, Member Runner's making a motion. I will second that. We're just repeating the same motion that was made before.
Right, but the language is slightly different. That was a Section 40 decision that you wanted to be precedential. That's what was missing from what you just said.
Okay, right.
As stated.
As stated, let's just make the motion as was previously stated that was rescinded. Just repeat that motion again.
Yes.
Okay. And then now, is there any objection?
Members, just for the record, after considering the matter and the law in this particular case, I would like to amend my motion from an affirmative motion to a no vote.
You don't need to, you just need to say if you object now. So you're saying you want to object to the motion. The motion's on the floor, and you object.
Not really, but, okay.
Okay, because we rescinded the first motion, so now object. Okay, so we have, please call the roll.
Chairwoman Harkey.
Aye.
Mr. Renner.
Aye.
Mr. Horton.
No.
Ms. Ma.
Aye.
Ms. Dowers.
Aye.
Motion
Okay.
carries.
4-1.
Thank you, members, for your indulgence.
Thank you very much. Everything's just new today. I'm having to, this is interesting. Okay, now,
So next are final actions from our board meeting yesterday.
item B1.
Item B1, Richard R. Betchley and Kelly S. Brunk.
Item B1, the Betchleys,
Catch up.
Richard R. Betchley and Kelly S. Brunk.
Let's see. I need to amend, based upon our discussion, I need to amend my pre-statement or whatever we're doing, whatever they were calling those.
Your disclosure?
Yeah.
Okay.
For, what is this for, is this for Betchley?
Yes, it is.
Oh, okay.
Right.
Oh, okay, I
right,
get,
right.
I get.
Yeah. I already stated my first portion, and my second portion is to provide certainty for this taxpayer. I will disclose that one of my staff did talk with the taxpayer in advance of the previously scheduled hearing last year. There was no record-keeping requirement at that time, but our recollection is that we did not discuss any or received any materials in that briefing.
Okay, so you said your staff did talk to them?
Right.
I will disclose that one of my staff talked to the taxpayer in advance.
Long time ago.
Right, well, you're from
I don't know if you
appeals,
have
right?
to do that because you said to the best of your
Because
knowledge.
they would have the
I did not use
opportunity to comment.
Oh.
I'm sorry, what was that?
The parties would have the opportunity to comment on that.
Well, I'm sorry, who? Why does the department gets to comment on my statement?
Would have the opportunity to comment on whatever the communication was. You're saying specifically that the communication, that there were no additional facts or analysis that was otherwise reflected in the briefs?
Nothing that wasn't shared.
There was no record-keeping requirement at that time,
Okay.
but our recollection is that we did not discuss or receive
Oh,
any
that you
materials.
did not?
We did not.
Oh, I'm sorry.
Okay. We've
Okay.
borne our chest here. Anyway, okay, on Betchley, B1. Do I have a motion?
Madam Chair, for this particular one, we have heard it earlier last year, and then it came back, and we were really trying to focus the parties on proving the basis of the property, and based on the testimony and the evidence presented, I do not believe that the taxpayer provided any credible evidence to support that the basis should be any more than what the Franchise Tax Board had already allowed. So my motion is to sustain the Franchise Tax Board on all issues.
Second.
There's a motion and a second. Is there any objection? Okay, such will be the order. Okay, the next one is Fusco Engineering, Eric Armstrong, Oliver Chikiro, and Patrick Fusco, and all of the spouses, looks like. That's item B2, A, B, C, and D, and E.
Correct. And I'm going to amend my statement.
Okay?
To provide certainty for this taxpayer, I will disclose that I did meet with this taxpayer and representative last year on November 10th, 2016. As the taxpayer indicated yesterday, we discussed the case and the nature of the case's business, and the taxpayer did send us follow-up videos regarding the business. My staff did speak with the taxpayer representative on the phone a number of times in the past as the case was previously scheduled a number of times. There was no record-keeping requirement at that time, but to our knowledge, we did not discuss or receive any materials that materials that were not in the briefing except for the videos.
Those were project videos, I take it? Just project videos. Okay.
The board could vote, and the parties would have 10 days to respond.
Okay, thank you. I am going to make a motion to grant the appeal, which was reduced down to the 47% claim for refund based on all of the data provided, and that I thought it met the criteria for the credit.
I'll second.
There's a motion and a second. Is there any discussion?
I have a comment.
Madam
Yes.
Chair, may I interrupt? I don't believe it's necessary for you to put into your motion the 47%.
Because that's what the case was.
Appellants have already conceded that
Okay.
the 47% is the revised refund amount. So on appeal, that is the revised refund claim. So it's not necessary for you to include that in your motion.
Okay, strike that motion, and do you want to remove your second?
Yeah.
Okay, then the new motion is I would like to grant the appeals in B2A, B2B, B2C, B2D, and B2E.
Second.
Madam Chair,
Yes.
although the appellant did make some concessions, I'm afraid to give the percentage, but they conceded 52.6%, and have asserted that 47.4% of the remaining contracts with the expenses is qualified research because they were fixed contracts. However, I note that in the record, we only have contracts for 12, meaning that it's not in the record the 1,240 contracts that comprise of this research credit. I also note that I do believe that some research did take place, but the evidence doesn't support or explain what the exact business component was. I mean, they talked about certain projects, but they really did not provide evidence that would do the shrink back that's required under law.
Thank you.
Madam Chair, if I may. You know, this is one of those situations where the administrative process is really creating a disadvantage for both the appellant and the respondent. In this particular case, additional evidence was presented on the record, and there was a discussion about that evidence as to whether or not it could be presented and considered. And the department was provided an opportunity to respond, to provide additional briefings. And so, just based on the evidence presented thus far, I do believe that there is an element of research and development and that there is a business component. The inherent challenge is how do you, I don't necessarily believe it was 47%, and without both parties being able to provide additional briefing and additional evidence, it just puts a burden on this body to try to come up with what that percentage is. So, anyway, it's just my concerns.
If I could just comment, I do believe that at least in my file, it was the appellant and the department that worked together. The appellant did submit how they calculated the 47%. So they were trying to negotiate, as I understood the file to read.
Well, she explained how she got to the 47%, and she said she looked at, I believe, as the contract was being paid, but we didn't have those records, the source records. And even her spreadsheet, her H2, she left out some contracts that she later says should be there, so it raised in question in my mind how accurate her calculation is, but.
Well, I think because there were, I had in my file 791 contracts, and we were only actually looking at 12 individual projects, that was the problem. It was a sample. And of the sample, I found some justification on all that I had contracts for, but we didn't see the whole 791. I think that was the deal. Okay, Member Ma?
Oh, yeah. We also felt there was some element of research and development, given the nature of their business and the type of solutions that they come up with. They're not cookie cutter, but they're really hired to figure out the best solution economically, environmentally, socially for their projects. I want to thank Ms. Harkey for her extensive research looking into this. I felt that Ms. Harkey's evaluation was very fair and thorough, and I am going to be voting with Ms. Harkey based on the amount of work that she's done to kind of give me more confidence in the type of work that they do and the credits that they would be eligible for under the code.
Thank you, Member Ma. So I think we have a motion, a second. It looks like we need to call the roll.
Chairwoman Harkey.
Aye.
Mr. Renner.
Aye.
Mr. Horton.
I abstain.
Ms. Ma.
Aye.
Ms. Dowers.
No.
Motion carries.
Thank you. Okay, the next one. The next one is Moffett.
Yes, B3, Jeffrey Moffett. and
B3,
Storetta
Jeffrey
Moffett.
Moffett and Storetta Moffett. I believe you recused yourself.
Yeah, I did not participate.
He did not participate. I will entertain a motion. I'll make a motion to deny the appeal.
You have a question about what?
Oh, okay.
I don't care.
Why don't you just go to the back?
Well, we can just ask the attorney.
I'm sorry, I didn't catch
The
what you
question
said.
is, since I did not participate in the, is it sufficient for me just to sit here quietly, or do I need to leave?
You
the room?
recused yourself from the discussion and the vote?
Yes.
Yeah, if you just don't participate, please.
Okay, thank you.
Second.
Okay, I have a motion and a second to deny the appeal. Is there any objection? Okay, please show that there was no objection. The motion passed to deny the appeal, and that Member Runner recused himself and was not present or did not discuss the motion. Okay. Well, I used to sit on the city council. It's coming back. Okay. The next one is item B5A and B5B, Schatz, Richard Schatz and Andrea Schatz.
Waived appearance.
That was a waived appearance. Is there a motion?
This is the shots. Oh, he got lucky. Yeah, my motion is to sustain the franchise tax bill on this matter.
Second.
Is there any objection?
But he didn't appear.
Okay. Such will be the order. The motion is to sustain the franchise tax board. I guess that's what deny the appeal means too, right? Okay. Okay. The next one is item B9, Dimitri Berius and Larissa, no, Benus, B-E-I-N-U-S.
Chair, I have a B8, but I'm not really following, so I was just...
B8 was withdrawn or wasn't of record. That was Lawanga.
Postponed.
All right.
Yes,
thank you, Madam Chair.
postponed. So B9, Dimitri
Move
Berius.
to sustain the FTB.
Second.
There's a motion and a second to sustain the FTB. Any objection? No? Okay, such will be the order. The next one is item B10, Keith William Brown.
Move to sustain the FTB.
Second.
Motion and second. Any objection? No? Okay, such will be the order. Mary Dowry was worked out with the FTB. They withdrew that. So then there's Victoria Joy LeBeau. Was the elderly couple, item B14.
I need to amend my statement on that one.
Okay, member Runner needs to amend his statement.
To provide certainty for this taxpayer, I will disclose that the taxpayer did contact my office last month and speak to one of my staff regarding the issues of the case. There was no record-keeping requirement at that time, but our recollection is that the staff member did not discuss or receive any materials not in the briefing.
So you don't recall that there were any additional facts or analysis or argument?
I'm sorry, what?
There were no additional facts or analysis or
No
argument?
record-keeping at that time, but our recollection is the staff person did not discuss or receive any materials.
Oh, did not
Not in the
receive-
briefing.
Okay, so there was none?
No new
communication.
information.
Okay, I'm sorry, it's hard to hear.
Okay. This was a very tough case for me. I wasn't predisposed to help at all, but we did ask about the interest and the penalties on the 57,940 for the year that's, I would kind of even be predisposed to grant the whole appeal, but 1995 was the year that I think is really in question, and the lien on the property and all of that. So I'd like to make a motion to grant relief for 1995 with regard to the amount of the deficiency, or actually, no, excuse me, draw that. I would like to grant relief for the deficiency for all years, because I have looked through the file and read through the case, and the previous case that was brought up, I reviewed that again. And it appears that there is a strong case to grant relief deficiency for the all years, not the tax liability, but the deficiency. And I would like to ensure that the lien on the property and the residence has been appropriately removed.
I just need some information what that means, the deficiency.
The deficient,
The amounts are what we're dealing with.
let me see, grant relief for deficiency. Deficiency was what they were billed after the time. They sent in a tax payment in 1 year, and if you didn't pay it, that's a non-payment. But if they went back and re-audited years later, a couple years, many years later actually, and found that there was a deficiency or something wrong with the way that it was reported to begin with, and I believe in this case it was an IRS or something that happened, I can get it out. But then that would be something that that Victoria Joy LeBeau would not have signed. She didn't sign that item on the tax return. She signed the tax return as presented, and later on the department disallowed, I think, exemptions is what happened. And so there was a deficiency assessment on all of the tax years. And rather than, I do believe she was responsible for the tax that she signed for and that she thought was legitimate, but the deficiency in particular for 1995 that caused a big problem, 57,940 plus interest and penalties, is, that's a huge amount. I don't think the law that I've read, that I'm reading in this case,
Madam Chair?
yes.
Or I wait till you have a second, but I do want to speak.
Okay.
Sorry, what?
Yeah, and in this case that was Taxpayer Exhibit B14, I actually didn't have time to, the Wilson case that was being argued, and it's in the file, but I just got a hold of the whole case, and I read through it, and I found out that, I think she could qualify for the equitable relief, but I think we don't have to make that case because there was actually a deficiency. And so anyway, that's kind of where I'm going.
Wait, somebody monetize that deficiency? I'm trying
What were whatever were the deficiencies for the 3 years in question? I don't know that we can go back and get those monetized, but maybe we can. Because I think they should pay the tax, but just not the adjustments that came years later that she clearly did not sign the returns for.
Maybe I can help here.
Okay, good, please do.
Okay, so we're looking at 94, 95, and 97. 95 is the deficiency year, being that after they filed the return, which was late, the Franchise Tax Board received information from the federal government adjusting the income and disallowing expenses and issued an assessment. That's the deficiency year. The other 2 years are self-assessed, no pay returns.
Okay.
They are not deficiency. With respect to the deficiency for 95, the assessment,
I had 57,940.
yeah, the additional tax from the assessment was $48,284, and the interest, the penalty is $9,656.80, and that way where you get your $58,000. That is for the 95 year. With respect to the comments that we made yesterday that regarding the lien, I know I asked appeals to do some research on whether or not the lien was issued in error, and I would like to see if appeals can address that now.
Certainly. Okay, so we start in Article 3, deficiency assessments. So under 19033, R&T Code Section 19033, if FTB determines that the tax disclosed on the return is in error, is less than the tax disclosed by its examination, it shall mail a notice to the taxpayer of the deficiency proposed to be assessed. So that's their authority to issue the NPA. Under 19041, if within 60 days after the mailing of the NPA, the taxpayer may file a protest. And under 19042, if no protest is filed, the amount of the proposed deficiency assessment becomes final. Then jump to Article 2, lien of tax. Under R&T Code Section 19221, it says if any taxpayer or person fails to pay any liability imposed under Part 10, which is what we're under, such that at the time it becomes due and payable, then that amount, which is, the tax, the penalty, the additions to tax, together with any cost, shall thereupon be a perfected and enforceable state tax lien. And then you jump down to subsection B, and it says for purposes of this section, amounts that are due and payable are, and in this case, the date the assessment is final. So,
okay, we're dealing with the innocent spouse release, or innocent spouse relief that was mentioned by the department that is an IRC code, Internal Revenue
Right, but you had said that I asked the department to explain the lien procedures, because part of the issue here is that the appellants argue that the lien was issued in error.
Yeah, well, I think that's because when we were listening to the hearing, the lady with the dark hair.
FTB commented that they, with respect to the, FTB were responding to whether their request for innocent spouse relief was timely or not, because I had asked the question, was it timely, because the hearing summary indicated that with respect to traditional relief and separate allocation for the 1995 year, it was not timely because the request for release was requested in 2015, and the first collection notice was in 2003, so it exceeded the 2-year statute of limitation. FTB clarified that although they too have a 2-year statute of limitation for requesting relief, the taxpayer's request for relief was timely because the collection notice did not inform the taxpayers about innocent spouse relief. And that was the whole point of that exchange. It wasn't to say that FTB, in their opinion, had done something improper with respect to filing the lien or, in their opinion, denying the request for relief.
But if they hadn't offered it, then the timing was still on when she requested it.
Yes,
So
and
in essence,
FTB said that she had a timely request for relief.
So so then the lien, had they followed the law, probably wouldn't have been there.
No, the lien would have still been there, Madam Chair, because FTB issued their collection notice December 3rd, 2003, and January 16th, 2004, and those collection notices are in FTB's Exhibit L. And in those notices, it's for the 97, 95, and 94 year, and those notices explain to the taxpayers, both of them, that if they don't pay the tax within 30 days, they may file a lien.
Okay, but
And then since they did not pay the tax after January 16th, 2004, FTB did file a lien on March 30th, 2004.
But they
And the
filed
taxpayer did
the
not-
lien on her property
Because she
without...
was liable for the tax, they filed a joint tax return.
I
So
know.
until we decide that she is granted innocent spouse relief, it's still a joint and several liability. So at that time, FTB was in the right to file a lien against the property.
Okay, well, I'm sure if I had an FTB attorney here that understood it, I could argue it with you. You're making a very remarkable case. However, in this case that was argued, this is on equitable relief. I am not thinking we should have equitable relief because I think she's entitled to relief. And one of the issues is that she, it came after the fact, and in this case, let me just read the Wilson case here. Okay, first it was denied in 2004 because without substantiation, it appeared that half of the business income on the tax returns was attributable to the wife, and her failure to disclose information about the income of other household members and her awareness of past taxes owed at the time she signed the returns, and that she was still living with her husband. So that was denied. Then the law changed again. She petitioned the tax court for review of administrative denial of her claim for equitable innocent spouse release. At this time, later she obtained a divorce, which had become final. And so the tax court reopened the record, held the second trial where Wilson again testified. The government took the new evidence, and they determined that she was eligible for equitable relief. Number one, the court said she was now divorced. That was the point, even though she wasn't at the time she signed the returns. Number two, she had no knowledge of the tax underpayment, which I don't believe the spouse had any knowledge of the tax underpayment. I think that she signed the original return, and I'm always, I'm always skeptical when people just sign blank returns, but I know people do that or sign at will. The tax court also concluded that Wilson would suffer significant economic hardship. I think that's apparent in this case. And the tax court also concluded that the tax liability was solely attributed to the husband. So they issued a final equitable judgment in her case. And this is United States Court of Appeals for the Ninth Circuit. Karen Marie Wilson, petitioner and Commissioner of Internal Revenue, was respondent appellate. And that was filed January 15th, 2013. So this is kind of a fairly recent case on equitable spouse relief. And I would submit that I'm primarily arguing, from my perspective, for 1995. I think that is the big year when everything came back, and she had never worked. It was a deficiency. They are now divorced, even though it's retrospective. That's what happened exactly in this case. And so I would argue that at least for 1995, that we allow her to have equitable spouse relief. And so that would be my motion. I'd like to grant it all, but I don't think I can get there, but I'm hoping for 1995 I will get the votes to do so. Do I hear any second? No? Okay. Next.
Move for the FTB.
Second.
Object. Would you call the roll, Ms. Richmond?
Chairwoman Harkey,
No.
Mr. Renner,
Aye.
Mr. Horton,
Aye.
Ms. Ma,
Aye.
Ms. Dowers.
Aye.
Motion carries.
Okay, I think we are finished. Is that right? Are we all through?
That is correct. We are done with this meeting.
Okay, great. Thank you, members. It was rough, but it was good. It was a good one. And I have memos that I wish to share with council. I'm just going to read them really quickly. Yeah, these cases, I don't think we heard Calabito, did we? No. Okay. So that's the same thing I just said. Okay. Bachelor. Okay. 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 I said that. These are fine, but I will just give you these in writing. They're the same announcement I had, only shorter version. Okay? No new information. All right, members, I think that's it. I think this adjourns the Board of Equalization meeting until we meet again in August. And that will be in Sacramento, nice and warm. So thank you very much, everyone, and thanks to all the staff and everybody who had cases.
Thank you.
Thank you.
Thank you.